right, we're moving on here. I'm capturing a thingy.
So a lot of these today are about motions in limine.
Mm-hmm.
So it's about all the stuff they're going to argue about at trial or not argue about at trial. So that's what a lot of this is going to be about. And then I was going to say your chat's going to feel seen and heard because there's a whole discussion about autism.
Do they try to use
Just like
autism
my
as a
chat
defense?
Well, no, they're worried about like because he's getting the death penalty, and they're arguing stuff ahead of time. But they're like, Your Honor, well, if we have to argue death penalty, you know, he's got autism, and we want to make sure the prosecutor's not going to go kill him because he's a tard. And the prosecutor's like, I was never going to do that.
I was never going to kill him because he's a tard, but we can't rule it out.
Yes. Yeah, pretty much. But no, I just when I heard that, I was listening to Emily Baker because she was narrating it while I was driving around, and I'm like, wow, my chat feels heard.
I'm sure they'll be happy to know that they won't get executed for the autisms.
Yes, no, I'm sure most of the internet will know that in Idaho, they don't execute you because you're a tard.
Is that, I guess, like, are they deciding to plead, like, well, he did it, but he's retarded, so you can't kill him? Is that what they're going with, or are they actually trying to defend?
Well, they're going to defend him, but the problem is that, like, the case, the judge is not going to stop the, because when you get the death penalty, you have two parts. You have the trial and then the guilt phase.
Mm-hmm.
So, like, the penalty phase. And they're just, like, planning ahead because the judge said, I'm not going to make these jurors wait in the middle of deciding the trial for a couple days for you guys to argue about crap. So they were just arguing it as preemptively as they could. So they were just kind of getting ahead of themselves, but the judge would have wanted them to do that ahead of time. So it was a proper thing to argue, but it doesn't matter right this second. It matters if he gets convicted. So.
Well, all right. I think I have managed to finagle your camera in here. And like I was saying a minute ago, I was very unaware how long these things are. So
yeah. So if you go 1.25 speed, that helps a lot, because you're going to realize how slow people talk. And you want to fucking kill yourself. You can even cheat to go to 1.3 speed, and it'll just sound like you're listening to normal people talk. That's how I do trials at all. I go to like
insane.
1.3. Oh, you'll try it. Trust me. You'll be like, wow, these people sound normal. And then we could skip all the breaks. And also, if we just run out of time, we run out of time. But yeah, you will catch up pretty quick doing it.
And I mean, we have plenty of time, right? If we need to do like multiple shorter streams on this, like he doesn't have the actual trial until August, so.
No, and there's also day 2 tomorrow.
Oh my god, I didn't know it was split up into 2 days either. So yeah, we'll probably need a second day at some point, and we can probably do that on a weekend day, so we both have more time.
Yeah, whenever you have time, let me know what your schedule looks like, because I'm usually around doing stuff throughout the day, so on the weekends especially.
Well, how closely have you been following what's going on with his trial? Like, what are your basic thoughts on the overview? Because I know both of us have been kind of following it. My memory's not the best, but
I don't know if they could prove he did it. There's just so much of it that doesn't add up, like that the kids who lived in the house, they called friends and other people came over to the house after the murders happened. Like, the murders didn't get reported till later in the day, and there's unknown people who have traipsed all over the house. There's some issues, though. I mean, like, one of the ones is, how did Bryan Kohberger's DNA get there? And now I get it, it's a touch DNA, which means it transferred around. But how did that person transfer it from Bryan Kohberger? Like, there's a bunch of this where there's a bunch that it's going to be a problem for him.
I agree. And I think, like, one of the biggest things that was a red flag for me at the beginning was how the one chick who claimed that she saw him changed her story multiple times, where she was like, I saw, the girl laying on the floor and I thought she might have passed out drunk. I looked later and, there was nobody in the hallway, or like I looked and there was somebody covered in blood, or like I looked and I saw him and he spoke to me. And it's like, well, kind of, which one of these things happened? And then also,
it sounds like Ralph Wiggum.
Yeah.
It's like, they were making babies and one of the babies looked at me. It's like,
well, what's actually going on here, lady? And then, the speed with which he was able to kill all 4 adults in the house, as this being his first time killing people.
Yes, he put in a lot. His major league debut, he put in some work.
He
did it very well.
I was just because it's
And
like
he was able to. Yeah, he didn't leave any trace evidence anywhere else. His car did not show signs of being cleaned. They found no blood. They found nothing. And from watching forensic files, you always leave something.
And like
And he did it.
I'm not a Moida expert as it is, but the fact that they had ordered DoorDash, picked up the DoorDash like 5 or 10 minutes before he started killing them, and then from start to finish that only took like 18 minutes or something. I can't remember the exact time. But it's like there's no way that they were all asleep if they had just ordered food. So some of them had to been awake. So how did none of them like fight back? How did he kill all 4 of these people so quickly?
I will say with that, I agree, but what I will say is, from having seen crime and violent crime, like, people are fucking weird when things go down. So I could easily, like, I had a case where my guy was like one of the idiots in the car, and these 2 dudes, robbed a meth dealer. And when they walked in there, they realized there was no meth. Dude pulls out his fucking gun and he looks at the lady, and she's getting all mouthy, and he just like, bop! And then he looks at the guy standing right there, and he plugged the lady right in the chest.
Oh, wow.
And she goes down, and she dies. And he looks at the other dude, and he just goes like this, and just right to his knee, and they shoot him in the knee and leave. So it's really weird. Like, people do weird, like, instead of you're thinking, oh, well, once you kill one, you might as well get the second. Nope. They wounded that guy and ran off. And, my guy got charged with murder as an accomplice, and like, the weirdest shit happens when you're playing for real. I mean, think about if you got thrown in the Super Bowl. I mean, it's different when you're doing it and it's your first time.
Oh yeah, no, I can absolutely agree with that. It's just, I don't know, if I'm thinking like 2 of them were in the room together, if a guy comes in and starts stabbing the person next to me, I feel like I might have some sort of a reaction, right? Like, I get that you get stunned and there's like the adrenaline, but I feel like you might move. You might not just lay there and let him stab you too.
No, I agree. There's so much of it that doesn't add up, and that's the problem.
Yeah. So. Well, how exactly do you want to start with this thing? Because this is, your area of content.
Yeah,
so.
Sure. I mean, we could just talk about, like, the basic idea that he's, facing the 4 murders, and it's just the idea of what's the, where we're at, and like the motions in limine, and what exactly those are. And I can just explain, like, these are attempts by one side or another to limit discussion or limit the presentation of evidence about certain topics, and these will tell you a lot about what's going to get presented. Because if you know what, like, one side wants to do, you'll know, like, how they're going to argue it or what they're worried about from the other side.
Yeah, of course.
So that's all I was just thinking.
Yeah. I just, I guess...
Yeah.
I don't know how much of, like, the beginning is just, like, nonsense that we can, like, skip. I guess it says court will begin soon at 1 hour for some reason.
Well, you could skip ahead, yeah. Skip through it till you find the parts that are going. I don't know which spot you're looking at right now. Oh, wow. So all the tariffs did go into effect. Shit.
Yeah, it looks like he put a pause on tariffs for other countries for 90 days, but then increased on China by like 100 and something.
I don't know how you go over 100% on tariffs. That's just weird.
There were some people who were like, we should do 400% tariffs on China, and I'm just like, fuck it, give China all the tariffs at this point. If they're gonna try and play ball, we're gonna throw the largest ball at them.
Yeah, but I don't know. I think the game is we can stay retarded longer than they can stay solvent, which it's an interesting game. We're playing GameStop with the world.
We're playing an interesting game of hot potato, as it were. Yes. So I don't know if you wanted me to just like stream my screen to you, or if you like wanted to use the video link I sent you. I don't know what would be easier.
Oh, as far as where to jump in, let me see. What link did you just send me? You just sent me a link. Let me see.
Yeah, there's a YouTube link to like the 6-hour VOD.
Yeah, I see that. Oh, you just want me to watch along with you?
Yeah, like I said, I don't know if you want me to
okay.
like stream mine to you or if you wanted to have yours
Yeah, if
separate
you
from
just
mine.
stream it to me, that's
Okay.
fine. That's fine. That'll work easier.
Yeah.
Or if it's easier for me to do it, that whatever way it works for you. You stream to a real audience. I just stream to like a handful of
Your
people.
audience is real too. Don't be rude.
Well, not in size.
Well, all right. It should be live to you now through Discord, I think.
Yes.
All right.
Yeah.
Perfect.
So see, you can tell your chat. Look, you skipped ahead like an hour in time.
Yeah, because like the beginning just has some like weird. I don't know what this is. I
Yeah.
guess it's just silent question mark.
Screensaver.
Yeah.
Yeah, no, it's just a screensaver now, and then let me see here.
It's like
Let me see.
118 something. Yeah, like here.
Yeah.
Also,
let me just see here.
I'm noticing that the people at the courthouse have the activate Windows timestamp down at the bottom.
Yes.
I feel like that's kind of interesting that they don't have an active copy of Windows on their little government computer.
Oh, that's a. Well, remember, this is out in Idaho, so this is not like your, fancy Boston courtrooms.
I mean, I guess that's true. I'm sure that's the judge up at the top left. He kind of looks ancient.
Yeah.
And then you have Santa Claus down here at like one of the tables. I don't know if that's defense or prosecution.
Yeah, that's prosecutor.
Santa, no. Have you?
So you have. Hold on here. There's an hour and a half of breaks in here too.
Yeah.
After this point. So
Yeah. So it's a little shorter than it looks like.
Yes, a lot shorter.
Have you heard the joke that the activate Windows timestamp on the computer is the white man's version of the ceiling bird chirp?
Yes, I have. It's very true. It's
That
very
lives
true.
in my head rent free since I heard it.
Well, I hear. Oh God, you know how many times I've gotten body cams of like drug raids, and you just hear the bird chirping.
Oh,
and I'm like,
no.
Oh my God.
In all of those things of people talking about that recent murder where like that kid stabbed another kid in the heart at a high school thing, yeah. A lot of the people coming out in support of the murderer, they have the ceiling bird chirp in their videos. It's very interesting.
Oh yeah, no. You know how many times I get a phone call. It's like, hey, the court here in Cleveland Heights appointed you to represent me on a case, and I just hear a chirp in the background, and I'm like, okay, well, I guess that's that. No, I'm sure there's also the idea that this is. I've seen the meme of the chirp drives black people crazy. That's what does. It's like their Manchurian Candidate signal.
Like they can't hear it.
To him.
They can't hear it in reality, but they hear it in their subconscious, and it kind of reprograms them. That makes sense.
Yes, that's why he killed him. He heard the chirp, and it's my time.
It's time I have to act.
Yes.
I guess that brings up a question.
Yeah.
Obviously,
What's
when you
gonna
win a
happen to him?
case, like, you're happy because you won the case. But, like, what if you win the case, but you, like, don't think you should have because you're like, my client's probably not the most innocent, but I did my job.
Oh, I'm still happy. I mean, those are even bigger. Like, those. I tell people I'm the linebacker. My job is to sack the quarterback. If I get the quarterback, it's not my fault. The linemen were in the Special Olympics. It's like you go get mad at the prosecutor for not defending,
not doing a
the
good enough
case
job.
well enough. Yeah, no, that's how I look at it. It's like Omar said. It's all in the game,
Oh yeah,
and that's how I treat it.
I just figure I would
All
have
in the
some degree of like, man, if this guy gets out and kills another person, I'm gonna feel kind of bad because like I think he did it.
I mean, I've had people get out, and I know they're going to go out and go buck wild in the streets, and I'm like, yeah, you know what? Oh, well, it's not my problem.
You have to have a certain level of compartmentalization, I feel like, to do a lawyer's job.
I mean, you do a little bit, but it's more of just, don't get mad at me. I'm not the one who screwed this up.
Yeah, true and real.
That's how I look at it. I mean, really, it's you're worried about what he's going to do to people. I'm like, the government goes out and murders people all the time too. So it's like,
Also,
are
fair.
we really that much worse off?
I guess it depends on where you live.
Yeah.
That's why everything's expensive in the Northeast.
Oh yeah, yeah. Well, it's all expensive in the Northeast, and then your cops use Dixie cups for crime scenes.
Yeah. Yeah. It's not the greatest, and like, I mean, I always knew that there was a degree of corruption, but again, talking about the Karen Reed thing, it seems pretty ridiculous. Like, I know you're like, yeah. I'm not gonna say she's innocent, but like, it feels like they don't have enough evidence to prove that she did it, and there's more evidence that she probably didn't.
Well, and even the evidence that she did do it, it's so questionable because the police are so corrupt. You can't trust any of it. Like, that's the scary part. Like, she very well could have done this, but the police have just fuckered it up so badly. I can't trust anything that's happened.
And I think, like, my biggest question with that one is just, like, well, why did they kill the guy? Like, even if it was an accident, wouldn't it have been much easier to, like, go through the accidental process? I don't know.
Well, like, that's the thing, though. I mean, what's the likely outcome here is kind of what I've looked at. And I think, honestly, the biggest thing that probably happened is, I mean, like, got drunk, fell down and cracked his head, and they're like, oh, shit, and they panic. Like,
maybe.
That easily could have been the outcome. Or, you know, Karen's like, fuck you, John! And he's like, fuck you, bitch! And slips and cracks his head on the ground and dies.
I mean, apparently she wasn't even there. And, like, the 911 recording, like, she just shows up out of nowhere. The two people in the car, I can't remember who they are, but they're, like, calm as fuck. And she's just, like, screaming for help, and they're just, like, ignoring her. And I'm like, this is weird. Like, anyway, you like, people deal with crisis differently, but this is weird.
Oh, yeah, no, the way this entire thing is shaken out is so weird and so concerning. Like, I am not at all thrilled with... None of the witnesses are good. And that's the thing. You know, you don't, like, you have to trust these witnesses. Like, you have to trust the McCabe's. You have to trust that lady with her, like, I'm gonna bite your dick off look on camera.
Yeah.
You know, you have to trust all of them. You have to trust the Fed who broke his phone in half and threw it away at different parts of a military base. Like, you have to trust these people and say, you know what? They're legit honest brokers. You know, like, none of them are, so, like, that's the problem with the case. That's the problem here. That is the 100% problem.
Very much so. Now, if only Mr. Turtle Boy could stop showing up in courtrooms and getting himself arrested.
Well, yeah, and that's the funny thing is with the whole Karen Reed thing, I've had to tell my chat about this for the longest time. I was like, I am not touching Karen Reed because Turtle Boy. I knew Turtle Boy from interacting with a sovereign citizen.
Oh.
And his name is Chili DeCastro. I don't know if you've ever heard of him.
I have not, but that is a name of a sovereign citizen that I would expect.
Yeah, well, he's hilarious because he's he was one of the original Power Rangers, but he was such a lunatic they wrote him off the show.
Oh shit, that's cool. So
he had his chance at Hollywood fame. Well, anyway, he was fighting with the masshole lady. I don't know if you know the Turtle Boy's nemesis, Kate. She was mocking him and deriding him. Well, he tried to go confront her, and she basically, you know, made him look like a bitch in the middle of, I think it was in downtown Canton for the Memorial Day parade a couple years ago.
Oh, wow.
And eventually, because Turtle Boy and this Kate lady don't get along, like, Chili starts working with Turtle Boy, and I'm like, oh, I don't know who Turtle Boy is, but I'm like, fuck him. He's hanging out with a sovereign citizen, but, like, I didn't cover Kieran Reed for the longest time because I thought Turtle Boy was a turd.
Aw.
And, yeah, I mean, like, in hindsight, I was like, well, he was, but he was right about Karen Reed. So.
I just randomly happened to find Turtle Boy. I don't even remember what exactly led me to him.
You say that. You probably live down the street from him. It's okay to say it.
Well, I live in Georgia right now. I'm not near Massachusetts at the moment.
Oh.
You know, I found him randomly from looking up, like, stuff that's going on.
You're hanging out with Young Thug and the rap person.
Yeah, I'm in the Atlanta sound booth, as it were. But, yeah, I was looking up something, and I can't remember what it was. And there was, like, eventually I found a story about, like, a local city councilor lady or something, and I can't remember her name, but she had, like, a video that leaked of her having anal sex with some guy in front of her disabled son in a wheelchair in the same room. And, like, the guy was taking video of it while she was getting dressed, and he was just like, yeah, she just lets you stick it in the poopa. I was like, who talks like this? And
that's...
Turtle Boy called her, and she didn't answer, and he left, like, a long, disparaging voicemail that culminated in Tuesday night's anal night, which has been an alert on my channel since I found that now. I was like, wow. This man seems crazy. I kind of like it.
Well, that sounds on par for Atlanta politicians, honestly.
That was a Boston politician.
It was a Boston politician?
Yeah, because he was the one covering it, and I was just like, I was interested.
Oh. Was it like, it wasn't Mayor Menino?
No. It wasn't a mayor. I want to say it was a city councilor. It was just like, it was so long ago.
No, I've never heard this. I'm gonna have to, like, I hate to say this, but I'm gonna have to Google it. But I'm gonna have to Google this now.
It was a wild story.
Oh no, I don't know if I want to see it, but I guess I'm gonna have to.
I probably still have the link to it somewhere because I don't close my tabs. I have thousands of tabs open, man.
I know. I know the memes about your tabs.
All right, I am going to hit play on this and see where we go. If you want me to pause at any point, just, like, say something.
Okay. Are we live right now or no?
No, we've been live the whole time.
Okay.
You're brandishing a gun at my chat.
Oh. Well, I don't want to. That's why I was like, I didn't know if you were gonna get, like, yanked off YouTube for that, because that's like a no-no.
Well, you know, I mean, I'm on YouTube and Twitch. They can't shut me down in both places, right?
I don't know. They have pull. You know, parenthesis.
In parenthesis. You know,
they do have pulls.
It's okay. It's a prop gun, chat. Legally speaking.
Yes.
Five.
Bella's like, yeah, we heard what you said about us. Well, what about everybody? All right, so
it's very low. I gotta find my volume control. Yeah.
Miss Barlow, Mr. Horowitz, welcome to the fray. I think I saw you back there, and Mr. Nye's here as well. I apologize for missing you there, Mr. Nye.
I'm gonna turn your volume down a little bit because I cranked my PC volume to 100.
Today we have a number of
yeah, I'm gonna send you a link.
Motions to get through. What we don't get through today, we will take up tomorrow. You should have received by email a listing of score sheet of the motions and.
I see what you mean by having it on 1.25. They just sound like normal people because they talk so slow.
Separated
into groups,
they move. Their hand movements are very awkward.
Yeah,
but otherwise, when they're talking, it makes a lot of sense.
Yeah.
Within a group, they're related at the same time.
Here, I'm going to send you a thing so you can
that,
boost the sound here. This is what I use.
Okay.
Defendants' motions in limine regarding inflammatory evidence, use of the term murder, and use of the term
enhancer for YouTube. Hold on, let me pause.
Yeah.
Enhancer.
This is what I use.
So is this just like a?
It's a plugin.
It's a plug. So I just like.
Yeah.
Search for it. Hold on, let me close my browser for a second.
Oh.
I'm in Firefox.
Oh, I don't know if it'll work on that, but you can try it. And
it is just enhancer for YouTube. I gotta remember how to find plugins first. Here we go. Enhancer for YouTube. Search. Oh, it is here.
There you go.
All right. Add Firefox. Add. This should be really helpful because we find tons of videos that just have like super low volume and I have to crank my PC and then I forget that it's cranked and I blow everyone's eardrums out.
At the top of the screen, you see that thing looks like a lightning bolt on the bottom of the little white bar there? Like you see the green, big green box?
Yeah.
Yeah. If you click in here, you'll see that's the volume thing.
Oh, okay.
So once you open up that video again, it'll have the volume enhanced.
Okay. So I just gotta refresh, and it should save my space.
I think so.
Yep,
there you go. In the middle.
Oh.
You see it? So
lightning bolt.
That one.
Boost volume.
There you go. It should be louder.
All right, perfect. Let's see.
And so with that,
it is louder. Beautiful. Thank you.
Defendants.
Do you have it at 1.25 right
Motions
now?
in
It
limine
is on
regarding
1.25.
inflammatory evidence,
Okay.
use of the term
He's
murder,
just
and
slow.
use of the term psychopath or sociopath.
Can you be a psychopathic sociopath?
Thank you,
No,
Your
and
Honor.
this one actually makes
I'm
sense though because he
Guessing
hasn't been
from the
diagnosed
court's comments,
as
the
being
court wants me to
a
address all
psychopath.
three.
Yeah. Yeah.
So, yeah, they don't want it in there, and that's a fair argument to make. Like, you can't talk about it because he hasn't been diagnosed as one.
That does make sense. I mean, can he get diagnosed before trial, or is that something that like they wouldn't
No,
allow?
no, that's something you wouldn't want anyway.
Yeah.
Because that's an issue there. And so you guys are saying who's Bryan Kohberger? He's accused of slicing and dicing up a house full of college co-eds in Moscow, Idaho. He knifed 4 people to death apparently, allegedly, and left other people in the house alive, and then escaped back across the Washington state line, and didn't get caught right away.
Yeah, they had a little bit of a manhunt for him. It was kind of interesting to watch.
Yes.
It was in December 2022. So we're pretty far out from when this happened, or 23, something like that.
Yes. Yes. Yep.
Yeah, this is the
Yep,
one
so-
where I thought it sounded like that the person that lived, or one of the people that lived, might have been kind of in on it, potentially, allegedly, maybe. I'm interested to see how they
There's
act in the
some
courtroom.
sussiness with that.
It
There's
definitely
some
is.
sussiness with that.
Of those, I'll do that then. Your Honor, the motions are brought to the court based on Mr. Kohberger's constitutional rights and the rules of evidence and relevant case law. With regard to the inflammatory evidence, that is requesting that the court issue an order preventing the state from trying its case with an emotional appeal or an excessive use of emotional phrasing or an
wonder-
excessive use of repetitive photographs. Certainly, we understand that there will be photographs that we may not like that come in,
Is that too
testimony
fast?
that we may not like that will come in. But what we're talking about is an
1.3
excessive
is
use of
probably
emotional.
like the limit before it gets too fast.
Well, this is 1.5,
1.
but it doesn't let
Yeah,
me do
1.5 gets
1.3.
fast. That does. If you go up to the top,
Oh, the custom.
you can slide it.
I've
yeah.
never done that before. Okay, so 1.3. We'll do 1.3.
Yeah, it's a little faster.
Yeah, yeah.
Appeal. That the examples that we've seen in relevant case law come from State versus Ellington. In that case, the prosecutor repeatedly used a phrase that was inflammatory about the defendant having run over the wife of a witness who was testifying. And
What?
that was found to be inflammatory because of the excessive use of that phrase. Additionally, in that case, there was an appeal to juror emotion when the state sought testimony from a witness about why he might have left his job. Those are examples of what we're talking about. The court has to do the rules of evidence balancing test, and to do that after the state has elicited inflammatory testimony is difficult to undo and puts Mr. Kohberger in a position where the jury's already been inflamed, and so we're seeking to prevent that.
Now, part of the issue is this was apparently a very, very bloody murder. I mean, anytime people get stabbed, generally, there's a lot. We leak pretty bad when
Yes.
you poke a hole in a person.
I'm pretty sure they
So
condemned
apparently
the
there's-
house.
Yeah, they basically stripped it out. So we're going to see, and this is something I know it hasn't been presented yet, but you're going to see, like, they probably cut out parts of the floor, or cut out parts of the drywall. So there's going to be big bloody chunks of the house coming into court.
Oh, wow.
But they're going to be, I mean, part of that's the shock value. You're showing people how brutal and gory it was. Now, the prosecution has to be careful because if you do too much, you can overdo it. But the defense is trying to do the right thing here. They're trying to limit it. It's just really hard ahead of time to limit it because ultimately they do have to prove, like, look, he did kill these people. How do we know? Because they're all dead. Here's what the house looked like. So
It's also like when you have a high profile case like this and you're trying to not taint a jury pool, how is that even possible? Like, how do you find people that don't know anything at all about this?
you'd be surprised. Oh, it's easy. It's easy.
Really?
The Karen Reed thing's a great example. You know how many people don't know? Like, we are. There are normies out there that are worried about taking the kids to soccer practice, worried about dinner, worried about every other thing out there in the world except this. So this is not a. It's not that hard. In the Karen Reed case, they found a bunch of people who didn't know anything about it. And you think, well, how do they not know? But
I feel like Karen Reed is much like less known than this case, though, because that's like.
Well, in Boston, it's well known. So,
in Boston, it's well known, but this was more like it was
national.
Like larger news stations.
But still, I mean, how many people? Most people people don't pay attention.
Oh, that's
They're
fair.
like, "What's this? Does it matter to me?" And if not, don't care.
Oh, that's a good point. That's fair. I don't know. I just always thought about that, and then when she brought it up, and I was like, "How? They've been talking about this for years now."
Yeah. And there are people.
Your Honor, I will move.
There are people that what?
And there are people who do live under rocks.
That is fair. I wonder if, like, when OJ's case was going on, there were people that were like, "Who's that? What did he do?"
Okay, that one was probably a little different, but overall, they're like, "Wait, he turned her head and he turned her into a Pez dispenser?"
Yeah, right. Like, what's going on with that?
That's not the OJ I know.
It's like there's this one case I bring up occasionally. I'm pretty sure it was in Florida where like a guy got so mad at the chick he was with, and she was so drunk that he managed to punch his entire hand up through her vagina, grab her intestines, and pull them out.
Oh my God, that's metal.
Yeah.
That's pretty cool.
I was like, I mean, I'm
Did
upset.
she die?
Yeah, she died.
Oh.
I was like, that's fucked up, and I feel bad for her, but also, how the fuck did he do that?
Well, nobody's going to fight him in prison. They're like, what did he do? And the guys on the cell block are going to be like, wait, what? No way.
He disemboweled a living
pull
woman?
Up the news article. Yeah, disemboweled her with his hands. Yeah. They'll be like, oh, shit.
I'm like, yeah, we're not getting Aztec in here. Let's leave this one alone.
Yeah.
And to our motion regarding the murder term. This motion is also based in Mr. Kohberger's constitutional rights to due process and to a fair trial. This is not a motion to ask the state not to use the term murder. That's going to come out when the court reads to the jury the charging document. That's going to come out in jury instructions. This motion is about the state, through its witnesses, labeling Mr. Kohberger. That invades the province of the jury. Mr. Kohberger sits here today. He's innocent, and it's up to the state to bring evidence and a jury to decide if that's different. The state, by using that kind of term as applied to Mr. Kohberger, gets in the way of what the jury needs to decide. Back when we were looking at a change of venue in this case, we worked with a social scientist named Dr. Amani El Aleli, and she talked a lot about how bias is made in people and how we think about things and how we remember things. And one of the things she talked about, and her report is in the court record, one of the things she talked about is the influence of people in a position of authority. And for the state to come in and label Mr. Kohberger in their position of authority or ask a witness, especially...
It's a very true thing. People tend to believe, the prosecutor because the prosecutor's a representative of the state. Like, that's seen as a little bit more prestigious position. A policeman coming out, people tend to listen to them a little bit more because they are policemen. Like, that is all very true.
Am I retarded because I always saw, like, the prosecution and the defense attorneys as on equal footing?
No, that's how it should be. No, the fact people do that is not a good thing, but most people are retarded, so...
I mean, I guess fair. I don't know how you see the prosecutor as, like, somehow more authoritative than the other lawyer. Like, yeah, they're in the employ of the state sometimes, but, like, I don't know, man.
That's because people are idiots.
This judge looks bored out of his mind, by the way. Like...
I'm sure. He's read through it. I mean, he's generally already made up his mind by the time he's had these hearings. So he's already read the pleadings. He's already read the motions. But they have to speak. They have a right to speak, and especially Bryan Kohberger's side. Like, they have to speak. Even if they know they're going to lose, they got to make their motions, and they have to preserve the record for appeal. So, like, he's just like, okay, look, get this over with, and then I'm going to give you my ruling.
And typically,
that's why it's happening.
Typically, I have the same view, right? Where, like, I've seen enough of the evidence, I've read enough stuff where I can feel generally pretty good about, like, they probably did it, or, like, he probably didn't. In this case, I have no idea which way this could go.
No, I mean, at the end of the day, he's probably going to get convicted. Just, it's the nature of the game.
Yeah, I mean, I agree with that.
Yeah, that's the problem. He's probably going to get convicted. Will he get... Will the Autismo defense save him from the electric chair? I don't know.
Like they would have to pull out some like crazy level smoking gun in order to be like, yeah, he wasn't here when this happened. Like just that one chick, even changing her story multiple times, I don't think would be enough, even if it's suspicious to the rest of us to like.
No, because it's still one of the biggest things is his DNA is at the scene of the crime, and there's like what's the answer for that?
Yeah,
that's going to be a critical thing. So,
witness in uniform to do so is very detrimental. It's inflammatory to Mr. Kohberger, and it would.
Outside of opening statements, perhaps, where the state might say, we intend to prove the defendant murdered the victims, perhaps in reference in voir dire, in this case, the defendant is accused of murder. I'm having a trouble understanding how this would come up during the evidence phase of things.
Your Honor, that's why I'm asking the court to issue an order to prevent it from coming up.
Sounds like you're asking me to issue an order that says the state shall not commit prosecutorial misconduct or the parties will follow the rules of evidence.
Your Honor, I would like an order that the parties will follow the rules of evidence.
I'm sure the state would like one too.
I'm not going to oppose that, Your Honor. We'll get to the state's motion.
I don't think I need an order because, as the name implies, they are rules, which means they will be followed.
Funny.
Your Honor, in an abundance of caution, we bring these motions, and that's based on review of case law and based on years of experience when things happen in trial. I found and I believe that it's relevant to bring these kinds of motions before the court now and have all of the parties aware of.
I think there's maybe a difference between bringing them to make sure that the issues are highlighted and the parties are vigilant versus perhaps entering sort of prescriptive orders that are so broad and vague in nature that they are essentially meaningless.
So is she just being kind of silly here, I guess? Because like I'm not used to like the inside court lingo.
So she wants some. She basically is trying to say, the prosecution needs to be put on notice. They can't use the word murder like that, but more importantly, that their witnesses can't use the word murder. And the prosecutors are responsible for their witnesses, especially the law enforcement types. It's one thing like just random, citizens that are witnesses, but like all the actual professional witnesses. Now, I agree with the judge, though. It makes sense. He's saying basically, you want me to tell them don't be assholes, and it's like, okay, well, he's like, I'm not going to do that because it's. Now, I don't blame the defense for making the argument. I would have probably done this too. I mean, this is a death penalty case, so you kind of, when it's a death penalty case, you kind of do everything.
Yeah.
Every motion that passes the straight face test, you file. And you make every argument that you can make. So I understand why they did it. But yeah, it's not going to go anywhere. And, unless he knew there was specifically an issue, that's what would happen there. I know, like, I'll use for example, like I had a case where they raided a house, they found some drugs in the house, and they charged my client with the drugs. Well, my client had been tangentially involved in the drug deals that led up to the raid, although it kind of, from what you could tell from the videos of the drug deals, he didn't know there were drug deals going on, but he looks like he's part of the crew. So I had to do a motion limine to keep all that stuff out, because if they showed him being involved in all these different drug deals, well, the jury's going to say, wow, this guy's a piece of shit.
Yeah.
So there are times where you are trying to hide and shape things, but stuff like this, you generally assume the prosecutor's not going to do it. And then if he's, that's his way of saying he's not going to tolerate the prosecutor doing misconduct. So I think in a way that's also good. I think it's his way of telling the prosecutor, I'm not going to order this, but you're on notice and you know better.
Yeah, that's why he was just like, well, these are already rules, so I'm not going to issue anything further. So, like, what happens if a witness uses the word murder?
Well, at that point, it all depends on how it's used, how it all goes down. But, obviously Bryan's team's going to say, well, that's, prosecutor misconduct, mistrial, the jury's been prejudiced. And I think the judge might have to grant it at that point. Now, if it's like the lead detective or a cop and it happens, there's a presumption the prosecutor went back and talked to the witness and said, make sure you don't say the word murder. And the cops would say, yes, sir. And if they do it, then that becomes that could become a intentional, now it's not only the police, but they are an agent of the state. So, yeah, that can make it very easily a mistrial.
So many more rules than I, really understand.
Yes.
I'm used to watching court TV, not real court.
Yes, and unlike Nam, we do have rules here.
Your Honor, this is my opportunity and the place that is reserved for the defense to bring these motions. I think that they're important motions, and with court's orders, it makes it more clear. Even if the court order isn't spelling out, you can't say this, you can't do that, I think there's an awareness, and I think it's relevant to have that order. I think it's important to have that order, and most of all, I think it's protective of Mr. Kohberger's constitutional rights to have that order. That's our request with regard to...
Address sociopath or psychopath? That
Yes,
seemed
I'd like
the
to
state
address...
was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not
It's
to
like,
use
I
those
don't
terms,
get
I
paid
don't
by
need to
the
make a
hour.
full
I'm
argument.
not doing this.
Oh boy. Yeah, like you said, they're doing this tomorrow too, so this is a lot of time that they are talking about this stuff.
On that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again under Mr. Kohberger's constitutional rights to a fair trial and due process of law. This motion is really spelled out in Dr. John Eden's affidavit when he talks about the unreliability of tests that might label somebody in that particular way and the danger of having that label applied to somebody. If that's allowed to happen, then Mr. Kohberger is colored with an opinion or a way the jury will view him that is unfair. And our request is that the court not allow the state to label him in testimony as a psychopath or a sociopath. Because any kind of testing is unreliable, that would relate to, or that would become problematic within the rules of evidence to do so, and the inflammatory nature of those kinds of labels would...
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This, again, is my opportunity to bring a preventative motion to protect Mr. Kohberger's constitutional rights. And that's the purpose of that motion. Thank you.
That was pretty brief.
Thompson?
I mean, kind of brief after all the other rambling.
Yeah.
Responses that we filed, Mr. Nye and I actually kind of divided these motions up. We didn't realize they would be heard together. But as to the inflammatory evidence, what the court has noted is exactly what our concerns are. In the defendant's filings, he doesn't specify what inflammatory evidence he's concerned about. He doesn't define the phrase exceptionally inflammatory, nor are we aware of any definition of that. The words just seem to be used loosely and freely here. And in fact, in the defendant's reply, he acknowledges at page 2 that he really doesn't even know what he's trying to object to. He's asking the court to presume that something's going to happen or anticipate something without a basis for it. We don't see any basis for the court to enter an order. We intend to conduct our trial professionally, and we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative
And this
evidence.
is where he kind of lays out the whole issue about the evidence and what's necessary and not. So yes, almost all evidence is relevant to some degree. It's relevant to making it more likely or less likely that this thing happened, or you did this thing, or this thing occurred. So, that then it becomes the issue of, okay, well, it's relevant. How relevant is it? Okay, well, now it's relevant, but is it also prejudicial? So, for example, like they're talking about like these 13,000 pictures. I'm sure, some of these pictures of the people split open, and I'm sure that they're pretty gnarly wounds and stuff. Some of those are going to be, relevant. But the problem is, especially with a dead body, they're almost always going to be prejudicial. But how else do you prove a murder happened?
I'm sure some of them are just like, oh, we can see the knife wounds, and some are like, well, you can see the knife wounds and the face,
Yes.
and that could be more emotional to the jury.
Yes. Well, I mean, and it's just also the idea of 13,000 pictures.
That's a lot.
If you show too many of them, yeah. Well, I mean, they definitely documented, but
Yeah.
it becomes an issue of, like I said with that other case I had, where the guy, he was seen to being involved with drug dealers. That also becomes, things like propensity evidence that, oh, he was involved in dealing drugs, therefore he's a bad guy and he had drugs.
Mm-hmm.
Those are things you're trying to avoid. You're trying to avoid prejudicing the jury. You're trying to avoid, shocking the jury. I mean, although it's a quadruple homicide, there's only so many ways
You can pad that.
you can show this.
Yeah.
It's 4 people got knifed up really bad. When you tickle someone's spleen, it doesn't. It's never pretty.
It's not a
never
confetti
pretty, so-
explosion. They're not a piñata.
No, no, and it's not going to look like Animal Crossing.
Yeah, I mean, I got used to seeing like post-crime scene pictures or like post-suicide kind of pictures because I did insurance. And so in the insurance files, if there was damage from like the blood or the body, bloating and whatnot, those pictures would
you'd
be
have to
put in
see it.
there. Yeah, like I'd never see the actual body. I would just see the aftermath, but it's like that's still kind of disturbing to have to look at, especially without too much warning.
Yes, especially if you're not getting paid for it.
The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms or their equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you're also
get
required
louder?
to
Am I
bring that to my
crazy?
attention outside the presence of the jury.
No, I think he just
With respect to the term
microphone
murder,
in his chair.
and, well, let me start with the term
if I
murder.
had to guess.
So I don't, obviously, the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that.
I just want to say it's really I know it's a turn of phrase, but it's funny that the bald man is speaking about dander.
Yes, but he's warning them. He's not gonna. That's the one thing. This is the judge is saying, I'm not gonna let you guys screw around. And that is a bit refreshing. Although every judge says that, and then people screw around. So we'll see what that actually means.
He does seem like he is short of patience, though. So.
Well, I mean, he says that, and then the prosecutor's gonna screw around, and he'll be like, "It's okay.
It's okay when they do it.
It's okay, Mr. Prosecutor man."
Also, I saw something in chat, and I don't know how this works either, so I'm gonna ask.
Yes.
Do you think that it was done on purpose to have Kohberger have 3 female attorneys with him?
No. I mean, having a female or 2 on there would be a tactical decision probably, but all 3 being female, no. That's just kind of how things go at times. Public PD offices do sometimes have more women in them. It's a little more of a women-centric area. People who are typically PDs are a little more left-leaning anyway. Mm-hmm. So when women are more left-leaning and, going by the Jordan Peterson standards, they're far more agreeable.
True.
And they don't wash their penis. Hopefully they can't. So that's probably part of it, if I had to guess.
That makes sense. I mean, since I didn't know anything about this, I figured I would ask the question anyways, but
sure.
I don't see how having, a woman or 2 women there would be a tactical thing to do, but you said sometimes they do that. So what is the tactical reasoning that they
this is sales at the end of the day. A trial is sales.
Mm-hmm.
You are selling something, and it's about presentation, and are you likable, and can you present the facts? And I mean, it's no different than selling you an air conditioner.
Mm-hmm.
Buy this one or buy that one. You're trying to convince this jury to go along with what you want, and it's about presenting image. It's about how if you're going to go to trial, if you're a guy and you look kind of I've had clients before we go to trial and they look like they're grungy or kind of scuzzy, and I'm like, shave your beard,
clean yourself up.
One time he had the System of a Down, Surge from System of a Down. He had the just growing out like that.
Ugh.
And I'm like, that's gone. He's like, I'm not cutting it off. I'm like, you're being accused of being a massive scumbag. Do you want to, I said, you're going to deal with Susie Soccer Mom and, Nancy the nurse. They're going to look at you and see scumbag.
Mm-hmm.
So you're going to have to trim. You're going to have to shave. You're going to have to get your hair cut. The guy had to, you're going to have to be presentable. And his wife enjoyed it because he finally quit looking like he was, quit looking like a shitbag.
My husband going to trial was the best thing that happened for my sex life.
Yes, but it's about presentation. I mean, there is, how you present the evidence, but that's only part of the That's only part of the battle. Only part of the battle.
True. I mean, how can you pick a random woman over Santa Claus over here? To be fair.
That's true. Very fair. Very fair. As a big guy with a beard, I'm kind of. I felt a little called out there, but but it really does come down to. It does really come down to though. How you look, how you're presenting. Those things are the that can push it over the edge one way or another.
Yeah. No, that makes a lot of sense. Thank you for the explanation.
Yeah. And someone asked who I am, because I didn't, like I said, I didn't realize at first we were live. I'm potentially criminal. I am a law tuber, if you believe in that type of term. I'm an attorney out in the Cleveland, Ohio area, and I run Potentially Criminal and talk about trials and crime and court and legal stuff. So. And
he doesn't do cocaine yet.
No, I don't. I'm cutting it with Crisco if I'm doing that.
That'd be one way to lose weight fast, I guess.
Yeah, it would be.
I'm gonna touch my play button here.
And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. Certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene.
Are you just like tossing around swords over there? What is?
No, so the future, so 2.0, my fiance, she's working right now and she's talking really loud, and I'm like, instead of getting up to close the door, I grabbed my sword and I pushed the door closed.
Oh, that makes sense. So, I was like, what is happening over? He's just like organizing his sword collection while this guy's struggling to talk.
No.
Oh, someone in chat asked, what crime would you most likely convict me of? Is this like tarot card readings but from lawyers?
I what, like you personally out there in chat? I don't know.
Maybe me. I don't know.
Well, I don't know, chat. Whoever's asking that, are you a white girl? Because there's a presumption of what you do with dogs. But otherwise, I don't know. I don't know what your crime would be.
I think we can't always talk about the white women with dogs, because then we have to bring up the Colombian men with donkeys, just to make it fair.
That's okay. That's okay. I'm fine. I'm not a Colombian man, so we can go down that road.
That's true. True and real.
This, I would imagine, from what I've seen, some of those photographs are particularly graphic. But make no mistake, these murders, whoever committed them, were brutal. And
whoever committed them.
That's a funny thing to say.
Horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, etc., will be presented. But I don't feel it's really does anything it doesn't advance the ball for me to abstractly say don't use inflammatory evidence. So I'm not going to do that. I will rely upon the obligations of counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding the 404B evidence that was noticed in this case, which is the traffic stop.
I'm prepared to address that, Your Honor. I do note on the court's list, state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court prefers.
Let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Ms. James was going to handle that. We're happy to just submit it to the court.
I think it's
on
the
the
defendant's
filings.
motion, so if they want to argue it, they can.
Your Honor, it's the state's motion.
Oh, is it the state's motion? I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. If you want to, Ms. Jennings, address that briefly, you may.
I think it's amazing how Santa doesn't look like he moves his mouth
This
when he
relates
talks.
to the concerns that the defense.
When you have a big enough beard,
like
it doesn't move.
Something of that nature, as I understand.
Yes, Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And the defendant replied basically saying the same in their response, that they suggest to use phrases that comport with existing language and statute and jury instructions, and that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of a better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered.
I feel like we've been watching for half an hour and they're still talking about the same thing.
Well, I mean, it's all the first couple of these I've been told were pretty tangential. So.
Good morning, Your Honor.
And I mean, obviously they have to like hash out all the legalese, so it's not too surprising. But it's just like that's a lot of roundabouts here.
Yeah, I know. I was just hoping. I'm like, I hope you weren't thinking they were going to be showing like like bodies and like, look, here's how he did it. And it's like,
no, I had no
like,
idea what a pretrial hearing would be, but I was interested in it regardless. So
yes, well, and these get a little better as they get going.
Because they're like, this is like the first chunk of meat we've gotten in like ages. Like we had the release of the 911 call, which was a shit show. That call was so bad. Like the operator was just disinterested. The girls could not keep themselves from passing around the phone. Some random guy showed up there. Like who is even this?
Well, yeah, no, that's the thing. Like then these dudes were in the house. How long were they there? You know, this was like almost a whole day later.
Yeah, and it's like, well, why didn't you call sooner? And it's like, well, we thought they were drunk. And it's like, okay, but like you also said that you saw one with blood on her. So like, why wouldn't you have called the cops then? Yeah. And you saw somebody creepy in your house. Why wouldn't you have called the cops then? Like,
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan, and so the state has expressed that they plan to use that paper.
It's,
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of colloquial term.
What he's getting at there is Rule 404B, and Rule 404B covers prior bad act. Mm-hmm. And this gets to the idea of we don't want propensity evidence, meaning, well, he did bad things, so he's a bad guy, therefore he's guilty, send him to prison. What you can do, though, there are exceptions to that. So, for example, showing planning, intent, the modus operandi, identification. If you're trying to claim mistake, they can show you clearly you did this every other time. There was no mistake. You've done this before. It's called mimic, is kind of like the mnemonic we use for that. Mm-hmm. But that's what Rule 404B is. They're trying to show, and the prosecution is trying to use one of his papers to show, look, he knew how to do this. And the defense is saying, well, wait, that's a prior bad act.
So
and that's the argument they're making.
Would that count for his Reddit account as well? Because one of the first things that people found was on Reddit, he was like, I'd like to talk to people who have done previous high crimes like murders, and I'd like to see how they got away with it. Is that something that they'd be able to bring in, or would that be considered
No, you could use that because you could show, planning and knowledge and all those things. But part of that issue is you'd have to verify that's him. How do you know that's actually him? It's the idea that we all know it's his Reddit account is different than a court saying, yes, that is his Reddit account.
Yeah.
Use that and convict him on it. But no, his papers, his academic work, that's all fair game. And it's because that's a I pretty much there's statements you've made that are out there.
And it's like, I guess you could also use it to show, like, not necessarily prior bad behavior, but it's like he took an interest in this. How far did his interest go?
Yeah, was he doing a practicum right now?
Yeah.
It's like, look, I know it works.
He was doing the legwork before he did the practical exam.
Yes.
Yes,
and I agree. Yes, he used Reddit, so he should go to prison. Anyway.
Exactly. All Redditors are always guilty.
Yes.
Sleazy in the chat asked, Sean, does Kirsche know about Mama JF? What is a Mama JF?
So, do you know who Jean-Francois Garapi is?
No.
Okay, so he is he is the French Canadian, part of the alt-right.
Oh.
That was back in the day with like Nick Fuentes, Andy Worski.
So
do you know
he's
who
gay.
he is, Andy Worski?
Yeah, I know Andy Worski and Nick Fuentes.
No. Okay. Yeah, so no, he's not. No. Unlike I don't think he would. He would look at Nick Fuentes and go, "But you are homosexual. I do not wish to have relations with you, Nicholas." Because he's got that accent, and he's very conceited. He's like a neuroscientist. He's actually very intelligent. He had affiliations with Jeffrey Epstein. Like, that has been confirmed.
I see. I was going to say he sounds cool until you said that.
Yeah, well, he has this thing where he dates mentally handicapped women and he marries them, and then he starts pumping out babies with them. Like, that's his thing. That's his thing, is about, like, breeding women.
He's a potato sexual?
Yes, because he likes them potatoes.
Oh my god.
Well, the last time around, he had a woman, and she got the nickname Mama JF because his name is Jean-Francois, so he calls himself JF. So her name was Mama JF, and she had come on stream before, and she's like, and the problem is she's Quebecois, so she already sounds retarded when she speaks, and then she's retarded, so she's even more retarded when she speaks. And she's like, "You're trying to kill me, help me, everybody!" And like,
so she just sounds like an Indian woman.
Yes. Sorry. So at some point, JF says that Mama JF went for a walk in the woods. Like, she just got dropped off, and she had like a backpack with like a juice box in it, and she wandered off into the Canadian wilderness.
Oh, that is suspect.
And then right after that, JF then does he's like, "Hey guys, look, I did a home renovation. I stripped everything out to the subfloor, the studs, and we rebuilt everything. Isn't this cool?" And yes, it's very likely he murdered her and cleaned out the house, and the RCMP, the Canadian FBI, and other police agencies have been to the house. They couldn't find anything, and she's been missing now for quite a while.
That's fucking crazy.
Yep. And as it said, he mashed the potato.
Oh, see, I was gonna make that joke for like having retarded kids, but this is a different kind of mashing.
Yes, he bleached and cleaned the entire house. Yes.
That is insane.
Yes.
Oh, clearly Bryan Kohberger needed that man's advice.
Yes, he did. He did. And it's And yeah, it's probably not likely. The RCMP, did I say the RMCP? Yes, the RCMP.
I'm also bad with acronyms.
The CSIS, or whatever the Canadians call their higher level agency, like, they had all kinds of law enforcement looking, and now he claims he's kind of on the run across Canada, because the police are putting the heat on him.
I was saying, why would he be on the run if they couldn't find any evidence?
Well, at some point, it sounds like it's starting to fall apart. We don't really know, though. We don't know, because he's also kind of retarded. So it's hard to tell what he's talking about.
See,
and is he really?
I'm so used to like streamers getting swatted and streamers being like the victims in these things. I would love to see a streamer get in trouble for murder or some shit. That would be fantastic.
Yes. Yeah, I know. Like, you got Johnny Somali out there like, "Oh, I'm making Korean people mad." It's like JF is just like beating his wife to death with a hammer.
He's just finding mentally deficient women, impregnating them, and then taking them out in the woods like Old Yeller.
Yes.
Allegedly.
Yeah, no, it's a thing, and he actually got interviewed. These women out in Alberta, they sound like the most stereotypical Canadians too. They started covering the story of Mama JF, and JF showed up in their chat and was talking to him, and last week, and he agreed to come on and talk, and he's like, Mama JF, she went to the woods, and she lives on the street, and that's where she wished to be. So I tell her goodbye, au revoir, and she walked off the woods.
That's not believable.
No, it's not. But that's what he says.
Jesus Christ. That's something I'm interested in now. Like I'm not a huge repository of information on like streamers, and I only even tangentially got information on like lolcows from watching Jim. My memory is trash. Like I can't even remember half the people that have been talked about.
JF would have been like 2016, 2017 Jim.
Yeah.
Medicare. So that's why you have to go like way back.
Well, I mean, like I even forgot like Bathtub Ross and Short Fat Otaku were people that Jim talked about, and I completely forgot their existence. So.
Yes. No, it's very true, and it's I mean, and Short Fat Otaku is one way, and now he's like, you go look at his Twitter, and you're like, wow, he changed.
That's what I guess lusting after trans women will do to you.
Yes. Very true. Very true.
Prior bad act to show that the party acted in conformity with that they have propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder.
He just like
that's
me.
How the rule works.
Yeah.
I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in-run. The same example that I will give you has to do with the Amazon records.
I don't think that we're reading the rule the same is the concern I have, and so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act.
Also, if he had that knowledge, why didn't he do it?
Yes. But the other thing here is he didn't do so good. The thing is, though, this isn't a prior bad act. This is just a statement he's made. Mm-hmm. This is something he did. This isn't a bad act. This is like if, when you hear about people, they murder their wife and they write like a murder story and they save it on their computer and it's like they wrote a murder novel and it's like exactly how it happens. And you're like, that's not a prior bad act. It's just literally you kind of just tipped your hand to it. And then and for Chad, I know they're wondering, what's a self-authenticating document? There are times where if you bring in documents, you need the person who signed off on it or somebody to come in to be like a custodian of records who can talk to you about the document and verify its authenticity. Well, there are times where documents are self-authenticating. So in certain situations, if you have like a court judgment that's been stamped and sealed by the clerk of courts, there are times where you can bring that in. I don't have to bring in the clerk of courts who says like, yes, I stamped it. Yes, this came out of here. The document by itself is authenticating. So that's what they're talking about. And yes, Bryan Kohberger's, doctoral thesis is going to be or this thesis paper, whatever it is he did. This will be self-authenticating because he wrote it. We know he wrote it. Nobody's questioning that he wrote it.
Like, even if he does get convicted while he's in prison, he can always just be like, this was the ultimate college thesis I actually put into practicality instead of just words.
Yes, he can write his paper afterwards. Well, apparently my theories did not work.
I wish Joey Spaghetti had responded to me, but maybe he did, and my P.O. box just didn't get it because my P.O. box was terrible. But there was how do I explain this? I was on a dating website for prisoners because I found it while I was on stream, and I was like, this will be fun. And apparently death row inmates are also allowed to have dating profiles. And
yes.
Joey Spaghetti, that's not his real last name, but I've forgotten his real last name at this point. It was some Italian thing. He was on death row, and his like little bio was just like, I didn't do it. And so I had to look up Joey Spaghetti and figure out what he was like even in there for. And they basically had him dead to rights on evidence, as far as I could tell from reading the story about the murders that he did.
I'm totally sure they did.
And so I was like, I'm gonna write to Joey Spaghetti, and I want to ask about anime and who his favorite waifus are, and then also ask about the murders, and maybe we'll get a fun story.
Well, there's an entire show. It's called Prison Wives, and it's about these. Mainly, they're women from overseas who come and do the prison pen pal thing with guys in America, and it's very interesting. It's you'll watch it for 5 minutes, and you're gonna be like, not surprised, exactly what you're expecting. Chad, I know what you're thinking. You're 100% expecting it.
I think it'd be super fun to like find prisoners on those dating sites and be like, I don't want to date you, but I'm fascinated with your story. Please communicate with me.
Well, there's a funny thing I covered this on my show. I think it was a week or two ago. So there's a guy in California. They do conjugal visits still, and it's like you hang out. You get like 48 hours to spend with your loved one, and they have these like little trailers on the prison yard, and you get to go in them, and you have to show up for counts. Like you have to stick your head out the window. This guy had been convicted of murdering somebody and strangled a woman.
Oh,
well, she ended up, this other woman's like, oh, I'm gonna be his wife. He ends up murdering her in the fucking prison trailer.
Oh, wow.
And her family's like, no, oh no, it's like Pikachu mode, like, oh no, who could have seen that coming? Like, the guy who murders women murdered a woman.
Wow.
And then apparently, recently, a guy did it too over, like, Valentine's Day. He murdered a woman, and he had been in prison for, like, doing, 40 years for, like, being in this carjacking where people got shot and everything. And, everybody's like, how could we have foreseen this? The prison should have done something. And it's like, maybe you shouldn't hang out with the violent felon.
I mean, like, there's obviously a degree of I can fix him. Look, he violently murdered this woman, but I can fix him. I can be the one that makes him better, right? Like, I can get that, but also have some self-preservation, right? Like, if he specifically targets women, maybe don't try to fix that one. Maybe stay away.
Yeah. No, but women have this thing, and it's like I said, the Prison Wife show is hilarious because it's they have like Svetlana, and she's from Lithuania, and she's like, I come meet Jamal at prison in Detroit, and like it's like that's how it goes. You're just like, what the fuck?
I'm like, why are you doing this?
Yeah, it's like you couldn't it's this nice like perky little thin blonde lady from Eastern Europe. I'm like, you couldn't find some guy in London to be your like husband?
It's like you could have anyone you want. Why are you looking in the prison system?
Find some Russian oligarch or something. Like, come on.
And that's like, before I started VTubing, I always thought the like I can fix him mentality was purely a woman brain thing. After being a VTuber and seeing how many just like off-kilter men see like the most deranged psychopathic woman they could possibly find and just be like, I love her. I will forfeit all of my material possessions to her. She will love me. We will be together, and I will fix her. She might have gone on a tirade that almost landed several men in jail, but you know what? That won't be me. I will fix her. I was like, you are crazy.
Well, crazy goes everywhere.
It really does.
Crazy goes everywhere.
Speaking of crazy.
That might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, etc., that's not anchored to a bad act. And so I don't see how 404 relates at all to the Distell's paper.
Well, it's our position that the way that the state is putting this in is, in essence, trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right. Well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
It's not a bad act to purchase things on Amazon.
But the state is using it.
Caleb Hammer
I
might
agree with
disagree.
the judge. I agree with the judge. It's not a bad act. And to be fair, when she says, like, I understand that, the way she phrased that, that's how you have to say it, where it's like, well, I still think you're wrong, but I know I'm not going to win the argument.
Yeah.
You can't pull an Ethan Ralph and go, no, but it's you, Yana. You were wrong. It's like, no. You're like, I'll save that for appeal.
Like, I could get it, right, if he had, like, bought the martyr weapon off of Amazon, but if they're just like, look, he bought zip ties a month ago, it's like, well, what does that have to do with anything?
Well, I'm sure it's like, he bought zip ties and a shovel and some quicklime.
It says here he bought hog's feed.
Yes.
Judge.
Yeah, but no, they can use that
To
all
show-
towards it.
Yeah.
Using it as other things to show a plan or knowledge or intent.
That is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right?
Was it just like the drug guy you were mentioning earlier?
Abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
Correct.
It's our position that the state is trying to do an in-run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice. They should not be able to argue evidence is a prior bad act or make any attempt at an in-run on that rule.
So I'm not understanding what you mean by an in-run on that rule in this context.
Yeah,
By
I don't think
saying
it's an
that the
in-run.
argument about the Amazon purchase is that was prior to November 13th, 2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I
not a bad act.
think I understand what you're saying. I just think we're
So I think
completely missing
completely off
each
base
other's
here on this
understanding of
one.
the rules of evidence.
Like I get what she's saying, but like if that's not how the rule works, then she can't use that rule for wanting to exclude that thing.
Mm-hmm.
It's just like that's why I brought up the drug guy you mentioned earlier, because it's like if he had done like a murder before, they would probably be like, okay, well you can't bring that up because that's something that he did before, and then that would taint like the jury, right?
Yeah, but this still though. I mean, they're not. And like I said, I'm not the best lawyer in the world. I'm a retarded guy who wears pants.
Same.
And I figure out how to do it. This is not even close to being, Rule 404 territory. It's like if you drew a map out of like the bank you're gonna rob. It's like, well, that's a prior bad act. No, it's not. You literally drew out a map of the bank you're gonna rob and the route you're gonna take. And the police, the route, you wrote down the police response times. No, that's valid evidence that you committed this crime.
That's valid evidence for
you can't-
this crime.
Yes, and that's the thing. You can't just run around like. I didn't watch a whole hospital. If they're gonna scream everything is 404B. Okay, at some point you just have to start just accepting like it's coming in.
Yeah.
Because this is getting kind of retarded.
Ever since you mentioned the like cutting out pieces of the drywall and stuff earlier, I just imagined like one of the prosecutors coming in with a giant piece of like bloody sheetrock. And like, this is my evidence for right now.
No, I mean it happens sometimes in these cases because they want to show the scope of what's going on. I'm sure they've got a couple of them. It's going to be interesting.
Yeah.
Well, I still stand by my position that the state should not be able to in-run that, and I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or keep
On
it
the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car. That is not just the make and model. It is Mr. Kohberger's statement that he doesn't think seatbelts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop.
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So it's
what year?
Of 2022. So it's remote. It's
Before the murders.
Yeah. Yes. Before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Wouldn't that not matter? Like, I get what she's saying with, like, the way that he's talking to the police officer with the phone number and the seatbelt thing, but, like,
Yes.
the description of the vehicle, I think, is, like, something that they can use to be like, this is definitively his vehicle, and I don't see how they would not allow that in.
That's and it's a valid argument. Like, it's a very good argument. Like, I'd like to think they're just doing everything they can and throwing everything at the wall.
Yeah.
But the way they've argued some of these really makes me think, like, it's one thing to make an argument for the sake of making the argument, but some of these are so bad it's hard to figure out which way they're going with these arguments.
Yeah.
Like, is some of this stupidity or is some of this just pulling out all the stops?
Probably a little bit of column A and a little bit of column B. They're wanting to pull out all the stops, but they're just not, like, good enough at arguing it.
Yeah, and if it's a little bit of column A, a little bit of column B, he's going to get executed.
Yeah. Yeah, unfortunately.
Yeah.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, and so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, I can't remember the name, the maker.
Hyundai
Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records, and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state
Sounds like that makes the evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, how can you make this determination of what the automobile is, et cetera, to me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but...
Okay, well, they've noticed it as 404B evidence, so I'm arguing it in that context, and what other things can be drawn from this video that make it over...
If he's telling her that it could be excluded under 403 but not 404, why doesn't she just argue it under 403? Am I missing something?
No, I don't think he's saying he would explicitly argue. I think he's trying to make you'd have a better argument.
Yeah.
But no, and that's just, remember, Rule 403 just goes back to, like, the relevance issue. And I think that that's always the better argument to make is, what's the relevance of this? Because you can always argue the relevance to something, and that's why usually at trials you hear attorneys really always objecting on relevance. Mm-hmm. It's an easier time than having to go down this road of, like, it's a prior bad act or running into like Rule 404B. It's a much harder argument to make.
And it doesn't exactly inspire confidence that the judge is having to correct your attorney and be like, well, you'd have a better case if you did it under this rule.
I mean, sometimes yes, sometimes no. It's just, remember, he's also making what he thinks is a proper argument, and
I mean, for sure, but if I was like in Bryan's position here, I'd be kind of sweating a little bit, like.
Well, you know, they said he's got a little bit of autism going, so he's like, this is, you know, he's not picking up social cues. So
maybe that's true.
Really prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
But you don't get
his
to,
phone
and I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
I think after what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence.
This man's bought a
Just
book
because
with
it's
him.
prejudicial, and just because the defendant doesn't like the fact
Yes,
that
he
we can
has.
prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask
Yes,
that
it
the court
is.
deny the defendant's objection
Your Honor,
to the
this is
admission of this
devastating
evidence.
to my case.
This actually confirms it was me. Please exclude it. This judge just looks so tired.
Well, yeah, but I mean, they have to do this. They have to do this. Partially.
It's. I mean, like, yeah, you have to go through it, but this judge just seems like so exhausted, man. And this is the first
Yes.
pretrial hearing, to my knowledge. So, like, he's just already done with this case.
Well, yeah, well, because they've had other ones that were a little more supported with argument that weren't just kind of like complete dumpster fires. So yeah, this one is a complete disaster.
What about the concern within the video, as I understand it? First you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another, of violating the traffic laws in some way, including by not wearing a seatbelt. And so can you address that part of it, the prior bad act, and how the court should deal with that? And then also I am concerned with the issue raised about the communication between the officer and Mr. Kohberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. I think when you review the video, you can put it, the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's a preposterous concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thank you, Judge.
And that's his point. Like, I just want to show he was there, what his phone number is, and that he's driving a car. That's all they want out of it. They aren't worried about him saying, oh, look, he's being dishonest or he's being sketchy. They just want to show all the basic information to show it's him.
I feel like if you had a higher propensity for murder from not wearing your seatbelt, I haven't really worn one since I was a child, so like it's only a matter of time until I take someone out.
Well, and that's what the defense is worried about. They're like, oh, they're going to show he's doing this and that, and he's a bad guy, and and there is a fair argument to make that, like, oh, he would refuse to give his information. I don't have to cooperate. Well, yeah, that's somebody knowing his rights, but to the average person, it does look sus. But that's what the prosecutor's like. I don't need it for that purpose. I just want to show he was in the car.
Yeah,
and I just want to show his phone number is. So I think that makes it a little easier for the judge.
Definitely.
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, the make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case, and so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
All right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote-unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so, I don't think we can say that the shot clock has run out on that at this point. But certainly, as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. And so, as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically a prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile.
I didn't even think of that, about how, like, not wearing your seatbelt is actually illegal in most states. That would have been, maybe that was the point of her argument, being like, oh, the prior bad act was him not wearing the seatbelt, so they can't include this.
Well, they're showing he's a lawbreaker. He's a bad guy. He was speeding and not wearing a seatbelt.
Not wearing your seatbelt is pretty, like, low on the scale of crimes you can commit, though.
But once again, this is a combination of they're trying everything, but they're trying so hard they look stupid.
Yeah. It's
like I would not, like, if I was on this team, I'd be like, boss, I ain't making that argument.
Be like, I don't want to look like that much of an idiot.
Yeah, I'm not going up in front of the world and talking about my seatbelt.
I don't know. It just seems like, after hearing him explain it, I was like, oh, that's the angle she was going for. But, like, I could also see the, like, him refusing to give his information, possibly poisoning the jury, because they'll be like, oh, well, he just, has issues with authority. He's like a suspicious person. He's not trustworthy. Yeah. I could see that, but it's like, I also wouldn't trust the prosecution when they're like, yeah, we're not going to say that. We just want it for identification purposes. So, like, I get her point, but...
Yeah, well, and this is where I'm surprised the prosecution didn't offer, like, fine, we can redact that part. We can bleep it out.
Yeah.
We could just go beep.
Yeah, but, like, why throw her a life raft when she's drowning herself?
Yeah. No, well, I would do it just to, it's a further insulation of the case, because they don't want it to come back on an appeal.
Yeah.
Like, the amount of money that's being spent on this, they can't, like, if they try this and then they lose, it's over.
Yeah, of course.
They don't have the money to do this again. So I would just say, fine, we'll redact that part. We'll redact that conversation out of it. Mm-hmm. I mean, there's ways to do it. That might have been a better way.
It's possible, but I don't expect this prosecution to, like, throw anything at the defense, really.
Yeah, I understand. I get it from their standpoint there.
Mm-hmm.
For that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion.
It's almost like the judge said, because he doesn't wear a seatbelt or he's a sped. It's like, no, that he sped.
Yeah. Well, I mean, it could go either way, but...
Yes.
The jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404, or notwithstanding 404B and 403, I do want the video potentially, I'll look at it, and it may change my mind. But just from the description, I am concerned about some of the interactions with the officer, that was mentioned that, that Mr. Kohberger questioned why the police needed his phone number. That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant. And it does
He's bringing up
potentially
my
create
point.
some unfair, some danger of unfair or unnecessary prejudice. So I think it
Great
needs to
minds
be
think alike.
redacted
I'm
to exclude
smart.
those kinds of things and
You
have
could be a judge.
the
Oh, please no.
video that shows his vehicle, that he gives the registration, that identifies it as his, that his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Is Sean getting kidnapped? What's happening?
No, I had to take care of something real quick. I'm still here.
Oh no, that's
Can't be
okay. I was just like,
do it.
what is this martyr view of the camera?
No. It's a. No, I'm not getting drone striked yet. That's next week.
Yet. Oh, okay. Well, I'll be sure to watch that live. It should be just as exciting as when Trump drone striked all those terrorists the other week.
Yes.
Thank you, Judge.
I like how they got in a big circle for it, though.
I know. It was like a ring around the rosy thing. It was like it was planned almost. That was cute.
They help make the bomb's explosive, probable kill radius more effective.
Nice, cute little drone strike.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family in general, in terms of a reserve seat. I'm not as concerned about the reserve seat part. We can address that at the pretrial conference down the road.
Chad,
I'm more concerned about the ability to be in the court.
You have what?
I have iron hands. I'm not paper-handed. I did not. But I was in court. I did not have a chance to buy the dip. I just have an iron hand.
Oh my god.
This hand doesn't falter. I don't click sell.
I was wondering when I should buy, and I might have waited too long, unfortunately.
Yeah, you should have bought last night when things were at the end of the day yesterday.
I'm on stream when the stock market closes, unfortunately.
Yeah. Yeah, no, that's the thing. So, Good Emperor says, explain the paper hands again. Paper hands are fragile, and they're frail, and they're scared. And the moment something doesn't go right, they sell. You have to be iron-handed, steady.
Yeah,
You don't move that. You don't click that mouse. You stay there.
I've never bought stocks before, and I don't know anything about investing, so I'm basically just kind of like, I'm going to click the thing, and I'm going to throw some money at it and hope it works.
Yeah. Well, the biggest thing is just write it out. There's like, you have to, if you try to do it like day trading, that's a thing, but the longer thing is just make a smart decision and hold it for a while. And that's an easier way to make money.
Yeah, I just kind of want to put it in a thing and then, like, forget about it for a while.
There's nothing wrong with that.
Notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-06-1B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of the defendant's family, but that's, I think, the defendant's motion, so I'll let them address that first.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further, that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them having been in isolation for almost 2.5 years. And by the time we get to trial, it will be almost 3 years.
Wow.
His parents attend every court hearing.
That is pretty scuzzy that they have subpoenaed and noted his family members like that. Like, oh, we want to use them for what things?
Yeah,
It's just their way of trying to keep him out of the courtroom. Now, that is a neat way you could screw with the rules in court. There are ways you can abuse the system.
Yeah, I mean, neat is not really the word I would use, but yeah, it's
a sandbox, and I'm just telling you how they can play in it.
No, I mean that's perfectly normal. I'm wondering if part of the whole like him having autism thing is like how has solitary sort of like affected him?
I'm sure he's been like, this is the best time ever. Everybody leaves me alone.
He's just like, what? People freak out about this? Like, I'm perfectly fine.
He's like, wait, you bring me chicken tendies once in a while, and I just read books.
I don't know how much I'd like the state tendies though. That's probably like the bad pink goop.
Reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Kohberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged. The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held, the assistant district attorney's blatant abuse of the trial court subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, who it would be even rational probably for the state to actually call. At best, there's one potential family member that they may see a reason to call. The state knows that Bryan's family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Kohberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber. And for our client, the jury will know that he has people there to support him. Mr. Kohberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Kohberger to have his family sitting behind him.
I definitely see your point here, because like if the jury sees like, oh, he has nobody behind him, that means nobody cares, and that means, you know, obviously there's a tenuous relationship, they're going to make these assumptions. And also, like you said earlier, it's kind of bullshit that the state's like, we can keep your family out of the courtroom. Like, just in general.
Well, this is, remember, like I said, it's about presentation. Who's here? Who supports them? How does this look? It is really about sales. It's about presenting and crafting a narrative. And yeah, if there's a whole empty row of seats there, it looks pretty bad.
Just a little bit.
Also, it would help him feel good knowing that they're there too.
Yeah, I mean, like, even if he gets convicted, it's just like, at least my family like was here to show support for me.
Yes.
We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. What? There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
They don't want people showing up with, like, wearing, you know, firing squad and death penalty.
I think that would be a little crazy for people to do. Yeah.
Well, I mean, when Ted Bundy was getting executed, people were selling T-shirts out front.
I guess that's fair.
You know, like, the true crime wine moms are dangerous.
I feel like the true crime wine moms would be more likely to, like, salivate and want to fuck Kohberger than they would want to, like, wear fry 'em up T-shirts.
Well, no, they want to do both things. They're crazy.
Like, first let me show him my titties, and then put him in the chair, and then I want to feel the residual shocks from rubbing my tits on his face.
You laugh, but I guarantee you some of them are thinking about that.
Oh god, I hate it, thanks.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Kohberger's family from the courtroom.
Yeah, right?
The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment, has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support Mr. Kohberger.
The reason you can't simply take up whatever family members you may need to testify in your case in chief right at the beginning.
I was about to say, you notice they aren't saying, Judge, we're totally not doing this to abuse the subpoena power.
Yeah, right.
They haven't stated that, and it's, as I tell people on my channel, notice what they're not saying, because what they're not saying is as important as what they are saying.
Because
it's like,
lying by omission is not as bad as straight up lying, because that's not illegal.
Yeah. Well, no, lying by omission to the court is, you can get disciplined for that. So, no, it's just they're avoiding the issue of saying, well, we're not abusing our subpoena power. And the judge, they're just starting to call out, well, why do you have to subpoena all of them? Like, what is the plan here? And, you know, oh, well, that's not our plan, Judge. He's like, well, what is your plan? And she's like, well...
The defense has also just not made many good points thus far, so, like, I kind of want them to get something here, you know?
Yes. Yes.
How you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them, and picking them up again. And so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, you know, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into that into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so
I thought you said gumball, not gumbo.
Yeah.
So I was very
Yeah,
confused
well,
at his
I was
analogy.
confused too. Yeah. What kind of fucking gumballs are you eating in Idaho?
Yeah, I was like, what the hell?
This gumball is this is mountain lion flavored.
Gumballs have layers.
Yeah.
I think we get too
God, stop it. Thank you, Mr.
excessively
Wonka.
stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendants support family here in the courtroom.
I do too. And I guess my preference would be for that, even though
But
it would
you
be
really
out of
don't.
context.
You don't
and interfere-
understand it.
Yeah, she's trying to
He's like,
wiggle
"Fuck."
around her
Yeah.
using the subpoena thing.
Yeah. She's like, Judge, just look, fuck these people. is what she's
Fuck
trying
these
to say.
people. Fuck his family. You know, he doesn't
Yeah.
deserve them.
with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
Constitutional right is not absolute and bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says a court can't use the exclusionary rule where, in good faith, a person who was otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you.
The huge manatee.
I'm going to take this matter under advisement. The defense raised some cases. I want to read those, though I don't think they were precedent on this court setting. I have reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think, about to use counsel's word, the humanity. I
Oh
think
my God.
that, I can only imagine the family of Mr. Kohberger is devastated by these things. That's nothing that they did. And I think their ability
they
to be
did do
here
it.
to
Right?
see the trial is important.
We love you, Bryan. Good luck.
To the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't, reviewed their interviews. I don't know anything.
Their
I do know
cameras
there's been an issue
died.
raised by the defense
Yeah.
relative to purchases on
It's a little-
alleged family account that could be an issue.
This is government
and so I
cameras
do see
working
some
shit.
issues
They don't
where
have the high
family members
quality
may be important.
equipment.
They're too busy spending tax dollars on hookers and blow to get good quality cameras.
This is what happens when you put Drag Queen Story Hour. They had to spend the money somewhere.
Those drag queen wigs, they're expensive.
Yes.
Oh, now it's just dead. Now I can't even play it.
Yes.
Oh no. Welp. It's so over.
Rip. Rip.
I was like, I would question if it's my internet, but I would have gone down on stream if it was. Help. I guess I'll try F5ing. Hold on.
Yeah. Sometimes it needs a second.
2:14 exactly on the dot.
But there is, I don't know why the state would want to call them. I haven't, reviewed their interviews.
You have to
I don't
turn
know
the
anything.
sound back
I do
on,
know
the
there's
booster.
been an issue raised by the defense relative
when you
to
refresh, it does
purchases
that.
on a alleged family account that
There we go,
could
get
be
the
an issue.
boost.
And so I do see some issues where family members may be important. And so I think there may be some need for exclusion, but I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course.
Why are the papers so loud in comparison to their voices?
All right, let's talk about the defendant's motion regarding conditions as an aggravator, and this is the concern about using the defendant's alleged autism disorder diagnosis as a aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for trifurcation with the death penalty, and that was denied. But we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Bryan, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Bryan's physical body is more stoic, how he sits in one place. And he will look for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Bryan is. We seek to prevent the state from using those kind of characteristics against Bryan. We seek that in the way of testimony they might bring. Sometimes
Chat, this is where they're calling you out.
It makes sense to exclude that too.
If you're on the spectrum, they'll execute you in Idaho. So stay out.
I was like, she's completely right. He's basically sat in the same exact pose this entire time. I haven't seen him like move his hands to like scratch his face or like move his hair or like do anything. He's just one position.
Yes. And when they're talking about they want to bring this up during the penalty phase. So if he gets convicted during the normal trial, then the second part is you have a second trial basically about the mitigation phase of do we give him life in prison or do we give him the death penalty? So that's the second part, and that's what they're worried about, where this is all going to come up. They'll be like, look at him, he looks like a killer. I'm motionless.
You motionless autists, you're just one second away from committing murder. Your dino tendies are late.
Get that tired rage boiling up in you.
Talk longer than maybe other people want to listen, and that doesn't mean anything.
Well, I assume he's not going to be talking in court unless he's testifying, so.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness.
Yeah, and also the talking isn't necessarily anything to do with his body language either.
He keeps talking about trains.
He's explaining the rules of D&D 3rd edition. Make it stop.
Yes, everybody in college is like, he talked about anime all the time.
Gotta give him the like spinny helicopter hat and the giant lollipop to make him look like the J.D. Vance memes. That'll endear people to him.
And using that as aggravating evidence against Mr. Kohberger, and that's what we don't want. We want to be able to present if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has and to prevent the state.
Reading the the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do with how we deal with that with the jury in terms of the penalty phase, right? Mm-hmm. If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Kohberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Kohberger's autism characteristics.
How would they use it as aggravating apart from
There's awkward silence.
arguing to the jury that,
Yes.
well,
Well, is that
because
you
he
trying to
has this
sneeze?
condition, it means that
Like
he
somebody
is,
did. It's like that's
I'm just making this up.
this awkward
obviously,
time
is
to talk about autism.
inclined
Someone's
to not
Right.
follow the norms of society and presents a greater danger or something like that.
That's true. Autists are dangerous. You said that after this, if he gets convicted, there's a second trial to decide whether it's life in prison or the death
Well,
penalty if
it's-
they can't get rid of it. What
Yeah.
if
Well,
the
it's-
angle they go with is my client is autistic and autistic people have a propensity for turning into not women? Bryan Kohberger is actually now Brianna Kohberger, therefore he should not be given the death penalty. Is that a defense route that they could go to?
Yes, ladies and gentlemen, let me tell you about AGP.
Well, they couldn't mention AGP because if they bring up the fetish, then it's just like, well, now he's just weird and not a stunning and brave
You see
woman.
the smirk. The smirk, ladies and gentlemen. It's not a normal smirk. No, it's no. I mean, it's a second trial, but literally you move on. Like you go from that into the next thing of the jury. The jury's still there, the same jury, but yes, it's like a second thing about proving how irredeemable he is, or how much, is he a nice boy who didn't do nothing wrong, or should we just send him to the death house? But yes, they could try that. They could try the argument of, yes, it just, he got into the Truman shine and he got carried away.
In prison, he realized his true self. It wasn't Truenshine, Your Honor. It was just, he's a beautiful, stunning, and brave woman, and if we execute him, that's trans erasure.
Yes. No, it's trans erasure. Somebody says, Your Honor, look at his hump look at the hump in his back.
Good Lord. I know there's a lot of inmates that do that, but I would love to see someone like halfway through a trial just like break out that defense.
Your Honor,
I'm sure
the
we'll see
order
something.
would
I'm
prevent-
sure we'll see something.
You're sure? You're waiting for
Yes.
the random upset in the middle of it?
Yes.
the
I'm waiting for
state
it. It'll be
from on the front end in presenting their aggravation case from using the conditions, the way autism works for Bryan against him, to say that he does things that are consistent with autism and that's an aggravating circumstance.
I'm just having a hard time envisioning what that would be, how it would be presented in a way that is making it an aggravator.
Well, I would hope that it wouldn't be presented that way. But, Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr.
The Three Musketeers of Discovery.
Yes.
I don't know why that made me think of candy bars.
Kohberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Kohberger's been arrested in this case. And people that he went to school with, that he interacted with, had
changed his
unkind
position.
things to say about him. And a lot of their unkind things, when you understand them in
Hello,
the context of
fellow humans.
autism,
Yeah, he's like, I'm finally writing something down. They've used my activation word, mounds.
Yeah. Yes, he's like Mark Zuckerberg. He's like, I am not a robot.
Hello, I am interested in fellow humans and what fellow humans do.
the way he may stand in a room near a doorway, the way he may look too long at a person. Their interviews are different when you
Too
know
long
he
at a
has
woman.
autism.
Yes,
and
I'm
you
sure
know
that women don't see this as being okay.
They probably thought he
looks-
was weird as fuck until he murdered people, and
Yes.
now he's hot.
Well, okay, yeah, now they're like, before I thought it was creepy, now the bottom of my chair is just sopping wet.
When he would stare at me from the doorway, I would feel unnerved, but now I notice his eyes have a glint in them. It's almost cute.
characteristics he displays, but those awful comments, those mean comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I, though, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to, in a mitigation aggravation penalty phase. Your position is that's due to his his spectrum disorder, whereas the state's view may, no, that's not. That's his view of women and goes to motive, etc., and goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem, Your Honor. If the state, and
Do you want
I
me to,
wanna
you want
be
me to weigh in
clear.
and say what the factual findings are, that it's this and not that? And I'm not sure I can do that short from a jury instruction that, you cannot use.
And like, she's basically just like, please, I don't want the prosecution to call my client an autistic weirdo. I don't want them to
Yes.
be like, he's autistic, therefore he's dangerous. Like, I don't.
Yes. No, I know. It's like, Your Honor, can we make a motion so you don't call him a sped? Okay, granted. It's like, that's all they have to do.
That's pretty much all they have to do. But like, they're wording it in such a legalese way that it's frustrating almost.
Well, yeah, no, this is I am not impressed with this. This is not impressing me right here at all with the way they're handling stuff.
Yeah, his defense does not seem the most competent, and this is even coming from someone who doesn't usually watch these things.
Mental health conditions as an aggravating factor.
that's an
What are
appropriate
you
jury
laughing at
instruction,
here?
and if
Did
we
somebody
get to
move?
that phase, my
you-
guess
yeah, I
is
mean-
that we'll have
And
one.
it's just like, I unpaused and he's like,
Oh yeah, he
mental
does
illness.
that a lot.
Yeah, he's struggling over here, man.
Too much under pressure.
Crypt Keeper needs some, like, Red Bull or something. I don't know.
Yeah.
Of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present
There
mitigation,
may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not
I
exist.
hope so.
I think that the court will not find that that comes up. I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with and that Mr. Kohberger's constitutional rights are protected.
Thank you.
Oh boy.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom.
Relying on it as what?
They're like, we're not going to rely on his autism. Like, well, you shouldn't. It's erratic.
Yeah.
You can't count on it.
And also you can't be like, Your Honor, this man is autistic, therefore he is a danger to society. Like, that's not always an equivalency.
No, it may be true. Even though it may be true.
It may be true, but it's probably not the autism that made him do it.
No.
Of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just
There are levels to autism? I thought it was a spectrum. How do you level up?
Well, there's many ways to do ASD. There's all kinds of ways of engaging in it. So like level 1's the high functioning stuff.
Mm-hmm.
Like when you have the Asperger's.
Mm-hmm.
You got the Asperger's like Cartman had.
Yeah. Okay. So like level 1 is actually the highest level. You're the most functioning.
Yes.
Okay. All right. That makes sense.
There's a couple of different levels.
I was like, how is he getting experience for this? It's like every time he rides a train, he gets more experience towards level up.
1? Fuck, he hasn't leveled up yet. Why is he only at 1?
My murderer was trains,
He's
man.
like Dark Side Phil.
Not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we've put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation. Thank you, Your Honor.
Your Honor, clearly he was spec'd into the school shooter class, but his autism made him stab people instead. This is evidence we need to enter into the record.
Yes, this IEP didn't work out so well. Yes, we found out his CSGO. All he used was the knife.
Oh, God. I could just, see the autistic running with the knife flicking in my mind, and I never even played CSGO.
They're like, Your Honor, do you want us to show
We
him
understand.
reading? Would that make you feel better? We're doing demonstrative. Bryan come up here and go, "Ree!"
We're gonna use action figures to replay the scene.
Yes.
That the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received through our expert disclosures reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Kohberger's constitutional rights, and we ask that you enter an order.
Thank you. Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. The state certainly shouldn't make those arguments and are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. And so I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say don't make that argument that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the symptomology that the defense contends is part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor.
Thank you, Skeletor.
Right. Why don't we take the morning break? We'll take 10 minutes and be back at about 20 till.
Yep, this is Clyde.
Hello, Clyde. Hello, fluffy doggo.
Yes, he is. He's a good boy.
I got a decently long break here. I have to make
It's
some
only
sort
like 10
of
minutes. You can fast forward through it.
Yeah, I have to make an appearance on someone else's stream for probably like 10
Okay.
minutes. I don't know if you wanted to like stop for today.
I can hear enough for a minute.
Or
I
just
mean, like, if you want to, like, well, I mean, like, I was probably gonna go on like 8 or 8:30, 9 o'clock, so I got a little while still.
Okay, yeah, we can come back to it after a few minutes. I was messaged yesterday during my stream like, "Hey, are you still good for the collab tomorrow?" And I'm like, "I'm sorry, the what?" So
Yeah,
apparently,
which one? What?
Yeah, apparently they meant to like tag me in a different Discord server and then they forgot. And like Fillion has died for the stream purposes, and I have to go give a eulogy. So I picked like 7 p.m. as my time slot, but there's like a couple of other people as well, so I'm not sure exactly like how this is working because I had no idea this was happening. So if you wanna like play with the dog, like get changed into something more comfortable, get food, whatever.
No, I'm good like this.
Okay.
I'm okay.
Kirsche on trial for the murder of Fillion. Oh my god. I was just like, oh god, I gotta write a eulogy. I gotta figure out what's going on here.
You just say he was a good boy. He did nothing wrong.
He was a good boy. He didn't do nothing.
He loved to be. It's like just watch the episode of the first 48. He was an aspiring rapper. He wanted to work on computers.
Fillion always manages to like almost kill herself on her streams normally, and apparently like the other night she ordered DoorDash and like the DoorDash driver stayed at her house for like 2 hours after dropping off her food.
What?
Yeah, I was like
was hanging out with.
No, she was not hanging out with him. It was like creepy hanging out at her house. Oh god, I have to figure out how to chroma key myself.
Yeah. So Exile Sky, you're saying the weight of the mitigation evidence? Yeah, they are trying to use his tism as a defense. They're using everything they can because they don't have a whole lot. So they're gonna say, look, you know, and like it doesn't help because being autistic doesn't mean you don't know any better. So I don't know how they're gonna weave it in there, but they're gonna say, look, he doesn't think like us. I mean, there isn't a whole lot. I mean, you've got to. These guys are kind of using. It's like when you're. It's like if you're playing cards and you get really crappy cards. It's what you have. It's what you have.
Yeah, they're playing a little dirty, as it were.
Yeah, but that's all they can do, and they're they know they're gonna lose, but they're working with what they have.
Yeah. I would be amazed and impressed if they did manage to pull off any kind of like, not just getting the death penalty off, but like if they managed,
acquittal.
Yeah.
Mm-hmm. Yeah, I did see. At one time I did see a death penalty case that got an acquittal.
Oh wow!
And it was pretty. Yeah, and it was like the way they found the bodies and the murder. It was like whoa, and yeah, dude walked out of there with like the one attorney walked out of there with like a not guilty, and I was like, holy shit. But yeah, no, that would be the sad thing is, if that happens, then they're never going to be able to convict anybody for this murder because they pinned everything on it being Bryan Kohberger. And then if they come back and say, "Oh, look, guys, we were actually wrong. It was Bob," you're like, "But you said it was Bryan Kohberger. You told us it was Bryan Kohberger."
It's like, how can we trust you now?
I know we did. Yeah, sorry, we're just government workers. We're a bit tired ourselves.
All right.
We got a little of that tism. It's like, yeah, they're like, this is it. If they don't convict him, it's just like OJ. The real killer will walk free.
Oh, Video Ninja does not want to work correctly. Okay, there we go. I figured it out. I'm nuts. I'm actually just cracked.
Mm-hmm.
Okay, so I've got my little special link here. Everything should be fine. Should be all set for whenever they pull me in.
Somebody saying the autist couldn't help himself. He killed someone, but his compulsions required he did it 4 more times.
It's like, I can't just kill one. There has to be an even number. And then he did a second one, but then like got caught by the third person. He's like, well, I can't just kill 3 now.
Yes, we gotta have even numbers.
Oh my god. No witnesses. Well, he left some of them.
He left a couple of witnesses, so. Yes. Oh, let's see. What are there any questions here? He specialized in assassin when he played Skyrim. Let me see here.
My client could never have done this. Just look at the train schedule.
Yeah.
If he's really autistic, is he going to ask for death by train if they do give him the death penalty?
Yes.
Like, I want to be tied to the tracks, and I want someone to have to do the trolley problem in real life.
That would be the best. That would be the best. Oh my god. Oh. Yes, he washed his hands. Well, that's the thing. He washed his hands. That's the issue. There's so much that doesn't make sense. Like, he took his shoes off. Like, if you believe the state, he killed each one of them, washed his hands in between killing each one of them, didn't leave a trace anywhere, took his shoes off. I mean, there's so much of it that doesn't make any sense.
Very much so.
Yeah, and I'm not saying he's innocent, but I just don't think they can prove this case.
I agree with you. It's like, I don't know if I think he's innocent or not. I just feel like the witnesses had too much weird shit going on. I don't know how I feel about killing 4 people for the first time in that short amount of time when some of the other stuff doesn't really make sense to me.
Oh, I agree.
Oh.
And you know, it's that said though, I'm not gonna let Bryan handle a knife around me. It's like, hey, can I cut the cake? No, I'll take care of that.
Yeah,
Don't worry.
exactly. I am popping over to the other voice chat really quick, so I'll be right back.
All right. So I guess I'll hold down the fort. All right, chat. So you guys know how to build towers, right? Somebody start with the N.
I don't think they'll be able to hear you when I move voice chats because we're in Discord.
Oh. Okay.
I thought I already did, but I guess my computer's lagging. I'm sorry. Hold on a second. I'm trying to find
No, you're fine. I'll just hang out here for a minute.
That's fine. I'm sorry. BRB.
Oh, somebody started with an N.
No!
Already. Well, no, my people can't spell, so it doesn't help.
Hello?
Hello.
Hello.
So we have, hello. Sorry, I'm Lon, and I am Filian's assistant, so I'll be helping get you all set up and stuff.
I have the what link? Oh, okay. Oh, I see. Password. I see the password. Okay, I see it. And then... Okay. Sorry, I've never done Veto Ninja like this. So I'm opening this Discord link, and it's just taking me to the channel. Join the following thing, click here, leaving Discord, okay. Enter password, I can do that. Enter my display name, I can do that. Okay. Join room with camera, I imagine. Okay, allow. Could not start video source. Okay, is it because I have Video Ninja already open, maybe? Let me close that. I'm using VC face. Okay, there we go, it's working. Okay. And you said that audio will be through Discord, so just turn off the audio source here? Okay. Okay. Alright. It should be working. I should be here. Director has me muted.
Okay, thank you.
Sorry, Chad. I muted the desktop audio because I was like, I don't know what she's gonna say, and I don't want to leak things. All right, just in case. Glad you tuned in.
You're all good, Kirsche. All right, Peckies, how is it?
Munya.
Let me see if I can. Oh, my computer is hating me right now. Okay, I am about as ready as I can be.
Hello?
What do you mean goodbye? I thought playing with corpses was fun. I mean, absolutely. The world's most prolific necrophiliac was a woman, after all. So what happened here? I was called last minute. Why is the body moving? Oh. We're thinking it's maggots and not possession? Like, we don't need a priest here to do an exorcism?
I'm very sorry.
Oh, that's unfortunate. So if it is a possession and it's not maggots, we might all be in danger, is what you're saying?
It wasn't in our budget, unfortunately, so.
Well, the good thing is if it's not maggots and it's just possession, now is the time for ethical cannibalism, so we can just divide up the body and roast it in ways we see fit.
Wait, cannibalism even though it's infested with maggots? Isn't that a little worrisome?
No, I said if it's not maggots, right? If it's just a ghost, we can just, yeah. Yeah, if it's maggots, that's dangerous.
Well, it's also extra protein if you think about it.
It is extra protein, but I don't think I'm ready to eat the bugs yet, alright? I'm not that desperate.
That's right. We still have plenty of food on this planet. We're still fine for another couple hundreds of years. I hope so. I believe so.
So I don't see any burn marks on the body, so did she manage to not accidentally die from house fire?
It wasn't a house fire. I can tell you how it happened if you're interested, though.
Oh,
it is
please.
a little sad.
Please give me the quick rundown.
Yeah, well, she was playing around on a ladder, you know, trying to do some really cool stunts involving a ladder, and she started rocking back and forth like a little fussy baby she is, and fortunately she slipped and hit her head, and the ladder collapsed onto her little tiny body.
She flipped too close to the sun, as it were. This is why you don't climb up on top of skyscrapers and try to cannonball into the pool below. This is what happens. She wasn't Russian enough to do that kind of parkour.
Fuck, man, if only she was Russian. Damn it.
If only, that would have saved her.
If only. Well, have you prepared a speech for us today?
I have prepared a small mental aneurysm for today to talk about my wonderful wine niece, Fillion.
Even better. Let's hear it.
I heard that, you know, she might have had a run-in with someone last night as far as a delivery driver goes, and so I was like, maybe she accidentally died because they were trying to get into her house, but she had set so many booby traps for her normal streams that they kept hurting themselves instead, and she had to fight through all of the booby traps. This is what she's known for. Who is going to make VTuber booby traps without Fillion around anymore? We're all suffering a great loss. She could have put so many IEDs in our front yards, and now we have to go trapless. We're going to all suffer for the worst without her ingenuity.
She needed all those booby traps for the lack of her boobie.
I know. It's like a better Home Alone. The President of the United States needs to call and offer his condolences, or else I'm going to riot.
Yes. Sorry, excuse me.
I would like to say I'm going to miss my wine niece very much. I always loved spending time with her. I loved watching her crumple herself into a small millipede of a broken spine and then uncrinkling herself despite the laws of physics. She has given Filipino men such a good reputation in the VTuber community. It's something I never would have been able to think of before. But she did it. And she's a wonderful inspiration to all of us.
That was beautiful.
Thank
She really
you.
was an inspiration.
She really was.
I don't know what she inspired us all to do, but I'm sure it was very, 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 very successful. To be honest, I think she's inspired all of these snackers to be very loud and disrespectful and annoying when people are trying to say their speeches, and I do think she did a great job.
The emote spam shows they care. She would have loved it.
Yeah, she truly would have. As I've been saying throughout this whole funeral, I hear her sometimes laughing. So it
Sometimes
might
we
be
can
the
still hear her
possession, as you
voice.
said.
If she is possessed, I'm sure this will come back in the future as like a follow-up episode.
Oh, wait, that'd be kind of cool, actually.
All right.
Whoa.
We're
Oh, did you hear something? I'm sorry. Whoa. Oh, jeez. There's like noises in my ear. Are you hearing this, or is it actually just me?
It might just be you. I feel like you might be going crazy. You might be getting possessed.
Oh, God.
Is the spirit of
hostess
Fillion
of
trying
the
to speak
funeral?
through you?
Maybe she is. Here, I'm gonna sit still and see if anything happens. I am Fillion and I am gay. Oh my God! It worked.
How
It
gay
worked.
are you?
Hold on. Let me allow her to channel through me again. I have broken the scale with how gay I am. And just looking at you really proves to me how much I love woman and only woman. Amen.
I didn't know you felt that way about me, Fillion. I will suffocate you
love with
again.
you. I'm in love with you. Would you marry me?
I don't know if
And
that's
join me in
legal in
this-
our state. Can you marry your aunt?
I guess the better question is, can you marry a corpse?
I mean, I feel like you can't say no, so it's gotta be legal, right?
Well, heck yeah, let's get married.
That's true, and it doesn't matter if I'm your family, if you're a corpse too. It's gotta be extra legal in that case.
Oh, I didn't even think about the family part. That's the better part.
If we manage to have children, will they be part zombie or part poltergeist?
I'm back. What happened?
Don't worry about it.
Oh, okay.
Don't look
Sure
at the
thing.
legal documents either.
I won't. Did she say anything important at all? Or did she say that she misses her snackers or anything like that?
No, she said that she loves me very much.
Oh, that's so sweet.
It's very
I'm glad you were
sweet.
able to hear her one last time.
I'm also glad. When are you gonna pack your things?
My things? I don't know. I'm just waiting for the sun to set here, and I should be on my merry way.
Oh, 'cause you're gonna live with me now.
Oh, I am?
Yeah, we're married because I'm married to the spirit of Fillion that possesses you.
Oh, okay. I don't certainly mind a very beautiful fox lady. Sure. Sure thing.
You're going to have to submit your mind and body to this marriage in order to please Fillion.
Okay, thank you so very much for coming here. I appreciate you, and I'm sure she did too, for showing up and, having her be able to share her feelings one last time with you. Thank you.
It was a beautiful moment, and I hope everyone remembers her and her wonderful memory forever. I have to go day drink now.
It's Kirsche, right?
It is Kirsche, yeah.
Okay, I needed to know the name of my forever wife from here on out.
It's probably a good idea to know the name of the person you're married to. You don't want to be a bad wife, do you?
Yeah, I didn't want to say it the wrong way and then ruin things between you two. I would have felt very bad.
It's okay, I haven't been lesbian long enough to beat you yet.
Well, things are changing. Life is changing. Thank you. Thank you, Kirsche.
Thank you, and I hope you have a good rest of the funeral. I hope she can rest in peace.
Now, I hope so too. I hope so too. Thank you.
Bye-bye.
Bye-bye.
All right, chat. What? Whatever that was. Just this is so wholesome. Oh my god. Okay, let me go get Sean back, and then let me change back into court clothing. I had to wear the bathing suit for the funeral because it just made more sense. That was fun, I guess. Hello?
Hey, that was very wholesome.
Just VTuber things?
Yes.
All right, let me crank all my volume stuff on my end again because everything was really loud when I joined on the other side. Let me pop out your camera stuff again. We're going here. We're resetting up. I'm closing their Twitch stream. Tragic ladder accident. Yeah, she's dead. Now I want, like, season 2, where Fillion possesses the bodies of other VTubers.
So he was a ladder and an Uber Eats driver. That's an interesting way to go.
Yeah. Yeah, I thought the whole funeral thing was gonna be because of the Uber Eats driver, but fuck me, I guess. All right, I have.
Well, you sold me on that, and then and we hear about the ladders. I'm like, what the hell?
Yeah, I was like, what? Because like the Uber Eats thing is actually something that happened, so I thought this was a whole joke off of that, but you know. Okay, we're going back to here. My gay prison gang fight neo-Nazis. No, that's not what we're looking at. Hold on, I can't find the right tab. Here we go. I have to refresh the page again because it's forever loading. The government works well all the time.
Yes, it does.
It was the Uber Eats driver with a ladder in the VTuber studio. Yeah, I didn't actually have time to write anything, so I was like, fuck, I hope my improv skills save me here. All right, we got this back up, and thank you very much for waiting. I typically feel really bad when I like have to do something in the middle of a stream, so.
Oh, that's all right. That's all right. I understand how it's live TV.
It's live, coming at you from New York City. Okay, I enabled the volume booster again, so hopefully everything is fine now. Let's see.
Yeah.
Hell yeah. Oh, they're different orientation now.
All right.
Oh, my hair is all like sticking out.
You get a little cowlick.
Let's talk about what I hope we
it's over in the
come
things too.
I'm sure if my hair was shorter, I would have cowlicks too.
to an agreement is not an issue.
Oh, my chat brings up a good point. I completely forgot. Hold on, let me put my more appropriate clothing back on. I can't be in court with a bathing suit.
You'd be surprised what people wear to court. They wear all kinds of.
I'm sure I would be. I have a very wonderful Santa in my audience, making me like a proper suit model. So I'm very, very excited for that. But my old model from like 2020 is the more appropriate one for this kind of stuff I have at the moment. Bam. All right, we're chilling out here. Sorry about the changing room.
Let's get
You
back.
got your tie on. It's always appropriate.
Yeah, exactly. You gotta have a nice tie for court. It's all about the appearances, as you said.
Yes.
Is the IGG stuff.
Oh, can you set it up so I can see in?
Oh, in Discord. Sorry.
Yeah.
I'm not.
Saying what's delayed a minute or two.
Yeah, no, that's perfectly fine. I completely forgot. My bad. There you go.
Thank you.
Hiya.
If I may start, and they're battling.
Yeah, I think there are 3 motions. One is the improper expert testimony of Middleman, who's related to the IGG. And that's a defense motion. Defense motion regarding IGG evidence.
Hold on. People in chat are saying there's Discord pings, but it's not mine because I have streamer mode on. Does the government have Discord pings? It's from
That should
me.
be my pings.
I can't be.
No, I don't think it's mine.
Is my streamer mode broken? Let me disable streamer mode. Go into the user settings. I don't know if I can streamer mode turn on. Okay, it's on now. It was on before, so I shouldn't have been getting pings. And I wasn't getting pings earlier. 2 pings. What the hell?
So guys, the IGG, if you don't know what this is, so Bryan Kohberger, they figured out some things with him using genetic testing, and they use.
Oh no, I'm sorry. I went to restart Discord because of the pings. I didn't mean it. He went black. Oh no, they got him. I restarted my Discord. I just completely forgot that that's how we're talking. Kirsche murdered him. They were right about the people not wearing out the whole time! They knew! He's blacked out. Now I gotta wait for Discord to reopen. My computer's so fucking angry with me right now. Okay. She hates him. I'm gonna kill Google Chrome since I don't think I need Chrome for anything right now. Alright, let's see if I can remember everything I need to set up. Hey, hello!
Yeah.
Hi, I forgot. We were talking in Discord and I restarted it because streamer mode wasn't working. I'm sorry. Cut you off mid-sentence, so please, I'm sorry, repeat yourself.
So the IgG is the investigative genetic testing that they're talking about, because part of the way they did their investigation of Bryan Kohberger, they did familial DNA testing.
Huh.
So, and this is something where, yeah, they use like 23andMe. They use their database, and they're like, oh, this person matches him. And we found a match, familial-wise, and then they say, oh, well, it's Bob Boberson, and then they start running through Bob's family tree, and oh, Bob. Did I get lost again?
Nope.
Oh, okay. I just heard the noise. So they say, oh, Bob Boberson, he's got a nephew that lives out in California. Guess where the murder happened? Out in California. So we know, and that's what they use for him. So that's part of what the Kohberger team wants to prevent that from coming in. The genetic testing that they did when they were doing the investigation. So that's what they're talking about with this.
That makes sense. Thank you for explaining that. And I think I have all of the tech issues figured out. I think everything's normal now.
So, all right, let's try it.
Let's heckin' go.
Fingers crossed. Fingers crossed.
And then the state's motion.
Oh, can you put me back in the thing?
I did. That was what the noise you heard was.
No, I know, but the live, like watching it with you.
Yeah, that's what I did, didn't I? It should be. Yeah.
No, you did, but then you had to restart it, and it took it away.
No, it says it's there now, unless it's broken.
Oh. No, hold on, let me... No, I just see... Oh, I see it down there. Watch stream. Okay, I got it.
Yeah, I guess the issue was my Discord decided to break because now I have the updated UI.
Mm-hmm. Yeah.
So...
Yes, good morning. You're right, Your Honor, that we have essentially, I think, an agreement with the state as to their position and our position being equivalent at this point for different reasons. And I believe that the state is willing to proceed without Dr. Middleman, therefore making that motion moot, and that they will proceed with using the generic term or the generic evidence of a tip leading to the identification of Mr. Kohberger. The only issue that we have is how that tip will be presented to the jury. The one thing that the defense is concerned about is exactly the testimony and the witness who will be testifying to the tip. And we want to make sure that nothing that is said by that witness implicates another source. Mm-hmm. And by source, I mean someone like a witness who called with a name or some other way of identifying Mr. Kohberger by name as the possible suspect. The state, in their response to us, said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Kohberger that set them on a train or a trail to charging him was the genetic genealogy. So we just asked...
Well, I don't know if that's a fair statement.
Once again, their arch nemesis.
Investigating him was the investigative genealogy. I don't think that's what led to, the only thing that led to charging him.
I apologize. You're right. It was what they led them to investigate him and ultimately charge him. But I think that the court could issue an order or at least require the state to make a proffer exactly how they're going to do this. The reason I'm here is because I've done a lot of cases with DNA evidence, and the last thing I want is a repeat from a case I tried many years ago, which was a cold hit, where the state simply introduced a quote tip through testimony of a police officer, and the first question the jury asked was, what was that tip? And that is not, we do not want the jury to speculate. It's not our job to tell them how to do that, but I think the court has to be vigilant.
Well, I certainly could anticipate that being an issue in terms of the jury's curiosity, right? Depending upon how compelling or not compelling the other evidence may be viewed by them. And so it may be that you...
There are a few people asking, so what is a cold hit tip?
So the cold hit is just like they send in, you know, it's like a cold hit. They just were like, they put it in the system and they got a hit. But they're trying to show we don't want to use the DNA laundering, so we're like, oh god, that's going to look really bad if they say, oh, DNA, we pinged on it. So that's why they're saying we just have a tip, and we just kind of got like a random tip and we followed it and we ran into Bryan Kohberger. So the state, the prosecutors are agreeing we're trying to avoid using this DNA issue because the way they did this, the whole thing with the DNA is really kind of sketchy. So they're basically trying to avoid this issue because they're just going to say, well, we got a tip and we kind of ran with it.
I mean, I guess also,
So
like,
that's,
where was the tip from specifically that made them go into the genealogy?
I think they ran from what I understood, they ran the genealogy anyway because they had DNA. So that's how that works. So if that makes any sense.
So, like, they found like the genetic material at the scene, and then they ran something on that, and that's how they got him?
and they just said, yeah, can we run this, and is this enough to run? And they ran it, and
Okay.
they hit up Bryan's family, and they're like, oh, and then they started working from there.
I mean, I guess that's a little weird, though, right? Because if they had, like, material to run for a genetic hit, how did they find his family and not specifically him?
Because he didn't do any of the stuff. So, like, if you don't do 23andMe, but your siblings or your parents do, the familial DNA hits are there.
Oh, that makes sense.
So that's been one of the deals of, well, that's been one of the problems there of 23andMe and all these things are people sending their DNA and they're like, oh, you've got a relative here. And they're like, that person's not my relative. And now you're finding out like, uh-oh, apparently mom did, you know, doink the mailman, or, you know, who's really my parents. Like that has been one of the downsides of all of this. Or, you know, dad on his business trips had another family.
Is it a downside if it exposes lies, though? I feel like the downside is them, like, selling their database.
Well, there's a downside to that, too, but also finding out, like, your mom was a hoe might be a downside, too.
Maybe I have a warped perspective because my mom was a hoe.
Want to come up with some instruction to the jury that basically says, you know, we're not going to tell you what that tip is, and you don't need to consider it, or something like that.
Is that an invitation?
It's an invitation for you, two sides, to work together to try to solve this conundrum in a way that you both can live with.
Okay, well, I accept that invitation, and I assume the state also will be willing to do that. I don't know if anybody has any comments.
I mean, we see this sometimes, not in the context of DNA, but we will have, as an example, a probation officer who does a home visit and searches somebody's property without a warrant or other right, because they have that ability on probation, because the defendant will have waived their Fifth Amendment rights as a condition of probation. And sometimes then we want, you know, we'll have to have the probation officer testify in a way that doesn't necessarily tip the jury off that the defendant was on probation, which would be a 404B issue. And I have seen, without some explanation to the jury, when we use those sort of generics or whatever regarded the search, that can cause curiosity with the jury and they can get sidetracked. And so we will frequently use an instruction to the effect of, you know, law enforcement's search of the backpack has been found to be lawful, and you should not consider or concern yourself with that. Okay. Right? And so it's basically telling the jury, don't speculate about this point or how we got to this point. It's not important, and you're not to do it. And I think that generally causes them to back off that.
Oh my
and
God,
so
this
that's
is
what
still
I'm
at 1.3.
suggesting that you try to work through.
Okay, will do. Thank you. That's all I have to say.
I didn't mean to cut you off. If you have
No, that's all I have to say. That was the only concern that was left for us.
All right, thank you.
Judge, I think that fairly states where we are. I was curious what the defense meant in their reply where they said that the testimony about the tip should not falsely suggest other evidence, and I still have no idea what that means. But we are happy to engage in discussion about a jury instruction like the court outlined. I will comment that it seems like it took a long time to come full circle because we're right back where the state started a long time ago with a lot of court effort invested in dealing with hearings in the interim. I appreciate the court's diligence with that. And I think also for the record, there were some pretty serious allegations, ethical allegations made by the defendant in its motion in limine number 11. Those were factually rebutted very clearly in the state's response, and I just want the record to reflect that the state maintains we did nothing ethically wrong with this, but we're satisfied with where we are right now.
I feel kind of weird that they have to specify that they did nothing ethically wrong.
Yes, we've done nothing wrong. You're really adamant about how wrong you're not acting.
It's just like a weird thing to say. I don't know if that's normal.
Yes. No, I mean, when I was a prosecutor, I never felt compelled to be like, Your Honor, we're being good boys. It's like, I never had to tell you that. I just presumed you knew.
Yeah, it's just a weird thing to say.
Oh, it is. It's very true.
Sometimes we litigate issues for purposes other than evidence at trial, right? We do it in terms of constitutionality of searches, and other things, and that's all okay. And I certainly have not made any finding that the state has done anything inappropriate, and so nor have I seen anything to suggest to me that that is the case as of this moment right now, at least, as it relates to that. To me, this is a practical problem, regardless of the reasons you are in agreement. The important part is that you are in agreement. I suspect what the defense is suggesting, I think, trying to read the tea leaves, is they don't want an implication that there was some other evidence related to a tip or specific to Mr. Kohberger that put him on the radar, right? And so I think that's just where you need to come. I don't think for those purposes, we're suggesting that the state can't present its evidence about the suspected car, about the defendant's whereabouts on the night, et cetera. Those are things that were discovered and put together after the fact, right? I think it is important to develop a narrative that doesn't suggest, for example, there's some fact witness who may have heard a confession from the defendant or have witnessed the defendant that led to the tip, right? And so I think it's important how that's presented, and hopefully you can work that out, and if you can't, we'll revisit how to address it.
Yes, Your Honor, I appreciate that. And the state's intent, we've already spoken with the investigators to develop this, is to have probably Detective Payne, who is one of the leaders and the lead investigators, to simply testify that they've received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point. Thank you, sir.
So we have a
logical.
pretrial in next month,
Yes.
and so hopefully you can.
And they're trying to be as clean as they can in this.
And
They're trying to be as clean as they can.
I imagine you would want to, because any sort of like accidental muckying, especially with some of the things that I pointed out that are not so airtight about the case, would make things kind of fall apart a little quickly, I would presume.
Yeah, and there's no reason for them not to do this. It makes it so much easier. We're just gonna be like, we got a tip, and that just, they think they're confident enough we can get him convicted without having to fill in the jury on that story or provide them with part of that story.
And like, yeah, I mean, like when I was figuring out what exactly happened with that tip, if I could come to that conclusion, I feel like most people in a jury probably could be like, oh, there was like blood or whatever at the scene, and they figured out it was him from that.
Yeah, and that's the thing. You won't, like, people will come up with their own conclusions, but those aren't really the critical thing. It's they found him, and it's the issue of or about who else it could have been. So that's really not the biggest problem for Bryan Kohberger right now.
Yeah.
I would argue.
An agreement on how this is going to be handled specifically by that time.
Yes, sir. Thank you.
Anything to respond to, Ms. Barlow?
No, nothing on that.
All right, thank you.
I still can't believe, like, you said everybody talks slow, but even at 1.3 speed, this is crazy.
By my
yeah, I wasn't
score sheet,
joking.
The alternative perpetrator evidence, which is the state's motion to eliminate.
Ooh! Alternative perpetrator.
Yes. So this part of this issue here is Bryan's argument is I didn't do it. Obviously somebody else did it, and the state's trying to argue, well, that's not fair because you can't. You need to show some evidence of who it is.
And they're just going to be like, we have no evidence of it pointing to anybody else, so you can't use that as a defense.
Yeah. Well, and what the other problem is though, instead of saying it's one thing to say, Kirsche did it. I know she did it. She's the real She's a real bad man. Mm-hmm. It's one thing to say somebody specifically is that person, but saying it could have been anybody else and the prosecutors have no idea is generally an acceptable way of saying it because they don't know who else did it and they have no answer for that. They've just pinned all their hopes on Bryan.
True.
So that's the argument that the defense team's going to make.
Interesting.
I just forgot it.
Yes. And I've had this problem before where you try to point out a third party and you get denied.
Oh.
So it does suck if you can't do this.
Yeah, especially if you have like I mean, obviously there wouldn't be robust evidence, but if you have like a decent amount of circumstantial evidence to be like, this person could have done it, it could have been somebody else.
Yeah. But ultimately when you get to but when you get to the point of they can't prove you broke the law, there's times where it's like, okay, clearly either nobody did it, but there's times where it's like, okay, the house was broken into, so someone did it.
Yeah. We have 4 dead bodies. Someone did this.
Yes. Yes. So it helps if you can pin it on an identified person.
Like the other 2 people in the house. Who was that third guy that was on the 911 call? When did he get there? How long was he there?
Yeah.
Actually, a very convenient transition. We're looking at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Kohberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime, and the case law in Idaho says they clearly can't do that.
So for purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without meeting a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, this case is full of alternative perpetrators. There are many alternative perpetrators. That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. Based on the case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crime.
So when he says, like, specifically connects, is he wanting more than just, like, this person was there and they could have done it? Like, they want some sort of, like, there was an alternative weapon, there was an alternative something else?
I mean, they want a little bit more than, oh, they were there. Like, how do you know that they could have been involved? Like, what action can you tie them to with this?
Because
so
like,
it's mainly just trying, because one of the arguments is going to be they're pawning it off on the roommates. But yeah, other than being there, what else do you have tying them to this?
I mean, there would obviously have to be some sort of, like, motive at a minimum to paint, but I'm not sure how much evidence would be needed. And in my mind, if they were going to try and pin it on someone specific, it would either be the two roommates, that random guy that showed up during the 911 call, because, again, we know nothing about him, who he is, how long he was there, when he showed up.
He's probably somebody the roommates know, yeah.
Like, why was he called before the police kind of thing. And then the only other person I could think of, I guess, would be, like, the DoorDash driver, which would be a Hail Mary, like, completely. And then the tarot card lady who tried to blame it on, like, a teacher at the school. But, like, that also seems even more ridiculous than
but
going
she
for the
doesn't
DoorDasher.
live there, though.
Yeah.
So that would rule her out. But yeah, they're trying to basically avoid slapping this on the roommates. And yeah, without anything else, saying they specifically did it is going to be hard. And, you know, they can always, though, get to closing and be like, well, it's obviously someone did it, just not Bryan. And you can kind of wink, wink, and nudge, nudge your way through it. But it helps when you could specifically point to that person and say their name, or if they're there, point at them.
And it's like, I mean, obviously this is a pretrial thing, so we're not going to be given any of the information that the defense has. But it would be crazy to me if they did manage to have some sort of, like, evidence that could implicate another person.
Oh, I'm sure they have something. It's just this, how credible is it, and what's the weight of the evidence? So
Yeah, exactly.
We'll see. We'll see.
Themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof, so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
That's all.
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that it requires the conditions of Meister and that we need to provide that information to you. We are still in the process of doing investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would
be
see
surgical,
that.
like a knife.
We are calculating.
Yeah, exactly. Like, I know we have to wait till August to find out any of the, like, actual meat stuff, but, like, I want to know what they have, man. Like, I'm itching for more info.
Oh, I know. And they're just pointing out, though, there's so much to go through. And it's like, that's their problem. There's just, we don't have enough.
It's a massive case. Like, it feels like not so much because of how much time has passed since it actually happened, but, like, I even remember when it first happened and there was so much speculation around things. People were like, oh, there were ceiling fans in the house, and, like, there were, like, people, someone was hung from the ceiling fan or something. And I did, like, a 3D walkthrough of the house before they took it down from online. There's no ceiling fans in the entire building, so.
Yeah, I mean, but that's part of the issue here is just think about 13,000 pictures.
That's a lot.
Yeah.
And I'm sure
On
some
top
of them,
every other thing
some of them probably only have like a couple of blood splatters, or they're just like, oh, this is like the hallway, even though there's nothing in it.
You got to check them all.
Yeah, you got to like
check them all so you don't know what's there.
You got to go over them with a fine-toothed comb.
Related and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
I don't believe the state has anything further on that point.
All right.
Thank you, Santa.
I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think it's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers and go from there. Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out before we go down that road. And so I will probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial since you're here to take care of that.
Thank you, Your Honor.
So it's not going to get addressed today. It's going to get addressed later, as they have more time to look at it.
The bringing up of the potential of
The
other
third parties.
people, yeah, which
Yeah.
I guess makes sense, and especially as you said, they're doing a second day of this, so. I wonder how much of the runtime.
I don't view Meister as controlling.
I wonder how much of the runtime of this is just like him pausing and taking so long
Dead
to get
air.
through one sentence. the other people, they seem like they're slightly sped up from normal, but this guy, he's got like,
he's so bad he breaks the system.
yeah, it's like the slowest processing speed.
For example, I know this defense has suggested that they believe the evidence suggests that there was more than one perpetrator. From presenting that sort of generic, unknown, unsub, to use the part of the craft involved. This relates more to allegations of somebody more specific, identifiable.
Oh, there we go. He's honing in like me on that.
Yeah.
You know, you could say other people did it, but if you want to say specifically who did it, you need proof.
Need extra evidence of that. And someone in chat brought up a good point, and I can't remember this through going through all of the stuff since this happened. They didn't find any like blood on him or any clothes
Nope.
that had blood on them or anything. Like
They found no DNA evidence on him. His car was dirty, but his car showed no signs of being cleaned. They found no blood in the car. They found no bloody clothes. They found no evidence at all on Bryan, his clothes, or in his car.
And it's like it's very possible that
apartment or
after he left the house, he could have stripped off the bloody clothes, put on a new pair, and then like kept them in a plastic bag and then set them on fire in the woods somewhere, and they wouldn't have known to like look for that because he drove from Idaho to Pennsylvania, so he had a huge stretch of country that he was going through. And that would have saved the car from getting anything in it. But, like, did he have time to do that?
Yeah. Well, that's the thing. Like, there's so much of this that it really strains your ability. It strains credulity.
Yeah.
That he killed these 4 people in 18 minutes. He, would have been covered in blood. And
especially
he got
if you
in his
said
car.
that the scene was incredibly bloody as well. Like, it should have been all over him.
Yeah. And he got into a car and drove off. I mean, this guy is the way everybody on Forensic Files is supposed to act. He left no trace. Except for that one little bit, which is kind of weird. Yeah.
Yeah, and it's like if you were going to take all of this effort to like bring a change of clothes and change into it so you don't even get anything in your car, so you don't have to clean your car, so that wouldn't trace you back to the murder scene, why would you leave because I don't think he left the full knife. I think he just left the hilt of it under one of the bodies. And it's like if you were even wearing gloves to make sure you don't leave fingerprints, then surely you could have like picked up the body and grabbed the sheath of the knife, right?
Yeah, like I said, there's ways that DNA, it's like transfer DNA.
Yeah.
So it's the idea that like I could touch this little jar of paint, I won't leave DNA necessarily, or I might. Mm-hmm. And then if I give this to you and you touch it, my DNA can end up on your hands.
True.
So and then you can deposit that somewhere else that I've never been.
And it's like maybe he knew one of the people in the house and they had like handled his knife or something. Who knows? I mean, it's like there's. Like you said, there's a lot of holes in this that don't make it add up correctly. And so I think that there is a chance that he could potentially get acquitted, but it's still just like they'd have to fight the actual DNA evidence as well.
Mm-hmm. No, it is. That is still the biggest problem. That is still the biggest problem for him, is that DNA being there. But overall, it doesn't make any sense. They couldn't find anything else.
Yeah, I agree.
All right. Let's talk about DNA, which is the inconclusive data, the statistical analysis, and the reference to touch and contact DNA. Let's take up the first two, and then we'll take up the third.
Nice.
I think the first two relate to kind of the same thing to a degree in terms of the science of statistics and probabilities and all that. There are really three issues, as I understand it. One relates to how to convey the statistics that DNA analysts use to more real world comparisons to, for example, planetary population. The second deals with DNA that was found under one of the victim's fingernails and by the DNA analyst as to whether or not Mr. Kohberger could or could not be excluded. And then the third really
I didn't know about
deals
the
with
fingernails.
more sort of this labeling problem that we've already addressed in some fashion in different contexts of what labels should, can, and must we use as it relates to the quote-unquote touch DNA that was found on the knife sheath.
This lady's like, please, finish your sentence.
Thank you. That's a great summary. And I'd like to start with the first, the first point that the court noted, which was motion in limine number 14, which was the relationship of the world population to the statistic generated from the sheath evidence with Q 1.1. And I think we are in agreement that the state is not going to address that kind of question in front of the jury because their own analysts during the grand jury essentially told them that you can't do that given the statistic that we have generated.
I understand the state's response is that they will present the testimony consistent with the way that the witness presented it at grand jury.
Correct, and it was my
Not
understanding.
in the way in which the question was asked that the witness sort of corrected the attorney about.
Correct, and the objection from the defense was simply, and I think the witness explained this very well, was that the statistical analysis that the state's experts have engaged in does not allow that kind of comparison. It's not the standard statistic that we're used to anymore, and so by asking that question, you're triggering, you're conferring, or not conferring, you're speculating essentially, put in front of the jury. It's a question that presents a false premise to the witness. And so we just ask that the state refrain from that and simply ask the questions that elicit, the testimony as laid out in the grand jury proceedings.
Okay.
Excuse me. The inconclusive data, I don't know if the court has seen that late, I apologize, all of a sudden my voice is just
Relatable.
Yes.
Allowed water.
Yes. Awkwardly sip that water.
I don't know if the state,
Bryan,
if the
Bryan's
court
sitting there
has
like,
seen the latest
"Stop!"
filing from the state.
It's swallowing. I can hear you swallow.
So they
I
filed
can hear you swallow in 4 dimensions. You stop it. I got distracted by like this guy up here in the audience.
Yes.
He's got like the Muslim neck beard where it frames his face, but it doesn't have anything on the actual like chin or cheeks. Like I got super distracted.
Oh,
a new expert disclosure on Monday from an expert who went through and analyzed the data at issue. So as
Response to the defense's having retained an expert who discussed whether or not you could exclude Mr. Kohberger from the DNA found under the fingernails.
Yes. And what triggered that was the grand jury testimony where questions were asked of the analyst regarding the meaning of a conclusive versus an inconclusive data result. And the analyst testified as to 13.1, the fingernail swabs, that their data was inconclusive. And to the defense, and that means that you cannot draw any conclusions. So the defense retained cybergenetics, which uses a different statistical tool than the lab here, and generated a statistic which is strongly exclusionary of Mr. Kohberger from that particular sample. And while that doesn't preclude the evidence from the state lab, it adds additional information to the picture, the overall picture, and
It's just a question for the experts to testify about and the jury to make its conclusion.
So she's trying to make the case that the DNA evidence underneath one of the victim's fingernails should be excluded because the statistical analysis showed that it was inconclusive and didn't match Kohberger or his family's DNA.
Yes.
Okay, I just wanted to make sure I
and they're worried they
understood.
could say, yeah, and the argument is, well, because it's inconclusive, that doesn't mean it couldn't be it.
Yeah.
We just couldn't tell for sure. And that's what they're worried about.
Okay.
I think that allowing the type of questions and apparently now the new conclusion that was in the state's response to our motion would be inappropriate and prejudicial and should be excluded under you have to.
Do you want me to believe your expert and not their expert?
No, I'm not asking you to believe any
That's
one
basically what
particular.
she's doing.
However, what I am saying is that the amount of time and energy it will take to explain what inconclusive means is essentially far greater than should be the job of the defense to do. Inconclusive means inconclusive.
We can't hear you, Sar.
No, I'm not saying that. I think it can be presented, and it can be presented in a fair manner that is consistent with due process and the right of Mr. Kohberger to confront it. The new disclosure from the state is an expert who went through in great detail. We have a 27-page report from him where he not only reanalyzed the data visually, but he also used another statistical tool. And he stated in his conclusionary paragraphs, and it's a very long report, that first he looked at the data using the lab's protocols and doing some validation himself, essentially looking at their validation studies, and he found that just visual examination of the data excluded Mr. Kohberger. He went a step further, and he said, I'm going to use this new third tool called LR Mix Studio to generate the same statistic or similar statistic that the lab did, the state lab did, as well as True Allele Cybergenetics did in their analysis. And he came up with a strongly exclusionary statistic. So we have now before the court, as he describes it in his disclosure, a statistic from the state lab, which means that it's 25 times less likely if the DNA originated. I always have a hard time with these numbers because you have to be extremely careful how you you say this because it can flip the meaning. So let me just double check. His statistic, I'm sorry, I'll start with his. It's 5,000 to 100,000 times less probable that a coincidental match would be made to an unrelated person. In other words, what he's saying is that Mr. Kohberger is not included, and that's a strongly exclusionary statistic. And I'm not saying this very well, Your Honor, because these likelihood ratios are hard to explain. So that's a 5,000 to 100,000 times less probable that Mr. Kohberger is present. In other words, it's much more likely someone else is there if there's someone else there.
Wouldn't this
Sounds
be
good.
Yeah, I was gonna say, wouldn't this be something that she should want and not have to get excluded? Because if it's not a match, she could just be like, well, this could be anyone else's DNA, and we have other people in the house. And
and that's the thing. It sounds good, but I think they're worried about trying to go through all of this because people are going to, 100,000 times more like when people start hearing the stats, their eyes glaze over.
Oh yeah, definitely. I'm one of those people. Numbers hurt my brain.
Yeah.
But like, I don't know which of the victims had the DNA under her fingernails, but it's like if it was the one with the boyfriend, it could have been the boyfriend's DNA as well, because it's like they were in bed together when they got murdered. So like, I feel like as the defense, you could make a case for it being somebody else's DNA that's present and not Bryan's, especially if the statistics are so high, even if people's eyes glaze over when numbers are being read.
Yeah.
Then the cybergenetics came up with a number that is in the range of 2.8 billion times less probable that he is there than some other unrelated individual. And this expert then relates that even the state lab's number is 25 times less likely that Mr. Kohberger is there than some other unrelated person. So all of the numbers point to exclusion. The numbers, the question is really the weight of it. And the way that the state intends to present it, and they presented it in their reply to our motion, was they should be allowed to say that this means that Mr. Kohberger cannot be excluded. And that is just a misrepresentation of their own data. None of the data that's presented to this court at this moment in this motion supports that statement or that conclusion. And it's unclear to me who is going to say that, because it's not in any of the disclosures that have been produced so far. The first time we've seen it is in this reply brief. So I think that rather than having a battle of the experts, right, where you're going to have all three of these people testifying before the jury, and to allow that just one question is going to subsume an enormous amount of time in explaining why it's not in it, why it's inaccurate. And while it might be technically true, it's not an accurate statement for the jury.
That's not true.
I mean, like, I get what she's trying to say, and that, like, if we take this to trial, it will take a lot of time to go through and parse. So we might as well just hash it out and figure out if we should even talk about it here. But again, I think it would still be beneficial for her to do this. Like, even with the people's eyes glazing over, because they can use that to their advantage with being like, well, the numbers say that it's more likely someone else that's not him, essentially, like in layman terms.
Yeah, and I understand they just want to get it out. And I mean, it makes sense just trying to exclude it. Because did anybody in chat really understand what all that meant?
I mean, I even needed like a second to have a conversation with you so I could parse through it and explain it. So,
no, it's very good explanation. A very, it's an understanding that makes sense.
Yeah, like I understand why she wants to exclude it, but if it doesn't get excluded, I think it can be used to the defense's benefit.
And they can, but it's just they're like they're better off just making other arguments. I think. Yeah, is what their thought is.
Jury to consider, and it's just going to confuse them. And it's highly prejudicial to Mr. Kohberger. So we would ask the court to, if it's going to allow this in, and we haven't asked to exclude the evidence, we simply asked the preclusion of this kind of questioning, that the state be precluded from inferring or asking a question to elicit some kind of inclusionary statement. I hate these numbers.
Your Honor. So let me just explain a little bit about the state's position. The state has no intention of suggesting to the jury that, oh, maybe this is Mr. Kohberger's DNA. We just don't know. That is not what the state is trying to accomplish. What happened is...
But it is.
Yeah.
The Idaho State Police Lab tested this DNA, and they came up with their likelihood ratio. And that number fell within a buffer zone. And under their policy, that buffer zone, generally speaking, with a likelihood ratio, anything less than 1 suggests exclusion, greater than 1 suggests inclusion. But they had done their own internal validation studies and had found that they were getting some false positives and negatives when you're close to that 1. And the range that they came up with was 0.01 up to 100. And so their policy is, if it falls within that range, 0.01 to 100, we report it as inconclusive. Not just meaning you can't, uninformative. You cannot draw one way or the other, whether it's exclusion or inclusion. And so that's what we had from the Idaho State Police when we went to the grand jury. We thought that it was important. What we were trying to portray to the grand jury was that there was the only DNA that connected Mr. Kohberger to the crime scene was on the knife sheath. But the analyst wasn't willing to just make that general statement because there was this issue, this inconclusive.
I understand it's not the state's position that that DNA is or likely could be Mr. Kohberger's under the fingernails, that it's unknown people from however the victim lived her life in the hours, days before
She a hoe.
event, and
Yeah,
whoever
that's-
was the perpetrator.
However she lived her life is a nice way to put it.
Yeah.
Fingernails didn't contact skin. I assume that's the state's position.
That is exactly correct, Your Honor. The state's theory here is that one would not expect the perpetrator's DNA to be under her fingernails given the eyewitness account of what the perpetrator was wearing, the complete lack of any defensive wounds on this particular victim, the toxicology report. All of that suggests you wouldn't anticipate this to be the perpetrator. And so we have no...
So does that mean the state's
Isn't he making the defense for the defense here then? If he's just like...
No, because they're trying... This is actually... I see what they're getting at. This is going to buttress the argument, oh, he showed up in a hood and had on gloves and he had on, like, all kinds of gear because he didn't leave any marks. So they're just saying, look, ladies and gentlemen, he was that good that he didn't leave any DNA.
He was so good that he didn't leave any DNA, but he left an entire fucking knife sheath.
Yeah. Well, what's that? I mean, that is an argument that they're gonna have to explain that.
It's like, how is he
I don't know
so
if you're
good that he
prepared
did
yet.
this so efficiently, didn't leave any of his DNA, didn't get any of their DNA through 4 stabbings in 18
Yes.
minutes on him,
Mm-hmm.
but was incompetent enough to leave an entire sheath behind? Like, I can't solidify that in my brain.
Yes. No. You are 100% correct. That's where they are right now. That's where they are.
not going to present this evidence in a way that would suggest or argue that it could be Mr. Kohberger's DNA.
Absolutely not, Your Honor. No, and that was part of that rather lengthy, I admit, report that was submitted on Monday was to demonstrate. Yeah, when you know, the other issue to keep in mind is the Idaho State Lab uses a different program than the True Allele program that was used by the defense experts. So the Idaho State Lab pointed us to someone else they were aware of that used the True Allele program and said, why don't you speak with him? We spoke with him, and he came back with the same result, exclusion. Nevertheless, given their policy, the ISP analyst is not willing to say he's excluded because their policy prohibits her. But the plan for the state, to the extent it addresses this, is for all of that information specific to her about the policy, and it fell within the policy, and that's why I'm saying that's what the state would present. And of course, she's open to cross-examination. Of course, the defense can put on theirs that can say, no, we can say he's excluded. The state has no plan or intention to in any way ask questions, imply, or certainly argue that this DNA belonged to the defendant. That, again, we will actually be arguing much different than that you would not anticipate the perpetrator's DNA to be under the fingernails. And so that's where that is coming from with the inconclusive data. On the issue of the statistical analysis, that we agree. I mean, we're not going to ask that question. The only kind of remaining issue we have is I think their motion specifically asked for an order excluding that question or other questions like it. I'm not a big fan of that language because it's just kind of vague and we're not entirely sure what that means. But we'll stay completely away from the population of the world or a country or a city or anything about population. That's all. Thank you.
That seems to make sense.
It does. It does. It's a very rational answer
I would just
to
like
it.
to say, Your Honor, that I guess we're in agreement, and
so then there's nothing else to discuss.
Caution, I
And
might.
pretty much, hopefully this is like her just giving a closing sentence on this part of it.
Yes.
ask
Well, the way she
for
looks like she
position.
started throwing cats at people.
She's gonna use her cat in attack position. It's a Hail Mary.
In order, just that if things change, that the state has to come to the court before even trying to present such evidence.
Why the?
Thank you.
Yeah, I don't
I
understand what she wants.
Yeah.
It sounds like, and I'm not trying to tell either side how to present their evidence, that the state's not intending to present the fingernail evidence as somehow being inculpatory. I could see, based upon cross-examination, et cetera, the defense questioning the lab person in an attempt to maybe attack the credibility of the lab, which then may require the state to put on its rebuttal expert that it's identified as to that issue. But I think we're at this point safe, based on what you've said, that the state does not have a good faith basis to suggest that the DNA, to make an argument that the DNA could be Mr. Kohberger's, that they not do that without first talking to me outside the presence of the jury based upon what the state of the facts on the ground may be at the time. As to how you question with respect to statistical analysis, I guess as guidance, it seems to me the answer that was given to a question that the analyst kind of rejected is probably the way the state ought to approach it, but I'm not going to tell them exactly how they have to ask the question. What I will say is I will make sure I'm aware of the way that it was asked in a way that was concerning, and certainly if a question is asked in a way that is concerning, the defense can object, and I can respond accordingly. All right.
Okay. Next issue. Paper
All right.
That was very anticlimactic.
Yeah, it
Eliminates
was.
Defense 12 regarding the make and model of the suspect vehicle.
Again?
Oh, I'm sorry, did I miss one? Oh, you're right. Within the group I identified before was the touch DNA. I apologize.
Still in DNA.
Yeah.
Your Honor, this is basically a two-part motion. One is to exclude the use of the term touch or terms touch and contact, and the other is to specifically exclude an opinion of Rylene Nolan regarding the sheath DNA and her conclusions as to the how, what I call the how and the sort of when of when the DNA that was determined to be on that sheath, item 1.1. And I'll start with the touch and contact language. Admittedly, that is language that has been used for a number of years in the
Your own expert used it.
Yes, she did. And we would be fine with the court precluding her from using that term. I think what is happened in the world of DNA, having been doing these cases for unfortunately 30 years, is that there's been an evolution. And we laid that out pretty well, I think, in our papers, an evolution of DNA testing, where people started realizing the sensitivity of this methodology allows you to pick up DNA from objects that have no visible stains, like no blood, no saliva, no semen. And that led to the use of the term touch or contact, because the implication and the theory behind it was that people who touch things leave things behind, leave DNA behind. We've now moved into a world where we know that not only can people touch something and leave their DNA behind, but for instance, Mr.
We've learned.
Up here, he was touching the podium. I've now placed my hands on the podium. His DNA is probably on my hands. And when I sit down and pick up my phone later, I could transfer his DNA to my phone.
Sure. But
Nobody's going to
probably also include your DNA too, right?
Of course, but not always.
Maybe. Not always true, yeah.
The problem with the use of
I've had
those
cases where a
terms
guy
is that it essentially
holding a gun all over the place. There were no fingerprints and he didn't wipe the gun down or anything. He dropped it as soon as he got done with it.
Oh, wow.
No DNA, no fingerprints.
How?
Like, it doesn't always automatically work.
That's crazy. I always figured that if you touch something, like, yeah, your fingerprints are gonna be on it, even if they're like scuffed up.
Well, I mean, like, you'd think so, but it all depends. Like, how oily are my fingers? How did it work on the thing? When I grabbed it, did I smear my fingerprints accidentally? But yeah, you're not guaranteed to leave DNA every time you touch something.
Interesting. I always just thought
for the Coomers. Yeah, I mean, there's a lot of times you will. So for the Coomers out there, that doesn't mean you're getting a free pass.
Why the Coomers specifically?
Because they have their DNA all over their hands.
Oh, gross, man. They're going and touching their phones with their DNA too.
They are, yeah.
it essentially allows a conclusion to be presented through a description. And there are many, many, many ways to describe touch or contact DNA. And Ms. Nolan illustrated that in the second disclosure that was produced. And I have copies if the court does not have them. If you would like to review those, I can have them marked. And she goes through her entire discussion of transfer, which is the question here, transfer. How does DNA transfer? And how did it transfer in this case? And she does not use the word touch in describing that process. It's not essential to the description of the process. It's not essential to the explanation of how DNA moves in the environment, because many of the things she's talking about with transfer happen with any biological fluid, not just skin cells. It happens with blood, saliva, etc. So it's essentially allowing the state to prove something, a very important fact in this case, simply by asserting that the term touch DNA is usable or acceptable in the forensic community. We presented at least 3 sources that say, and these are reputable people who are publishing in reputable journals, saying that this type of language is misleading, and it can lead to a misunderstanding of the evidence itself, because touch DNA does not mean now that someone touched something. It simply means that in some mechanism, DNA from a person has gotten to an object, whether that's through direct or indirect contact.
I assume your expert's going to tell the jury all that.
I'm sorry?
I assume your expert's going to tell the jury all that.
Yes, and Ms. Nolan will be telling the jury that as well as she testifies.
So what are we worried about?
What we're worried about is that it's confusing to the lay person to hear an expert use a term that is essentially a description of activity. I'm not very good at grammar, but I believe that's an adverb. And it is not one that is useful for a jury, and it will be misleading because ultimately
we have to assume everyone on the jury are monkeys, and so we can't explain things to them that might have an abstract concept.
The experts will be discussing a much broader source of what we might
Your
call
Honor, just like Bryan, they're
DNA,
retarded, but not
anything
functionally.
that comes from
They're not level 1 retards.
They're level 7 retards.
Yes.
Including saliva or blood. Just because you don't see it just because you can't see a blood stain doesn't mean it's not that stain or that area that is sampled doesn't have some other biological fluid. So it's very misleading. And it's just not necessary. And there's a paper that was presented as a human factors report that was published last year, where the consensus, although there were 2 dissenters, is that analysts should not be using this kind of language and not proffering, and this goes to the next question, not proffering opinions about this, but that the language itself is extremely misleading. There are other ways to talk about it. Ms. Nolan rejects the term trace. That was just one expert's opinion in one article that was cited to the court. But it's very clear she doesn't need to use that term in her description of how DNA moves in the environment. So we would ask the court to prohibit her or any other witness, frankly, from using those terms in describing any DNA sample that's been collected in this case. As far as Ms. Nolan's opinion, again, it goes hand in hand with this idea that touch DNA or the contact DNA is not what it used to be thought of. And there's a number of publications, scientific journals, where the scientists have reviewed vast quantities of scientific literature. I think I counted up over 300 articles in the 2, were reviewed by the 2 articles that were cited in the moving papers that say that there is really no way for a particular analyst in a particular lab to determine how and when DNA was placed on an object when you don't have any facts behind it. In other words, unless you see something or you know something, you have facts of the method of transfer, it's not possible. So first of all, Ms. Nolan is not qualified to offer such an opinion. It's very clear from the growing consensus in the community that transfer in and of itself, how things get places, is a separate expertise which requires separate training. And a DNA analyst working in a laboratory does not have that kind of training. And in fact, it's not really provided in the United States. There is a paradigm in Europe that is being used, but it's not been accepted or used here in the United States at this point, which is the concern from some of the experts who were on the human factors report. But Ms. Nolan is not at all qualified. If you review her CV, which was part of, I think, the first disclosure in December of last year, going through the list of courses that she's attended, none of them are specific to transfer. And in her affidavit that was supplied to the court, she discusses attending some presentations at a recent meeting where there was discussion of transfer, where some unnamed individuals disagree with this idea that it's not something that should be testified to. But I think there's that her presentation, and this is what the court has to consider, the facts presented by the state in support of their opinion, is not supported by anything other than this vague statement, well, some people don't agree with this position. We don't know who those people are. The state and Ms. Nolan have presented no particular scientific articles that support her opinion, and she has presented no specific training to take her from an expert around DNA testing, which no one is suggesting she is not, to an expert on the how and the when of transfer in this particular case. Then, when you look at her opinion, I think the court has to exclude it because it's highly speculative and it's incredibly confusing. She first states that the consensus in the community is that you cannot determine when and how DNA moves onto a particular object. She says that without any qualifications, that the science doesn't support that. She then proceeds to say the DNA on the sheath could have gotten there through indirect transfer, meaning it was not placed there by direct contact of a hand, for instance, with the object. And then she goes on to say, but because of 2 facts, the quantity and the fact there's a single source, I believe it got there through direct contact.
Okay, that does
She
seem kinda
offers
silly.
this court absolutely no
Yeah.
information to support that. She
Other
doesn't.
than those two things.
I'm sorry?
Other than those two things.
Well, yes, those are
Well, that's
two
the point. Yes.
facts.
Other than those two
But
pieces of evidence,
those facts
she has
and the
no ways
meaning
to
of
draw
the
an inference
facts,
other than those two.
are relevant. We cited a number of cases that talk about expert witnesses and speculative opinions. And our position is that this opinion is so speculative and so confusing that it shouldn't be presented to the jury, in great part because Ms. Nolan does not present this court with anything to support her conclusion. She's basically saying the science says I can't do this, but I think I can. If we were in a different place where we had some articles to support her conclusion, if there were articles to support the
It's like
fact
destiny
that
here. Do you
the
have an
amount of
article to
DNA
support
or the
this?
fact that it's a single source sample
peer-reviewed?
is
Oh my God.
probative of that the scientific principles and methods of DNA testing support that, then we'd be in a different place. But that's not where we are. We're here with a naked opinion with no foundational facts to support it, other than Miss Nolan's training and experience.
Don't let it get around
And
a
while
cell
training
phone.
and experience
God.
is a relevant consideration for this court, we don't even know what training and what experience she's relying on. We don't have any indication that the lab has done any studies internally about this question. We don't know what literature she's been reading. And frankly, even though she attended this meeting that was held in February, where the proceedings are online and available, she didn't bother to let the court know who spoke and what they said. So I think the reason is because she doesn't have any support for this. And it's going to be incredibly time-consuming, not only to cross-examine her, but to present evidence to rebut her opinion. And given the speculative nature and the sort of both sides of it nature, I think the court has to exclude it.
I see her reasoning, and I feel like since it's only speculatory, and they have nothing to like specifically point to, yes, he did place that knife there himself, and there's no evidence of that. I don't see why it wouldn't be excluded. She just kind of rambled for a really long time, though. Oh no, you're muted.
That took a long time to get to that point.
Yeah, it did.
I mean, wow. And I mean, I didn't get... This is just ridiculous now, the arguments they're making. And they've made other hearings. They've been on fire. And I'm like, what the hell? I feel like... I was like, wow, this is like... These guys are turds.
Maybe she's trying to like overwhelm him. Like the more I talk, the more he'll take my side. Like I don't know.
Yes. She wants him to start stimming up there. He's
I'll start where she left off. I don't think she's accurately characterizing what the opinion that's been disclosed. Ms. Nolan did not say, I agree that the science says you should not opine on this or that you cannot opine on this. All she says is that the science does say you can't conclusively establish it. But there are factors, she lays out a lot of those factors that you can look at to decide, to indicate how it ended up there. And she's very forthright. She says, look, it's possible that this was secondary transfer, but based on the fact that it's single source and the amount that was transferred, in my opinion, it was primary. I think under the Idaho Supreme Court's test for expert testimony, that passes. She's acknowledging the limitations, and she's giving her opinion, which is going to assist the jury in reaching their conclusion, because the jury's not familiar with any of these factors that she's laying out for them. So, and then as to this idea that she's not qualified, so Ms. Nolan, as disclosed, has been at the ISP lab for 2 decades. She's a forensic scientist. She specializes in biology and DNA. For the last 10 years, she's been the lab manager and overseeing all of the biology and DNA. That includes instructing, as indicated in her CV, law enforcement and others on the collection of DNA. What we're discussing is a critical component of all of that, which is how does DNA get from one place to another? She has plenty of experience to talk about that while admitting that she can't conclusively say one way or the other. But as laid out in the brief, that's never been the test for expert testimony, that you have to be able to say to a scientific certainty that this is in fact the case. Now, on the issue of the touch DNA and just the label itself,
it does seem weird you're going to go through all of this and talk about all of it for all of a sudden to say, oh, well, it doesn't matter here.
Yeah.
Like, it does not make a whole lot of sense there.
And it kind of, again, I think like the lady had a point, even if she took the meandering, rambling road to get to it. And it just, I don't know. His response strikes me as like he knows she has a point, but hopes that how long it took her to get there means the judge is gonna say, I don't care, you know?
Litigated a case where a party has come in and moved to exclude a phrase used by their own expert in their report. And she didn't just use it, she used it specifically in reference to the DNA on the knife sheath, the exact same way that our expert would use it. And now you have an attorney before the court. She used to be an expert in this case, but now she's an attorney saying, well, you shouldn't do that. You shouldn't, even though both the experts in this case use that phrase, the court should step in and say, you're not allowed to use this phrase that's commonly used in your field because it might mislead the jury.
Oh, it's more just like they're assuming, probably correctly, that the jury won't be smart enough to understand what touch transfer actually means. And they'll assume that because they're using the word touch, that means that the person physically touched it, instead of it actually being the person touched something or someone else, and that person touched the other object. Like, I understand the point that they're making because the jury's going to be retards. But like if that's the official terminology of it, like what else are you really supposed to do?
No, it's, I don't know. I think we're going to need to see more of what they're doing here because, and I think it's just because this has been so ridiculous. I feel like it's starting to toast my brain a little bit about how. I'm hoping, it's like they need to come up with a better. I don't know. I think even the prosecutor's like, I'm lost here too.
I've also gotten lost in the weeds because it's like they want to introduce this because they hope that the touch contact is going to put enough doubt in the jury for them to be like, well, it sounds this way, so even though numbers are astronomically high, that doesn't matter because touch contact. And the defense is like, well, that doesn't mean what the jury's going to assume it means, so we don't want that here.
No, and that's, yes. And I agree, and that's the problem. When you start running numbers, once again, jurors, tune out. And they just hear, oh, wow, big numbers must be true.
So this is quite literally just, like, actual lawyer fare instead of, arguing about things that matter.
Correct.
Whatever risk there is of misleading by the phrase touch DNA is easily dealt with on cross-examination. There's a definition that Ms. Nolan provides for that. I assume, though it's not given, that the defense's expert has a definition for that, and they can explain what they mean by that.
If they're experts in the same field and that's supposed to be a professional terminology, wouldn't they be operating on the same definition?
I mean, it depends. Like, you'd think so, but their experts may have, if they're part of different organizations, they may define things differently.
I guess that's
so
fair.
You'd like to think they would, though, but part of being an expert is you're scamming everybody.
That's true.
In your own special way.
Unfortunately.
Yes.
I think it's outside the bounds or intellectual capacity of a juror to understand that sometimes in particular professional fields, there are phrases used that may not mean exactly what they sound like. I think we can expect jurors to understand that and to understand the fuller meaning that's given to it.
I feel like if we could expect people to understand that sometimes when words are used, they don't mean exactly what the person means, then communism wouldn't have been as bad of a problem, actually.
No. Yes, I mean, and that's the funny thing because he's all, if he really believed this, he would never ask for a jury instruction ever again or a limiting instruction if something bad happens. And it's like, no, jurors are stupid. You cannot trust them.
Yeah, exactly.
Sorry, Chad, but yes, we think you're idiots.
I love this judge, too. He's just getting so much more fed up, and there's still like an hour left of this, man.
Yes.
Part of the problem with the defense's motion at this stage is by asking this court to limit not only our expert, but their own expert, they're admitting that there's something there to be cross-examined. And so if this court orders there can be no statement or no mention of touch DNA, then I think that cuts off a very legitimate line of cross-examination from the state.
So I'm not particularly fond in general of proscribing phrases and words that can be used by parties and witnesses in cases. I think it just creates the potential that you're going to have problems because people slip, and particularly when you're using phrases and words that are commonly used within the field, right? We see that all the time with the use of the term victim, right, in cases, and the Supreme Court has recently weighed in on that issue. And there's actually an ICHE instruction that deals with the use of the term victim, because it's just, it's hard to police phraseology. On the other hand, if what we're talking about is an agreement that, this term may be implying something that we all agreed isn't necessarily true in all cases. I mean, we could call it blueberry DNA for all that matters, right? And your experts are going to explain what it means otherwise. What's the concern here if we say, let's try not to call it this? Other than accidental violation, and now somebody's asking for a mistrial, right? I mean, that's one of my concerns.
So in reality, that's really the state's only concern is we don't want to get in a situation where there's a word that's off limit, and because she uses it, the defense expert uses it, it slips out at one point that suddenly we have a motion for a mistrial because there was a violation of this court's order. As defense counsel mentioned, Ms. Nolan didn't rely on this word heavily much at all in her opinion, and I don't anticipate her testimony to be anything different. But if at one point in the back and forth, either with us or with the defense attorney, she slips and says the touch DNA on the knife sheath, I don't think that that's a problem, and I don't think that it's something that this court should restrict. I think both of these experts felt comfortable and wanted to use that phrase. That's why they used it. I don't think it's superfluous. I don't think they just said touch to say touch. I think to them it means something, and it's accurate to use it in this case with respect to the sheath. But certainly the state has no problem encouraging Ms. Nolan to avoid that word to the extent it's possible.
Thank you.
Thanks, Your Honor.
Just a quick response. Language is important. And
language is important. Words mean things. Thank you.
Words mean things, and also, didn't the prosecution just be like, yeah, we can have her not use that word? So isn't the defense getting exactly what they wanted? What kind of rebuttal does she?
Yeah, I would argue they pretty much got what they want. Why are they now arguing for more? No, I agree.
Yeah.
It's like, you got it. You got the thing you wanted done.
You got the thing. Stop talking.
Mm-hmm.
Language in science evolves and changes. Ms. Nolan and Dr. Ballard, our expert, are scientists. They present themselves as experts. Mm-hmm. And I think that scientists should be held to a slightly different standard than the average witness. And the use of language, as this court pointed out to me early on when I first stood up here, is really, really important. And I am confident that Ms. Nolan can restrain herself from using that language, and I'm confident that all of the parties can ask questions that do not elicit that kind of information or use those words, and I would encourage the court to restrict the use of those words for this proceeding.
I mean, like, I agree with her as well. If you're calling somebody who's an expert, you should be able to rely on them being intelligent enough to, like, hey, don't use that word.
Yes.
But I also agree with the prosecution where it's like, if this is terms they're used to using in everyday scenarios, it could just accidentally slip out, and then that gives the defense a gotcha to be like, oh, mistrial. So
at that point, it wouldn't be a mistrial, but the judge may have to do an instruction, or he may let the defense question on that.
Yeah.
But they also point out, like, this is not going to be the end-all, be-all if that were to slip out. There's already enough stuff tying him to this.
Yeah, like, I feel like she should have just taken that W instead of arguing further.
Yeah, well.
As far as Ms. Nolan's opinion, no one is asking for certainty. Nobody expects scientific certainty. That is not our position. The question is it supported by the science that Ms. Nolan is essentially testifying about? And the answer to that is no. Her personal opinion is not science. It is a personal opinion. And if
We're relying on a scientific report to which there were dissenters.
yes, but the dissent was not about the content of the recommendation.
Yes, about
The
that, Your
dissent
Honor, yes.
was, we don't have
What
any
happened
options,
was-
and maybe we shouldn't be requiring trainings that are not particularly available in the United States. That is the nature of the dissent. And
But in support of the idea that his testimony shouldn't be precluded by these people.
I'm sorry, I couldn't.
But in support of the dissent, in support of
Yes.
opposition to a scientific consensus that this testimony should not be presented.
That's correct, but I don't think that the court has to rely on a 100% consensus of the community. I think that the evolving understanding of the science and the scientists in this area and of the people who are actually publishing work is highly relevant to whether or not that kind of opinion is actually acceptable anymore. And I suppose that the question of admissibility might revolve around a more like a Daubert standard. But given that we have not had the opportunity to see these opinions until so recently, that was not something we were able to do.
The Supreme Court has specifically rejected the Dover standard.
Well, I'm new to Idaho laws, Your Honor. That's why I suggest Daubert. But that kind of analysis, I think, is the same type of analysis this
That's
court has
rough.
to do.
Yeah, I was gonna say if she's new to Idaho laws, that's gonna be.
Yeah, well, and guys, the Daubert standard, there's a case, it's a Supreme Court case, and it's the Daubert standard is Daubert versus Dow Pharmaceuticals, and it's the Supreme Court establishing that judges are the gatekeepers of admissible testimony, and that expert testimony has to be on sound principles and methods, not just on their reputation. So, it's all the things that, like in science, that are supposed to be the hallmarks of science. Can you test the theory? Is there a known error rate? All of those things, and that is the standard in a lot of states. But she comes in, it's like, well, I'm, and he's like, that's not the law here in Idaho. So you're like, oof, that is rough.
Yeah, that is a really rough thing to do. I wonder why she's the one presenting the case if she doesn't know the law in Idaho.
Yeah. So they still use factors. They just don't. They don't do. They don't do the Daubert standard there. There's Daubert or Fryer, kind of the two. Those are two big ones, and Idaho doesn't do either of them. So they kind of use their own. They use their own rules of evidence, and the court can do it. The court just does its own information to determine it. You don't have to have formal training, but you must have practical experience or special knowledge. So, you don't necessarily need to have.
I was going to say, I wonder if that's part of the reason that they wanted to try this case in Idaho, because I remember preliminarily they were talking about whether to do it in Pennsylvania, because that's where he's from, or to do it in Idaho, because that's where it took place. And the prosecution pushed for it in Idaho.
I mean, they really wouldn't be able to do it in Pennsylvania because the murders didn't happen there. There were some issues about which county in Idaho to try it in, and this got moved to closer to the state capital. So that was a potential problem, and it looks like things are not faring as well for Bryan, because this is, even though it's a far more populous county, a lot of people here might actually want to convict him. But yeah, so Idaho has its own, and I just, as he was talking about it, I'm Googling how Idaho does it, and Idaho has their own expert rules, which is very unique.
How do their rules deviate from like the Daubert and the other thing you mentioned?
Daubert and Fry, those are two court cases. They say that you can be expert on scientific or technical things, as long as you show knowledge, skill, experience, education, and training. Not necessarily the scientific things of, can you repeat this? Has it been peer reviewed? There's, you just have to show your special knowledge, even if you're not a credentialed expert.
Okay.
So that's very different. That's very different than anywhere else.
Yeah, it sounds like
there are
it.
times where you can become like a lay expert, because you're just a lay person, but this is very interesting. It's very interesting.
It's kind of like self-identifying as an expert, essentially.
Yeah, kind of. It's self-identified.
I am expert gendered.
Yes. Your Honor, I have so much karma and updoots.
Look at my track record of commenting.
Yes.
To make sure the jury is hearing reliable evidence. And I think that if you read closely, in particular, Ms. Nolan's second disclosure, which I believe came out in February, or was given to the court in February, she lays out a whole series of things that affect transfer. She makes one statement about the quantity of DNA being higher with direct transfer, but that's not elucidated in any way, and doesn't talk in anywhere in that disclosure or any other disclosure why a single source profile would support her contention. And I think because of the complex nature of this, that we can't speculate as to why. It may make logical sense, but I'm not sure it makes scientific sense to speculate, which I think is what we are prone to do. And as I think the Idaho courts have said, the court's not supposed to substitute its judgment for the expert's opinion, but to consider it in the context in which it's presented. And here, there is nothing to support her opinion, absent her assertion of training and experience. I'll stop with that.
Right. I'm going to take under advisement the issue of Ms. Nolan's testimony about her conclusion of the likelihood of direct contact of the DNA. As to the use of the term touch DNA, I'm not going to preclude it. As I indicated, I think it's a discretionary matter. There's science in that area uses the term to have a particular meaning. That meaning can be explained to the jury through the experts. In addition, much as the term victim, there's an instruction for. I'm not opposed to giving an instruction to the jury should that term come out, that the court is not intending to, by use of that term or by any of the attorneys' use of that term, making a conclusion. On the other hand, I do encourage the parties to not use the term as much as they can. I think we underestimate the intelligence and reasonableness of jurors, having presided over, well over 100 jury trials. I think that we worry about things that they are more than competent to understand.
I'm gonna have to disagree with the Slowy Gonzalez here. Like I feel like they're probably still overestimating the intelligence of the jury, even with all of this meandering.
Yes, they are. They very much are.
It's crazy to hear a judge say that as well. Like, you should, of all people, know like how brain damaged juries are.
Yes, but he has to say, when I give him an instruction, they follow it because I gave him an instruction. So that is the cope judges have.
I guess so.
A conclusion simply be by the use of a word, particularly where there's scientific testimony around explaining what that word means in context. And so I'm not particularly worried about it. I'm not opposed to some kind of instructions if the parties can agree on one. I would suggest the parties come to an understanding of what a term they should, as a counsel at least, try to use. I'm not going to try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage counsel to try to avoid it as much as possible.
Okay.
All right, now I think we're on the make and model of the suspect vehicle.
I like we get the little hot mic moments.
Your Honor, this is a motion.
Yes.
Where the words do matter. We're following up on that one. This seems
boy.
appropriate.
This judge is like, kill me now.
Motion, we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in Mr. Kohberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case
It very much is.
And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos.
I just hold on. I need to put this back on like regular speed because like I need to see how slow she is.
That's fine. That's fine. Go for it.
And calling them all suspect vehicle number 1. That invades the province of the jury to make that determination. The state has Special Agent Immel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Immel insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number 1. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number 1 has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court
Why didn't they bring this up when they were talking about that original video when he got pulled over?
I don't know. I don't know.
It feels like these would go kind of hand in hand, would they not?
Yeah, I mean, I don't know why they are dressing us now like this, but because, guys, they had hearings already about the videos and some other stuff and the traffic stops. So, yeah, I don't know why this got filed this way, but that's, I'm not sure. I don't have an answer for that, but it is a very good point.
Yeah.
At least it makes sense to me.
Yeah, it would make sense to me to have them together because they're relevant to each other instead of having it split up.
Prohibiting the state from making the reference of this as suspect vehicle 1 to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
Look at that binder, that's thick.
Your Honor, it is our expert.
I'll be right back. Hold on one second.
Identification specialist.
Okay, no problem. I don't know if I should probably BRB and pee as well, because my bladder is full right now. I'll throw in some background music and I'll BRB peeing chat. I'll be right back. Hip. Chad, it's very late in the oh, look at that precarious placement of that heart. It's time to DNA all over the scene. I am, like, impressed at some of these lawyers' ability to just yap. Wonder, do we have another break? Oh, we do have another break. Okay, so there's, like, a big chunk that's, like, taken out here. Okay, so we are actually almost done.
Oh, there's still... I figured the judge was still talking.
Oh, no, I went up and went pee.
Oh.
I was like, it's time to empty my bladder of all this coffee I drank today.
Yes.
I know, it looks like there's gonna be another big break coming up, and then like maybe 30 minutes left after that.
Yeah,
that's pretty
and
nice.
it's just plowing through it.
Yeah, we're plowing.
But like I said, a lot of this is yes. Oh, yes, we are plowing.
I mean, I know this is probably a bit more boring than like a real trial, but I have been.
Yeah, and well, no, I know you're enjoying this, but I know some of you in chat are like, "What is this? Like, this is kind of prepping the field for the trial."
Mm-hmm.
And there have been some better pretrial, like very involved pretrial hearings, but this one's kind of telling you where we're going to be with some of the critical questions and things that are going to get asked. So this is actually pretty important.
Yeah, and like I said, I've been really looking forward to this for like years, and the trial kept getting pushed back. Like they were supposed to have it in like spring last year.
I felt so bad when you asked me about that before. You're like, can we do some Bryan Kohberger stuff like his trial? And I'm like, the trial's not till like the summer of 2025. You're like, oh. I'm like, sorry.
Yeah, I mean, it's not your fault, and there's not too many other cases that I've been following like super closely. The only other one I can think of off the top of my head that I'd be super interested in, and I don't think it's going to go anywhere, is there's that lady who was masturbating on the beach and then went home and apparently killed herself, and it was ruled a suicide. But then, like, her neighbors and everyone were like, actually, her boyfriend killed her. That's why there was blood splatter in multiple different places. And the police were like, oh, that makes sense, but we're not going to reopen the investigation, so tough luck.
I didn't know about that. I didn't know the whole issue about the murder. I just knew she had got caught whacking it. So
yeah, because like when they initially reported it, they had said that like the wound in her head, it like went straight up through her forehead, and I was like, that's kind of odd.
Oh,
that's kind of odd for placement, first of all, and second of all, they were like, there's blood splatter in the living room, there's blood splatter in the bathroom, there's blood splatter in the bedroom. So I was like, if you managed to do that, like, sure, I guess you could wander around in multiple areas, but I think it makes more sense that if she was like struggling with somebody else. And so when it came out several months later, where everyone's like, yeah, we think her boyfriend did this, and we don't even know where he is. He hasn't shown up since that happened. So it strikes me as really odd that the police were just like, yeah, we don't care enough. We're not going to reopen it. Fuck it.
That's impressive. And the cops are like, it's not even worth our fucking time.
Yeah. I mean, I can't remember if it was in Florida or California that this happened, but like, you know, one of those states.
Anthony Weimel, it is his opinion that the suspect vehicle, captured on various surveillance video, shares similar class characteristics to a 2014 to 2015 Hyundai Elantra. He specifically relied on certain video, while some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on logical inferences of review of the surveillance footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information with other testimony and other admitted evidence, and decide if they believe that that vehicle is a 2014-2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Weimel. That's the process, and that's the process that should happen.
The process.
There are no legal grounds to exclude this opinion or to limit it.
The white hats are in control.
Did she need to bring that giant binder up there that time?
Our request is not.
Yeah, they just keep it all together. It's easier that way.
I guess. I just don't remember seeing her bring it up before.
The timely disclosed report.
Agent Imholt, like Aaron's friends? No!
Preventing the state from referring.
Oh, no.
The steel toe law enforcement show.
I hope not. That would be weird.
Sorry, it's a joke. You didn't.
I mean, I recognize the name. I didn't really keep up on all of that stuff, but I know like the swiggin'.
to the vehicle as one vehicle in all of these clips. Agent Immel can talk about the clips, we can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about...
We'll say that this is the same vehicle on each of the clips, that
No.
his expertise?
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
Not actually factually true, as I understand it. It was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Frank's motion to the court was
like,
that
listen,
he
honey, you're not
preferred a
getting it.
2011 to
She's like,
2013
Judge,
Hyundai
like,
Elantra,
honey,
but open
listen.
up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Immel in that email did say expand that year. The change that there's a vehicle, a Hyundai Elantra, that's a 2014 to 2016 came later, and that came after Mr. Kohberger was identified on December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Kohberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
I don't think that's consistent with the facts, but okay. I think the facts are in the email. It was originally, let's look at this date range, and then he said, well, you know, I'm more comfortable with an expanded, or we need to expand the range through 2015, and that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
I'm trying to explain to the court where I'm coming to my request to the court. I was asked what Agent Immel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Immel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude, is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case.
And that's how you can get around some of these. And that is an issue because they, it's not clear. And remember, the FBI is pretty crooked. When did they actually change their identifications? And how do they know? And even if he changed it before they learned about Bryan Kohberger, that's him admitting, wow, I was wrong initially. But this does allow the prosecutor to say, well, various cameras will show the same car. He's not saying which ones or all of them. So this is how the prosecutor can kind of sidestep around what she's trying to do. And ultimately, I don't know what the judge is going to say here, but this is where I'd make the argument of, well, you attack his credibility and show that he doesn't know what the hell he's talking about, I think is what the judge is going to tell her to be the answer here.
And it's kind of similar to the Karen Reed case, isn't it? Where like they keep trying to paint like her vehicle being at these places, and then Turtle Boy was showing like that's actually a different vehicle. Like there's no damage to the taillight on the vehicle that the police have, etc.
I think so, but I don't know if I haven't heard that part from Turtle Boy, but I could see that being an argument being made.
Yeah, I mean that would be a different trial to go down.
Yes.
One, and so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
Right. So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't it? Good.
Yes, it was my motion.
Yeah. I tracked there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle one is making a specific conclusion. It's again using a term that is used within the investigation but specifically making an argument that the various vehicles, or the various images of vehicles on the various surveillance cameras is the same vehicle, making that conclusion is an argument. And so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be, right? As to the agent's ability to make that conclusion, I don't believe that that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about 45, 50 minutes. And
little
then,
lunch break
we'll come
time.
back. Shortly before 1, but no later than 1.
All right.
The whole hour just goes by on this.
Yeah, right.
Eyebrows.
Yeah, but oh, yeah.
No, I was pausing it so you could talk.
Oh, there we go. Oh, no. Go for it. Just hit play.
Just hit play.
This is a defense motion.
DM is considered an eyewitness. And eyewitness testimony is some of, if not the most impactful testimony in a trial. The testimony must be subject to close scrutiny before its admission is allowed. We seek that the use of the descriptor, bushy eyebrows, be excluded from use at trial because the witness with this descriptor is completely uncertain of what she remembers, and her description is derived from seeing the intruder for only a second.
See, I read this in an article, and I agreed with this because I don't think he even has bushy eyebrows. Like, if you look at a picture of him. So her being like, I saw this guy who was wearing a ski mask, but also he had bushy eyebrows, and then Bryan doesn't have that. It's just like, well, lady, what the fuck are you talking about?
Well, and this is where I haven't heard this. Like I said, I'm hearing all these new with you guys. This is still kind of like, okay, well, you can cross-examine her and point out she's a fucking idiot.
Yeah.
That's the court's. That's probably what the court's answer is going to be, because barring her for saying that, well, I mean, would it be, don't you want to, like, I'm not sure. I kind of want to show she's an idiot if I'm the defense.
Exactly. It's just like the thing earlier, I can't even remember what it is now, where I was just like, wouldn't this be something that they could use to their, advantage?
Like suspect vehicle number 1. I could still use that. I say, so you're implying there were other suspect vehicles.
Yeah. Like, there's definitely ways to word this.
You're prepared to acknowledge that there are other suspect vehicles. Yeah, I mean, it's still going to really hurt Bryan. He's still screwed on a lot of... He's still screwed on the big thing about the DNA being there. But, yes, that would be a great way to go forward with it.
Whether this court applies Manson-Biggers, which I would say is not completely right on point because there wasn't a
she
photo
said
lineup
Biggers.
and there wasn't
Yeah,
a show-up, or the court considers the science behind memory. The criteria you must look at is what factors influence the accuracy of the memory and make the testimony reliable, because reliability is the linchpin in determining the admissibility of identification testimony. Between Manson-Biggers and the science of memory, there are several factors that are consistently considered, and I'm going to go through a few of those. Factor 1, what was the opportunity to see? This is also known as first phase of development of memory, or the acquisition phase, and distance, lighting, and duration of exposure are important. DM is uncertain about the lighting. The stairs to her left were not lit. The kitchen may or may not have been lit, and the twinkle lights in the living room may have been lit. She described seeing the person for, quote, only a second, end quote. The person may have been 3 feet from her, or he may have been walking to exit out the back sliding glass door. The back door is further than 3 feet from her door and is not visible from where she was standing.
This was again the person that I was saying wasn't very credible as a witness because they kept changing their story on who they saw in the hallway, where they saw him, how much of him they saw. Like, it was just... It's not reliable at all. And because she kept changing her story so much, I was like, this person has something to do with it, allegedly, right? Like, I can't paint them as someone who is absolutely guilty, but this person changed their story so many times that, like, not only do I feel like they're not credible, but I feel like they had more knowledge about what was going on, and they're trying to not implicate themselves.
Oh, I think it's a very fair statement. Yeah, because it's really hard to... It's... The people in that house are so sus, and that's the problem. It's like all your friends got killed, and a bunch of people think you did it. That's got to be awful.
Yeah. And then, like, their families are just like, we don't want anyone speculating. It's like, well, too fucking bad. Maybe they should be less suspicious.
We don't want anybody speculating. Yeah. Okay. Well, gee. Why are they so sus?
Pictures.
Yeah, make them be less suspicious in that case, you know?
Is our exhibits to show you the vantage point of where she was standing in her bedroom. Her opportunity to see supports unreliability. Factor 2, the witness's degree of attention. This is where amount of alcohol has a significant impact on the analysis. She described herself as, quote, probably very drunk, and given the amount of alcohol she told law enforcement about consuming the entire day, that makes sense. She started with champagne mimosas in the morning, then White Claws 9 to 10 throughout the day. Then that night before she got home, she was involved in a drinking game and drank Borg, which is hard alcohol and flavoring. Her degree of attention, given this, supports unreliability. Factor 3, the accuracy of the description. Her description is that
she's living that Kesha life. And also, if she was that drunk, that makes sense, like, why her stories keep changing. But then also, that makes her incredibly unreliable.
Yes, that destroys all of her credibility. Like, how drunk were you? She's like, so fucking blasted.
And then wouldn't this be better for the defense, right, to not exclude this and just to be able to crucify her on the stand?
Well, that's why I'm thinking that. But once again, I don't know what they know or what's going on there. But yeah, if I was in their situation, I would want to blow her out of the water.
Yeah.
But once again, I'm not these guys, so I'll defer to them. They must know something I don't.
I mean, I guess so. I'm sure there's evidence that, like, both of these teams have that they haven't released publicly, so it can be like a surprise at the trial.
Insanely tall. She doesn't know if she saw lips and nose. She is certain he is white. She never mentions eyebrows herself initially. The person who asked about eyebrows was law enforcement. In her second interview, Detective Mowry asked her if she saw eyebrows. She never said anything about bushy eyebrows. Then in her third interview with Detective Gooch, she said she didn't know what the eyes looked like or the color of the eyebrows.
So you're saying that Detective Gooch has poisoned the witness by suggesting there were bushy eyebrows?
Yes. The good old Gooch get you again.
The Goochman, he can't stop.
Oh,
that's for the first time that she mentioned bushy eyebrows. This lack of accuracy supports unreliability. Factor 4, what is the level of certainty of the witness? In each of the 5 interviews, she says over and over again, she doesn't know if anything she says is accurate because she felt like she was in a dream state, frozen shock, fuzzy and cloudy, like wearing blurry glasses, influenced by alcohol, and sleepy. She has an absolute lack of certainty. This supports unreliability. Factor 5, the science of memory looks to confabulation. When the acquisition of memory, the first factor that I talked about, is impacted by emotion and stress, in this case, that is an important consideration. Confabulation is defined as the creation or substitution of false memories through later suggestions that fill in the gaps of missing memory. DM expresses in each interview how she was afraid and did not know what she was hearing, and also contradicts this when she thought everything was, quote, okay, and XK was simply just passed out on the floor. Later suggestion, under this definition of confabulation, is Detective Mowry asking her about eyebrows and each law enforcement officer, then reinforcing that in each interview. She never used the word balaclava, yet Detective Gooch asked her if she had ever heard of one, explained
God damn it, Mr. Goochman, how can you keep doing this? I'm glad she brought up the, like, switching testimony from, like, oh, my friend was just passed out thing as well, because I brought that up several times.
Oh, yeah, no, there's a lot to this person's testimony, and Chad, I've explained this before to people. Balaclava is the ski mask with just the slot right here. That's a balaclava.
Yeah, it's the baklava, delicious face pastry.
Yes, yes. There's also it's also a battle in the Crimean War, the Battle of Balaclava.
One was, and that it's used to hide identity, showed her a picture of one, and then had her draw one. This is law enforcement filling in the gaps.
Yes.
This also impacts the last factor, which is factor 6, post-event misinformation effect impacting retained information, exposure to subsequent information. Law enforcement, upon initial appearance at the scene, did not ever break up all of the people that were there. They then go to the police station, and after that, on the night of November 13th, those that were at the house when law enforcement arrived stayed together in a hotel room. So DM was basically together with other witnesses from the time that when they first called friends to come to the house, before they called law enforcement, all the way through the night. She was interviewed twice by law enforcement. That created this exposure to bushy eyebrows. And then that term was used in the probable cause affidavit, and the media seized upon it from the very beginning, causing post-event exposure, which affects how DM's memory is retained. This factor supports unreliability. When you look at all of these factors, or the totality of the circumstances, the way the state argues it, the linchpin, the reliability is not there. The state wants to bolster a person who admittedly has no clear memory with a photo of Mr. Kohberger to say, this is the person she identified. DM told police that she looked at Mr. Kohberger's arrest picture and did not recognize him. The state cannot run around her unreliability by entering into evidence a photo to show it's a person that she says she cannot identify, because the state's interpretation is that Mr. Kohberger's photo shows bushy eyebrows. That is misleading to the jury. It will confuse the jury. It will be putting words into the mouth of DM that do not exist. While they might not seek to do that on the stand with her by admitting a photo.
Yeah, I agree. I think asking for this to be excluded is kind of silly on their part. Because, like, you could both nail the witness for being unreliable. You could nail the law enforcement for messing things up. And you can also nail the prosecution for taking it seriously when they should have known that this was a mucked up witness.
Through her testimony off of his phone, if they make the argument in an opening statement that that description of bushy eyebrows is supported by a photo taken on his phone the next day, that kind of prejudice is beyond repair. The state also claims that because DM draws pictures of eyes and eyebrows, she is more reliable in her identification of them. But that is not the way law enforcement appeared to have viewed the artwork as they photographed it and reported on it. Given the science of memory and its acquisition, retention, and retrieval, this could be what is filling in her memory gaps as opposed to actual memory. When you apply the critical factors that a court must take into consideration for eyewitness testimony regarding identification, the words bushy eyebrows should be excluded. The heart of the issue is whether or not the witness is reliable enough on the issue to let the words be spoken to the jury when it comes to the description. DM said that
there's only one way to test the reliability through cross.
Because she doesn't think she saw a face. The court should enter an order excluding the words. Thank you.
I don't know. Clyde has bushy eyebrows.
Yes, he does.
Might be implicated.
No, he's involved with Building 7.
Oh, okay.
Not this.
That makes a lot of sense.
On the Manson-Biggers test. We just went through the 5-factor balancing test for the argument. However, that test is completely inapplicable in this case. Manson-Biggers has to do when there's a law enforcement-led identification process. The concern is that through suggestive techniques by law enforcement, it could lead to or create a misidentification. Well, that didn't happen in this case because it couldn't happen in this case. The male DM saw that night was covered head to toe. The only thing that was uncovered was a portion of his face. That does not lend itself to positively identifying any particular person. Therefore, an identification procedure was not used, and that Manson-Biggers test is inapplicable. Instead, on 4 separate occasions, before Bryan Kohberger was even identified or arrested, DM gave consistent descriptions of the male she saw in the residence that night at around 4 a.m. Every time she described this person as being white, male, wearing all black, a few inches taller than her, she's 5'10", wearing a mask, skinny, athletic, toned build, and not a voice that she recognized. During 3 of those interviews, she then describes the male's eyebrows, and she describes them as being bushy. Obviously, there was some focus on the eyes or the eyebrows by investigators because this is the only portion that she could see. She never wavers in her description of the person that she saw. She's very clear about what she does remember and what she doesn't remember.
I don't think she
put
is.
the state of Mr. Kohberger's eyebrows into question.
Yeah, I don't think she's very clear.
In an attempt to discredit DM's testimony or description, they wrote, Mr. Kohberger does not have bushy eyebrows. But the artwork on DM's walls and the way she draws eyes and eyebrows could be described as bushy, full, or prominent. So in response, the state attached a picture of Mr. Kohberger, and obviously that's a jury question, but it was taken only hours after the homicide, so the closest in time to when DM would have seen the smell. And we did this in order to, when we did apply the Manson-Vickers test, to show that it turned out to be accurate. Corroboration does not equal prejudice. The state doesn't intend to introduce, they're correct. We would not introduce that photograph through DM. We would
And they're
attempt to
correct
introduce that photograph.
about that. This
and
is
plan
pretty
on
prejudicial.
Yeah, it's like,
It's
I don't think they
pretty
should
fucking
allow
important.
the drawings either, so.
Yeah. But they're correct though. They're like, it's prejudicial as shit, but we're proving he committed a murder, so
Yeah.
they're acknowledging that.
So, I mean, maybe because they're acknowledging it, the judge will be like, okay, no bushy eyebrows, but again, I still feel like the defense could use that to their advantage.
Yeah. No, I think so.
proper foundation and relevancy at trial. There's no grounds to exclude this testimony. DM's the only living individual who saw the person responsible for these 4 homicides. Her description of the male, including any characteristics such as bushy eyebrows, is relevant to the identity of the killer. It is prejudicial, but it's not unfair. A jury should hear this evidence, and the state asks that the court rule accordingly.
If it was planted in her by the cop specifically asking about it, like, even if the slot in the balaclava is the only part of his face that she could see, that typically also covers the eyebrows, even like partially.
It depends on how you're wearing it.
Yeah, it depends on how you're wearing it.
I mean,
but for the
he's
cops,
all an autist, so I'm pretty sure he probably all weared it all goofy.
It's very possible. It feels like if they're specifically going to mention the eyebrows, that could potentially put like imagery in her head instead of just being like, well, you know, the mask has this slot. What did you see through the opening in the mask? Like, what parts of his face were you able to see?
Yes. That's why in the future, Chad, if you're ever going to commit a crime, wear a balaclava with someone's face printed on it.
Just wear one of the Richard Nixon masks.
Yeah, like Point Break.
Exactly.
I'll be brief, but I want to circle back to where I started. To say that there's no grounds to exclude this testimony is completely inaccurate because, in fact, there is a large body of case law and a large body of science about
You got some
how
faster
important this
chairs
testimony
spun.
is.
Yeah, I know,
and
she
that's
got
why
up
this
fast.
court must analyze the reliability going through all of the factors that I expressed. And there is not certainty with DM in what she saw. And the court now has, over a variety of motions, all of the transcripts that you can look at to understand the amount of uncertainty that she expressed.
I think someone in chat just called your doggo an orange cat.
An orange cat?
I had to pause for that because I was like, how is this? What, does it look like a cat?
Yeah, where is... He's like part Shih Tzu. He is not a cat.
Hey,
He is a
big
good
doggo. Same energy,
Yeah.
to be honest.
Oh, that yes, he acts like a cat in that regard.
He's big chilling right now, man.
Thank you. I'll take that issue under advisement. Text message, or pardon me, 911 call.
Yes.
This one's so fucked up.
I before they released the actual recording of the call, I had read the transcript in an article, and I was just like, this is messy as fuck. Like, it is so hard to tell what the hell is happening. And then actually listening to the call, like, it's so bad, man. Like, it was better for the 911 operator because in the article, like, just reading the transcript, it made it sound like the operator was much more callous than they actually were.
Oh, it just sounded like they're like, 911, what's your emergency? Doing their nails.
Yeah. Yeah, like, they still sounded, like, really bored and just not great, but it wasn't as bad as just the transcript had led on. But the 911 call's really bad for the surviving girls.
Judge, the state seeks a pretrial ruling that the audio recording of the 911 call and a transcript of that call are an exception to the rule against hearsay. The state submits that the entire 911 call should be admitted pursuant to IRE 8032 as an excited utterance. At 11:49 a.m., BF calls her friend and to come over and check the residence. The friend and a boyfriend show up to the residence.
There were
At
two.
11:56 a.m., BF places a call to 911.
There were a bunch of unknown men came over.
I
wandering
thought
around.
from the 911 call transcript and the recording, I thought it was the 2 surviving girls in the house on the call who kept passing the phone back and forth, and then one guy that they called to come there at some point before they called 911. I didn't know that it was like some woman and her boyfriend that showed up.
Yeah, there were multiple people that were there.
Why
it
would
doesn't
you do
make
that?
any sense.
Why would you do that?
It doesn't make any sense at all. Yeah.
Minutes later. This 911 call was immediately after learning that HJ had something was definitely wrong within the residence, and his instruction that the girl should call 911. The statements were before the declarants knew their friends had been murdered the night before. The requirements of IRE 8032 are met, as this was obviously a startling event, and 2, the statements were made under the stress and excitement that it caused, and that's clear by listening to that audio. The defendant has proposed that their version of the 911 transcript be used, and the state has no objection to that. And I do have a copy of that transcript and the defendant's transcript, if the court would like it. Thank you.
Well, I may ask you some more questions, because it seemed to me from the briefs that the defense focused in on 3 particular parts of the 911 call as not falling within the exceptions. So he didn't address those specifically, but let me see where the defense is at.
Look at that binder.
Yeah.
Your Honor, the best place for me to start is to probably provide you with some copies of the exhibits that we're going to want to talk about. The first set I'm going to hand you was actually filed with the text messages. It's an affidavit of Josiah Roloff, and also, let me give you the extra copy. It has DM's messages broken out in bubble form. That's not all. I gave a whole separate copy for Giovanna. I think that's what I'm supposed to do.
This, to be clear, when we're talking about 911, but you're giving text stuff.
We are. In our response to the state's motion about the 911 call, we referenced the whole copy of text messages. We just filed them with text messages, but they're appropriate here too for the court to consider. I have the additional exhibits that were attached to our response, and they are 1 and 1A. 2 copies. With those in possession of the court, I'll talk about the state's request. The 911 call is made 8 hours after whatever happened in that house happened, after the killings happened, according to the state's theory of the case anyway. The state wants to play for the jury the 911 call and give them a transcript of the 911 call as an excited utterance or a present sense impression. The context of all of what happened that night is captured in DM's text messaging. There's a separate text messaging exhibit for BF. But it's not that all of a sudden at 4 a.m. something starts to happen and then the 8 hours pass and they call their friends and are startled by finding out that their roommates have been killed overnight. There's a lot more that happens during that time, and to analyze whether they're under the influence of a new and startling event, the court should take a look at all of the text messaging, all of the use of Snapchat, all of the use of Instagram that happened. It doesn't start in the middle of the night and then just stop until noon. There is a whole lot more that's going on in that house. When you hear the 911 call and you analyze each of those statements, the only statement that could possibly be a present sense impression is that from HJ. And he really doesn't say a whole lot. The other statements that the state wants to capture in, one is attributed to a person with the initials EA, and that person is repeating what she's been told. She says one of the roommates is passed out. And then a bit later, under prompt from either DM or BF, she says, oh yeah, and they saw a man in their house last night. Those are not things that relate to an exciting event. She's reporting things that other people are telling. She's not somebody who observed any event in the house. If the court takes a look at Exhibit 1 that came with the 911 calls, it's a smaller transcript, and it comes from the grand jury transcript. If the court will look at page 277, that's numbered in the top right corner, lines 16 through 24, EA did not see anybody in that house. She went to the top of the stairs, and went back out, and she saw nothing. She never went back inside that house. Any statement attributed to her cannot be an excited utterance. She's repeating what other people have told her. Similarly, If you look at the grand jury transcript, this is 1A, this relates to DM, and I'm at page 187, lines 12 through 16. DM is not responding to any of the statements she makes on the 911 call to a startling event. She says that for a brief second, she saw XK, but thought she was passed out from the night before. She also wants to talk about what she saw at 4 in the morning, and the dispatcher stops her. Looking at page 190 of that same 1A transcript, DM talks a little bit about that morning when she woke up after whatever happened in the middle of the night happened inside that house, that she reviewed the text messages between her and BF from the night before. She was busy from about 9 o'clock in the morning on her phone. She was on Instagram, she was on Snapchat, she was on Indeed, she was editing pictures sometime in the night as well. This is
Who knows their friends have been murderated and starts like photoshopping images and going to Instagram? That is incredibly suspicious, and I didn't know that she had all that activity.
I mean, it is, but I mean that I guess, you know, when you're trying to find out an answer to all of this, I mean, they're vapid Zoomers. You know, that's probably the only answer that makes sense here. Is they're a bunch of just cancerous Zoomers.
I guess that's
and
fair.
You're gonna have to go, oh, that makes sense.
I guess that's fair. There was a VTuber who had like, I can't remember if it was their sister or someone, but one of their family members, I think a sister, killed themselves, and they like opened their VTubing programs and got on their model and started recording a video like right after it happened and released that video on Twitter. And I was like, that seems like a really fucking weird thing to do. Like, I don't know if I believe that this actually happened, but then it turns out that it did happen. So I was like, oh, I guess Zoomers are just really weird.
I mean, like, that's how you have to look at it, I think, at the end of the day. It's, you know, and part of the issue is, and what jury, you have to be careful, because juries will give people a lot of leeway.
Yeah.
If you do some weird stuff because people are weird, and your friends just got, like, you know, brutally murdered, like, the whole thing is weird. They're, like, you've got to be able to provide an explanation that shows she's lying or something. Because if you just give her the chance, she'll be like, yeah, I'm sorry, I'm an idiot. Or like, I don't know, like, how should I have reacted? So you have to be careful about how you go after her with some of that.
Yeah, for sure. Especially because obviously a surviving victim is going to be more sympathetic than the suspected killer.
Yes.
Not somebody who was asleep and then woke up and was startled. She is actively reviewing things that happened on her phone and communicating with other people. Any statements she made on the 911 call is not the result of a present sense impression. It's not the result of an excited utterance. It is somebody who's been awake and thinking about whatever she and BF talked about the night before and communicating with a lot of other people before that 911 call is made.
I mean, this I can agree with.
The court should not admit the 911 call as an excited utterance, and the court should not admit the transcript for the same reason. But if the court chooses to admit one, having both is cumulative. So it asks the court to exclude the 911 call.
Judge, I think there's a misapplication of the rule as well as the event that is causing the startling event, or the reason that they're startled. State agrees that this is somewhat of a culmination. There was definitely a startling event around 4 in the morning when DM opened her door and sees an unknown person in black in the house. She's not sure what to make of this, but that's obviously a startling event, enough so that she runs downstairs to her friend's bedroom. Yes, a period of time elapses.
She didn't run downstairs to the bedroom. She texted the friend, and the friend said, "You should come down here because it's better if we're together." I'm paraphrasing because I don't remember the exact message.
Yeah, it's something like that. Yeah.
Yeah.
She wakes up the next morning. The next startling event is the fact that when she wakes up the next morning, her friends, she can't hear them. And she's texting them, and that's what her phone records show. She's texting them, giving them time to respond, and they're not responding. So at that point, she had already looked out of her door and changed her story twice by saying she saw someone passed out and then later saw them covered in blood. So like this isn't like an exciting happening. This is like she already knew something was wrong.
Oh no, that's where, and this is where I think just going after her would do them so much more.
Absolutely.
She decides to call
once again,
over
like I said, I don't know
to
what
come
their
and check on the
strategy
residence.
is.
Remembering what
Same,
happened the
I
night
have no
before.
idea.
Now, adding to that she's not hearing the roommates above like she normally would, and they're not responding in the morning like they normally would, then she calls her friend to come over. Then the friend comes over, discovers Santa.
But why would you call the friend? Like, just because your friends aren't responding, that doesn't mean they're not just, like, really asleep, especially if you guys were partying the night before. So why would you call a friend to come and check on the house instead of going out, especially if you have your friend in your room with you? There's two of you.
Yes.
So even if somebody is still in the house, like, it would be 2 against 1. I mean, I guess they could think maybe there's other people in the house still. But then why wouldn't you call the police? Why would you call a friend instead of the cops?
No, that's a very good point. It's a very good point. You know, and
then instructs them something is wrong.
Listen to them picking them off one by one by one.
Yeah. I don't know. Like, he managed to kill these 4 people, and somehow you didn't notice anything at all. I don't know, man.
Wrong. And to the point that they need to call 911. That's truly the startling event here, is the confirmation that all of these things are coming together and that there's an emergency in the house that law enforcement needs to respond to, which is the context of how all of these statements are made.
What's your response to it seems like some of this I need to take bit by bit. And so, for example, EA stating that one of our roommates, or one of the roommates passed out and was drunk last night. She's not waking up. She didn't witness anything.
Well, I think that falls under her presence and suppression of what is happening at that time.
Her hearsay statement of what somebody else told her.
That's
she's
true.
not experiencing anything in that sense other than being there. And I think the case of, my note here, of Bemis is instructive.
Well, I would also argue that for this particular statement, we wouldn't be relying on it for that truth. So therefore, it's just not hearsay. Well, solely just for the context of the entire 911 call, but we wouldn't be asserting that what she was saying is true, that the roommate is passed out and she's not waking up. That's not the purpose, or that my friend's telling me that
but there's a hell of a difference between passed out and stabbed to death.
For the truth. You better have a good answer about what the reason is other than the truth, and I'm not hearing one.
Only that it's part of the substance of the entire 911 call, and that part could be redacted, which still, that doesn't mean that the entire call should be redacted.
I'm addressing them individually. I mean, there may be parts that qualify and there may be parts that don't.
I still argue that the entire call in its entirety.
Well, so here's kind of the way that shakes out. If you offer the tape, you, as an initial matter, can't put in stuff that is hearsay. It's unaccepted hearsay. If they want to put in the context, if it falls under the completion doctrine, they can. If it's the other way around, in the defense first plays the tape, and parts are hearsay are left out, and you want to complete it, you can. But you don't.
So he's saying that if the prosecution introduces the tape, the defense can't provide the text messages from before?
No, they can. They can. Well, they can produce the rest of it because it's the rule of completion. Meaning, let's say there's a video of Bryan Kohberger saying, "Yes, I did it," and they just play that clip. Well, Kohberger's team could then say, "We're going to play the 10 seconds before it and the 10 seconds after it." He's like, "Yes, I did it. I loved drawing this collage and making it."
Yeah.
But they're allowed. It's the rule of completion. They're allowed to give the full context of something.
Okay.
And initially, this witness saying, "Yes, someone told me they're not waking up." It's hearsay because someone else told them something, and it's an out-of-court statement being used to prove the truth of the matter asserted. Mm-hmm. Well, one of the ways you get around that hearsay thing is the rule of completion because, well, now we're showing these people don't know what the hell they're talking about. Mm-hmm. So that's kind of the rub right now for both sides.
Yeah, I just
and he's saying
misheard
they both
it, so
have
I
a
was like,
quandary.
that doesn't seem right to me. But thank you for explaining. I appreciate it.
No. That's that one's a different one because that's you just get to it's like the Simpsons when they keep blowing the space stuff off the book. Mm-hmm. I don't know if you remember that Halloween one where the aliens keep blowing the.
Yeah.
There's more space dust. Yeah, it's just the rule of completion. We get to hear the whole context.
All right, perfect.
To complete with hearsay, your own offered conversation, or I think it applies outside the federal context to recordings and testimony.
Yes, that makes sense to me.
So when you say for the whole context, that sounds like the completion doctrine. which I'm not sure you get to rely upon. Well, I know you don't get to rely upon. And so when you say it's not offered for the truth, I'm not hearing something other than the completion doctrine that you're telling me about.
I think that's fair. I mean, we only have certain exceptions to the rule. If it, I still believe that the entire call in its entirety and under the circumstances that the call was made, the entire call could be considered an excited utterances by all declarants.
Absolutely not.
Also, there's a statement.
Yeah, that would be very
and there's
tough to
also
call
an
the entire
analysis
thing an excited utterance.
Yeah.
That seems to me to even be more removed. Again,
Especially when you point out
statement of hearsay.
this happened how many hours after everybody's been dead.
Yeah.
They're in the blood's congealed. And they've had how much time, and they've looked around at everything. Are you truly excited anymore?
I don't think so. And obviously you can't say for sure anything, but I can't believe that they just stayed holed up in that room the entire time before calling 911. Like they had to have walked around and seen some shit, even if it was after they called their friends.
Oh, hold on. Somebody in chat saying you've never seen the Simpsons episodes.
What?
You watch Simpsons or no?
Yeah, I watch The Simpsons. Yeah, someone said I have no idea who Family Guy is, and I don't know why they would say that. Fucking Mari_en loves fucking Peter, man. And I don't watch movies. Movies are just if you make movie references, I'll never understand what you're talking about.
Somebody else, so you got hearsay within hearsay, and not by somebody who observed that, and relating to the event that happened previously.
That's true.
So what non-truth purposes is that statement?
Again, I would just have to say that the whole call is
that seems
excited.
to me to be even more concerning.
Right.
The first one,
Yes.
my roommates aren't waking up, and we're going to have that confirmed through other evidence. The statement, hearsay, that the roommate saw somebody is perhaps more of a piece of contested evidence.
Agreed.
Concern about being an offer for the truth is even greater there.
Right, and the appropriate remedy, when there's not any grounds for relevancy for this, would be to solely redact those portions of the 911 call, not to exclude the entire call. And based off of the nature of the call and the fact that the phone is passed around multiple times, and it's hard to determine who's speaking at what times. And obviously a lot of emotion in their voice considering what's going on. It's not always
you're admitting
clear to
there's the
understand
problem.
what's being said.
The problem could
She's
also
admitting to the
be-
problem.
Yeah.
We don't know who the hell's speaking half the time.
We don't know who the hell's speaking, and also, because it's been so long since the murders happened, you have no idea if the emotional state that they're in is because of what happened, or because that they are part of it and they're worried about getting found out.
Exactly.
So I think a transcript is a fair way also to convey this and should be allowed with the audio. Nothing further from the state.
Transcript and testimony? In other words, you're essentially admitting the evidence of somebody who transcribed it to say this is what they said. So to me, there's two different questions. One, should the 911 call come in? And second, should I allow, if there is a disagreement, a transcript?
Well, the state has offered to allow the defendant's transcript that they had certified.
The fact that certified doesn't make it otherwise independently admissible. It's hearsay. The transcript part of it.
Well, it's a transcript of the 911 call. I believe that it could be self-authenticating.
How would you you can't self-authenticate that.
Yeah, if it's hearsay, it's not like you're an expert or anything. It's just like you're some chick on.
Well, yeah, but here I'll the self. Hold on, I make sure because Idaho's got some weird rules here. I don't see, because self-authentication, like I mentioned before, it gets documents with seals, and it's clear that they are what they are. Like I said, records from the courthouse, things like that, certain public documents that are signed. official publications, newspapers. So you brought a newspaper, it's self-authenticating. Acknowledged documents, commercial paper like checks and other things like that. I don't see how they could argue that's self-authenticating because it doesn't fall under their rules. And I'm just reading it right now. There's no. This is they're starting to sound like the defense team right now.
Yeah, they're falling apart on this point here, and yes. I hope they're not given it by the judge.
Yeah.
Sufficient standards of reliability built into the transcript.
That may be one.
I don't think that works that way.
Yeah.
Sweetheart.
24 might be a hook.
Sweetie.
You haven't complied with the requirements of 24 at this point, but.
No, but we haven't met our exhibit or witness deadline yet. So obviously we would have to lay the proper foundation for that and would intend to do so. Thank you.
All right, I think I need to take a statement by statement approach to this. I do think that the surviving roommates, surviving victims of the burglary, were under the stress of the immediate events. But there are some questions about some of the other statements in there as to whether they would come in. So I think, in general, much of the 911 tape meets the qualifications, but not all of it.
Would you?
I think there are concerns with some of them, as I've outlined in my questions.
What was that noise? I know it spooked me.
That's from Windows.
Oh, okay.
But I will write that because to give you more particular guidance.
It's not what happens when you plug in a thumb drive.
Okay.
All right, the text messages and testimony.
Thank you, Your Honor. Similar motion by the state asking to bring in the phone records for DM between 2:10 a.m. and 4:37 a.m. on November 13th, as well as related testimony around that same time between DM and BF. Again, the state submits that there are allowable exceptions to the rule against hearsay to allow these statements to come in. I broke those down in my motion and reply and the applicable rules for their introduction. This is a much easier piece of evidence in order to be able to present certain time periods and not put in non-hearsay. It's much easier than an audio recording where we would have to redact. But for the messages that DM sends and the messages that BF responds, I think all of those are allowable under the excited utterance, as well as the present sense impression exceptions to the rule against hearsay. If you have any questions about any specific messages.
Didn't the defense want to introduce that stuff? So are they just trying to get it introduced as like something specific, so it's taken as like a certain?
I'm not 100%. I'm not 100% sure on that one, because I forgot these were a thing. These text messages, but yeah, I actually don't know the answer on that one.
Because it's like the defense was like, if they introduce the 911 call, we should be able to introduce the text messages, and
yes.
The prosecution was like, okay, that makes sense, but they want it to be entered specifically as excitable utterances instead of just regular evidence, I guess?
Well, no, it's the issue is because you have hearsay, because it's other people telling, somebody told the call or something, and that person's then relaying it on, so it becomes hearsay. And excited utterance is a hearsay exemption. So normally, like, you could say, hey, I heard Pippa say, holy shit, what is that? And you could say it was excited and she was surprised. So you could say that in court. Whereas if you said, Pippa said, holy shit, what is that? That doesn't sound like an excited utterance. Therefore, it's hearsay. And if we want to know what Pippa said, we have to bring Pippa in the court instead of you.
Okay, that makes sense. So yeah, I feel like trying to get all of this entered under excited utterances is very silly.
Yes. Well, and the easiest way to think about hearsay is if anytime you're like, oh, well, so-and-so told me blah, that's hearsay.
Yeah, because you weren't
or I heard from somebody.
Yeah.
Yeah.
Well, Your Honor has our exhibits already related to this, and then in the record were BF's phone activity. I don't need to quote extensively from those. there's a lot more to the text messages than the state has provided to the court, and the lot more makes a difference when you put all of these into context. We went through some of those in our briefing, and the court can see that there's even more when the court looks at the exhibit. I understand from the court's previous statement that the court would accept a complete copy of something versus just pieces of it. Well, I could offer
Qualifies
it.
for the completion document. If it's necessary to explain the prior admitted stuff and its close enough connection in time and in subject matter, and so there's some questions there. It's not just automatic.
We certainly would understand that we'd have to present some information or cross-examine witnesses about that. The additional bits of information that are contained in that record around that same time frame, though, provide a much better context when we're talking about other communications with social media, with saving pictures, creating new contacts in one's cell phone right before the texting starts between DM and BF, and then subsequent to that, looking at pictures, editing pictures, calling family members. There's a much bigger picture than just this tiny little piece of texting between the two parties there at night. Further context about these messages the court should be aware that it's not just these messages. There's a lot more activity going on between these two people, and it's hard to tell what it is because there's telephone calls. And those kinds of activities, as well as going down to one another's room, spending the time together, talking to each other, really take it out of an excited utterance because it's an entire transaction between the two people. It's not just a tiny little piece of context with this group of text messaging. And the whole is what matters here. And takes it away from being excited utterances because of the other activities of the two people.
The activities that occur after, so for example, the texts between, at 4:18 or 4:20 or whatever, those aren't affected by the later activities of, surfing Instagram or whatever. And I'll be interested to hear the testimony of the two young ladies because my experience with that age group has shown that where you or I might phone somebody, others might check out their social media to see where they're at or what they're doing, right? And so understanding how they're using those apps is also important.
It is important, and I would refer the court to our affidavit from Mr. Roloff talking about the Snapchat activity, talking about Instagram, and there's a way to tell if somebody's active on Instagram versus just having it open in the background of their phone, and those are things that were going on, as well as editing pictures. The picture editing happened in those overnight hours. Instagram happened later in that morning.
That wouldn't affect the excited utterance and present sense impression of the earlier 4 o'clock text, I guess is my point, because those are afterwards. Those are after they retreated to the room together, and and what happened there.
I can kind of see the point that she's making, but I think I agree with you that it would be better to just roast the witness on the stand instead of trying to get things excluded.
Yes.
Because
I think these witnesses are best to just roast them up.
Yeah.
I don't see what they gain by letting them. And I listen to this one. I really wanted to hear it. I don't see the plan here. But I'm also willing to admit I'm an idiot, so maybe she's got a better idea than I could think of.
Yeah, because it's like even if you want to try and say that the original texts were like excited utterances, the fact that they like went back to like humdrum everyday activity while there were people bleeding out in the hallway kind of makes it seem like a less excited statement in the first place.
I would very much agree with you there.
Mostly I agree. There were things that happened right before. DM created a new contact at 3:51 in the morning.
Before anything happened that was of an excited nature.
If you accept the state's timeline for that, and we don't know that yet.
The foundation that will have to be laid, but that's their version of the time events, and that's then the jury's job to figure that out.
Shortly after the last text message, and I'm talking just minutes, DM and BF are doing different things on their phone that night as they get together that night. There's the period of time that they're together in that room, both before there's a break in activity. There's not really a break in DM's phone. That is pretty well continuous. And there is a break for BF, but it starts again right away. So I understand the court's looking at an isolated part of time, but I think it's important to understand what activity was happening leading up to that and what activity happened immediately after that when the two of them are together downstairs, to put it into context. One of the other concerns is the use of this text messaging, not just through the witness that's testifying, but to bolster each other's testimony or to bring in somebody else's statements through another person. So I think that it's important when the court analyzes if this is really an excited utterance to look at what's being said, as well as to understand the context right before and the context right after, not the next morning, the one's continuous, but right after.
Well, there are several things that I have to look at. One is, first of all, is it hearsay? Is it an assertion, right? So is it offered for the truth of the matter asserted? We get to those two things. Then we look at, is there an exception? For each of those two things, it generally means it's an out-of-court statement. Then it's, unless otherwise definitionally excluded, hearsay. Unless there's an exception, then the exception being the excited utterance.
And that's how this works.
Surrounding events, is it common or current present sense impression? Look at the surrounding events, what's said. Much of it is not assertions necessarily, or I would imagine some of it not offered for the truth, but simply to establish a timeline. And so I'll look at all of those things, but I don't think I can just look at the whole thing in whole and say, well, because they later on were doing things that 19, 20-year-olds do with their phone, doesn't mean that what happened earlier wasn't an excited utterance.
I understand. Our position is that those things that happen immediately thereafter impact the nature of those text messages that occurred between the two.
I mean, I agree with the defense, but this is like, you would do so much better, like, arguing this in the courtroom than trying to get the evidence excluded.
Oh, I think so. I think so. I
it's
don't know
just
why
really
they're giving
weird.
this up.
Yeah.
I don't see why you would give all this opportunity up.
I
Now the
don't-
judge
I
is
don't
not going to
understand
allow it. He's gonna force them to deal with it in court.
Yeah,
so.
I hope so, because I feel like that would be much better for them.
Yes, I think so too.
I definitely want to see these witnesses get cross-examined because they are suspicious.
Well, don't worry, you will.
Item is the demonstrative evidence.
Welcome back, Santa.
Thank you, Your Honor. In our motion regarding demonstrative evidence, we were talking specifically about, for lack of a better phrase, a dollhouse, a not-to-scale construction, a 3D model of the residence itself. And as the court can see from the materials that have been submitted, the configuration of this house is unusual at best. Certainly we can use diagrams and floor plans, which we did at the grand jury, but it struck us as we were looking at this case that it would be particularly helpful for the trial jury to actually be able to see in a 3D sense how everything's laid out, what is on each floor, where the bedrooms are, how the first
Well,
floors.
for it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it in relation to the testimony. And the concept of a demonstrative exhibit is that it's actually part of their testimony.
Yes, Your Honor, that's exactly what I was getting at. What we contemplate is the witnesses being able to use this demonstrative evidence to demonstrate where they were, where the rooms of their roommates were, where the entries to the residence were, what they observed, and where everything was located. So it's not intended as a standalone exhibit that has significance. It's only a tool for the witnesses, not just the roommates, but the responding officers, the officers who investigated the crime scene, to point out to the jury where in this three-story structure certain things were that they observed. And so that is our intent on this. We initially contemplated offering a 2-scale model, and the defense, I think rightfully so, said, okay, well, give us the background information and data that would be relied on, and we requested that, and for whatever reasons, we didn't get it quickly. But as we revisited, we realized that to scale maybe is not what we want. We just want a demonstrative exhibit that witnesses can use, much the same as a sketch, or if they were to take a flip pad and try to draw things, to help illustrate their testimony to the jury. So that's where we ended up here. We look at the balancing test under 403 as far as relevance. We believe this will be helpful to witnesses and explain to the jury and to the jury in understanding witnesses' testimony. As far as prejudicial effect, the state doesn't perceive any significant prejudicial effect. Now, I realize that the expert witness for the defendant talks about jurors misinterpreting angles of view and stuff. Well, that would be true if we were dealing with a 2-scale exhibit. And the defense is welcome to offer their 3D imaging or whatever it is that they want, if they want to have a 2-scale presentation. That's not our intent, though. Our intent is just simply to have
whatever they're going to do.
Help witnesses explain their
I think having that diagram or little scale model would be very helpful as well. And I think the defense could also use that to their advantage because, again, they're trying to claim that this one guy killed 4 other adults in different bedrooms on different floors of the house.
In this big house.
With a weird layout. So I think that would be helpful for everyone.
That would not be intuitive. Yeah, the layout is so weird.
Yeah.
And help the jury understand.
And I think you understand this, but so that, it's clear. If it allowed as a demonstrative exhibit, it's not an exhibit in the sense that it goes to the jury. When they deliberate, it will not go back with them.
Yes, we completely understand that. We intend this to be something in the courtroom that is physical, that the jury can look at and the witness can look at and point to things so the jurors have the most complete understanding of what their testimony is.
I haven't seen it, so I don't know how visible it will be to, you've seen now where we're going to be, how visible it's going to be to the jury from where it would be presented. So I guess we'll, if I allow, we'll have to cross that bridge.
And that's understood. The last communication we had earlier this week, Your Honor, from the folks at the FBI is that it might be finished within the next 10 days. I'll be candid. I had proposed to the FBI, let us get this in front of the court and get a preliminary ruling from the court before you spend the effort to construct it, but they went ahead and started anyway. So
I'd rather the FBI suffer.
Yeah, I would rather them suffer, and also, like, I wish I had been able to see it. I think having, like, a little dollhouse model of the house would have been cool looking, especially since, like I said, I did the, like, 3D walkthrough of the building before they took it offline. So it is a very weirdly laid out house.
Tended, as you can see from State's Exhibit 1 or S1 with the dimensions in there, it's a fairly significant size, 35 by 48 by 52 inches. So the idea of making it big enough so the jurors can see it's out in the floor in the well, and they can actually see how things are constructed and arranged. It can take apart floor by floor so they can see each floor individually and then how they are stacked back together. So that's the purpose, to assist witnesses in explaining their testimony and assist jurors in understanding the testimony.
Your Honor, we request that you exclude the state from using this dollhouse model.
What?
As
I mean, I kind of understand.
Today.
Like, I
mean,
get
I
it
understand
because
it a little bit.
Because, like, the witnesses could be more accurate if they have the dollhouse, but also, I mean, again, like what I said earlier, I think the defense could use it to their advantage as well.
Mm-hmm. I think so, too.
We're
go
talking about Mr. Kohberger's constitutional rights, and we're talking about the rules of evidence. In this case, though, Your Honor, this goes beyond that. This is something that came up in 2023, the fall of 2023. We were disclosed that a group was going to the house before it was torn down to construct a model. We promptly asked in discovery to receive information about this model so that we could start to understand it, so that we could work with our expert with it. And it wasn't until 2025 that we get more information about this. I don't think that calling it a demonstrative exhibit excuses what the state has done here.
True.
The state said they didn't have any of the materials. They didn't come forth with them. Their date to be done with discovery came and went. Their date for their expert disclosures in December came and went.
Demonstrative exhibits and trials are typically not brought to light in terms of being shown until oftentimes during trial itself. I mean, it's no different in some senses, as I'm hearing the argument, of sketching on a diagram on a pad.
It's completely different than sketching a diagram on the pad, Your Honor. This, if somebody's drawing something in open court,
yeah, I don't think
I can see them. Mr. Kohberger's confrontation rights about how that's drawn exist right then and there if they're drawing something on the board.
Oh, okay, bye. Beep,
Uh-oh.
Beep, beep, beep. What just happened? What is this? An ice exchange?
I don't know.
What's going on here?
Yeah, I don't know. I'm a little bummed that this is happening.
I guess this is
What
like
are they all waving about?
I don't know what this is, but I guess it's the end of like the first portion. This is a completely different thing. I don't know what this is. New York Stock Exchange. I don't think we'll do the second half today because it's probably several hours longer.
Well, they haven't done this. Wait, there's... I forgot. Yeah, that's only the first half here.
Yeah, I'm pretty sure it went for like at least 8 hours today, and this was 6 of those 8. But like, yeah, we went pretty fucking late. I'm surprised we got through the entire like first portion of today's. If I'm gonna be completely honest.
Oh, I'm not. I'm used to going these. You could do these for a while. It's not too bad.
I mean, like, I'm very glad I got to do this with you. I know it was a long time coming because I asked like years ago.
I know. I'm happy. This is awesome.
Heck
I enjoyed it.
I mean, I'll get together with you and we'll figure out when to do the next portion of this. We'll see how long it is. We'll see how long the second day of it goes tomorrow. And then we can figure out, like, do we want to just do one long marathon thing on a weekend day or do we want to split it up? We'll see. We'll figure it out.
Yeah. Yeah, we'll definitely work on that. So thank you for having me on.
No, thank you. Thank you for coming.
it.
I'm glad that, like, I'm not as retarded as I thought I would be. It's nice to have you here with, like, your insight and your knowledge on all the court stuff.
No, well, thank you for having me here. I'm glad, and Apparently, your chat seemed to tolerate me, so that worked out well.
They were excited you were here. I know that there were a few super chats that were addressing you. So let me
Get
see.
John on Quine Bobs.
Quine Bobs, yeah. Quine Bobs is one of my favorite games. Let me go to my stream elements and pull things up here just so I can keep you a few minutes longer before I let you go. I just want to make sure.
No, by all means.
Let me see here. Just want to make sure I'm getting the people who addressed you specifically. When did stream start?
Sure.
It's 5 hours ago, 6 hours ago, 1 day ago. Okay. Natasha earlier said, we need Clyde. He brought out Clyde a couple of times. Little cute dog. Sigrun Eterna said, I was not expecting a Kirsche and potentially Sean collab today. Not unwelcome. Remember, if you can, to buy a cup or buy a cup for your cup using code Kirsche for 10% off. My merch is probably not something you would buy, I would imagine. But I have a merch drop at Gamer Subs with like mouse pad, t-shirt, little cup thing. If I sell enough cups specifically, I get my own like flavor of Gamer Subs caffeine powder. So
really?
Yeah,
Nice.
it's a pretty exciting thing. And I have stuff to talk about that after I let Sean go. I don't want to keep him here for that part. Adam Schiff stuff. Torgo the White had said, chat demands proof of Clyde life.
Yes. Well, because we're here in Ohio, so the Haitians may get him at any moment.
Oh, that's true. They are eating the cats and dogs out there.
Yes.
Schmearlies said, too potentially criminal. Rip Jeff from Legal Vices. The Lorax is solely missed. I'm glad I discovered him during the Depp trial, and I got a glass and tumbler from his site as soon as I heard the news months ago. I toasted him with a cigar and whiskey.
Yes, it was losing Jeff is he was known as Legal Vices has been it's been a pretty tough thing for all of us because he was actually like the one guy like that was actually pretty chill and everybody enjoyed. So it really made it difficult when he passed away. And I can't believe it's already been a little while, but it feels like it was yesterday. So. Yeah,
I mean, I didn't know him. I don't know a lot of the like LawTube figures, but I did see a lot of stuff on Twitter talking about him and talking about the tumbler glasses in his honor for after he passed.
Yep. And it's a shame, but it's all about just keep going. That's all you can do.
Yeah, it's like we're all getting older, so I'm sure we're gonna have to deal with a lot more of that as well, unfortunately.
Too. Yes.
And Cult of Personality asked, when is Sean getting a VTuber model? You wanna become an anime person?
Oh gosh, I don't know. I don't know mindset. Like I don't know how he'll react to that if I get a VTuber thing before he does.
I mean, he does a lot of VTuber stuff.
Yeah. I know, but does he have a VTuber model?
I don't think he does
that
yet.
Would be. I don't know if he would. He would be inconsolable.
Wouldn't it light a fire under his ass? Be like, look, man, I became anime before you did. What's your excuse?
Yes. No, I know, but I think he would just be so. God, I mean, he. I don't know what he would do. I don't know what he would do. That would be so funny.
Richard Gruber said, hey, Sean, leaving a dono for the Fox Zoo, catching the replay tomorrow at work. Looking forward to the show tomorrow night. What are you talking about tomorrow night?
Yes. Well, Thursday night's my weekly show. We get to hang out, cover different things. So, what do we got tomorrow night? I got a bunch of things. So there's an update in the Destiny lawsuit with Pixie. Not a huge one, so like people like it's not total orbiter death or anything like that. But we're gonna go over that. The California bar exam, basically, it kind of got ruined because they tried to do it through some digital means, and like half the people taking it couldn't take it. So the state was like, "We're so sorry, we ruined your opportunity to take the bar exam."
Huh.
The Tate brothers are being investigated by the federales, which is kind of funny.
Not surprising, though.
Yes, Russell Brand has got issues in
I saw that.
England.
He's being accused now.
He didn't have a license, mate, to go sexually assault women. You have to be Pakistani to have one of those, apparently.
Yeah, I was like, I'm not surprised, considering, but
yeah. Yes. Then what's the other thing on here I got? Where did I see? Also, there was this video on Twitter where this guy jumped in a boat and started harassing a kid. Like, he was on a bigger fishing boat.
Oh, I saw the video.
Yeah, that guy got charged of burglary because he invaded, like, somebody else's boat.
Really?
So he's facing a bunch of felony charges. Yeah.
Oh, that's interesting.
Yeah, yes, he committed piracy.
Yeah, I was going to say, I could see, like, maybe a piracy thing, but I don't know about burglary, right? Because he boarded a vessel without permission.
Yes.
Man, that's crazy.
But it sounds like it couldn't happen to a nicer guy from watching the video, so
yeah, I
don't feel bad for him.
Yeah, I don't know anything that's going on with the Destiny case either. Like, I saw all of the accusations going out on Twitter. I saw him being like, well, if anything happens to me, I have like 20 other streamers I can take down with me. And I was like, that's a weird thing to say.
No, when I heard that, I'm like, please do it.
Yeah.
Don't threaten me with a good time. Like, you're going to take everyone out?
Like, first of all, please do it. Second of all, why would you say that? Like, you're just letting people know, like, I know all of these streamers who do this sordid shit, but I've been protecting them for personal reasons and to use it as blackmail. Like, that doesn't make you look good.
No, but that's the best part. That's one of the best things of all that happened out of this is just, if I go down, you're all going down. It's like,
give us a show, Mr. Strimmer.
Yes. That'll be great. That'll be great when in the Discovery when he gets deposed. So Destiny, what does that actually mean?
I think that might be a fun one to watch. I don't know. Maybe we can figure out other cases to watch once they go to trial.
Depositions? Oh, those will be great.
Oh boy.
Those I can't wait for. I cannot wait for those.
I have no idea when they'll be, so I guess I can ask you about that.
It's not going to be anytime soon. And we won't get the videos at any point soon, but when they happen, they're going to be great.
Yeah, it's
like, Mr. Bennell, would you agree? Mr. Bennell, would you agree that Destiny is a girl's name?
Oh no. I'm going to assume.
Would you agree Jesse Lee Peterson was right?
I'm going to assume this is for you. Letty said, sending love from Green Gang, Grays keeping walking.
Yes, the Grays, because then you get the memberships here on YouTube. They get green, and their name becomes green.
Oh, that makes sense. Yeah,
we have a race war. We're trying to get rid of the Grays.
Oh, I guess technically we have an expedited race war because like Twitch chat has many colors and YouTube chat only has 2. So the many colors get my attention more than the just 2. And they tickle that autism. It's so many shiny things.
Yeah.
Yorick said, what is this? Sean following mindset and getting a fully rigged VTuber model at 50K. Kirsche, why are you infecting the lawyers with rigging? I mean, I feel like lawyers do a very good job at rigging things all on their own. I'm just giving them the anime.
That's fair. It's fair. No, we do. We handle it on our own.
Solon the Lich said, Sean collab with the Ketchup Fox, Tard Law. Kirsche, you wouldn't NTR your prison inmate boyfriend by writing letters to Mr. Kohberger, would you? If they allow that man to get letters, I feel like we have to write him one, right? Like, we've been involved in his life for 3 years.
Letters. They'll allow him to get letters. You can do it.
Yeah.
You'll be able to pen pal with him.
We can write him a letter together, chat, after he gets convicted.
You could probably write a letter to Daryl Brooks, the guy in Wisconsin who ran over all those people in the parade.
Oh, I don't know if I would want to write to that guy. I don't have anything nice to say to that guy. With this one, I'm interested. How did you want to kill 4 people in an expedited ninja manner? The other guy is just like, yeah, I hate white people and Christmas, so.
Yeah.
Sorry, I'm scrolling through these just to see which ones are related to you.
You're fine.
Feet Sniffer said, I'm so lucky to catch a stream with my favorite silver-haired fox and Kirsche. I will the potentially criminal. Are you used to getting sexually assaulted on your streams?
Yes, routinely.
They're just like, ooh, I want to give him a sponge bath.
Yeah. Well, it's usually not like that. It's usually just very deeply pornographic. So.
Oh, they go into like detail. Better. Oh, okay, all right. Chat, you're more normal. Unhung Hero said, Sean, why are you gay? You are gay.
I say your mom wasn't that good, Unhung. What can I say?
Zachary Rawlick, thank you for the 2. He said, I like this lawyer man.
Well, thank you. I appreciate that.
Oh, it's very kind. Very kind to like a lawyer. Not many people say that.
Yes. Very true. Very true.
All right, I think that's everyone that was specifically addressing you, so I will let you go. You can have some sleepy time.
Yeah, well, thank you. That's very generous of you to let me leave here.
Yeah, you needed my permission to leave.
Yes.
Well, thank you again for coming on, and I will get together with you again soon to figure out when we're going to finish the Kohberger pretrial stuff.
Oh, definitely. It's going to be great, especially as this gets going. But remember, it's not till August. Not till August. We got a long ways to go.
Yeah, I mean, that gives us plenty of time to look at the pretrial stuff. Maybe we'll get more articles. Maybe, some stuff will leak out, We'll see.
Mm-hmm. I will. All right. See you, Kirsche. Have a nice night.
You too. Have a good night. Bye-bye.
Mm-hmm. Bye.
It's over. It's over, chat. We did it. Emperor Creatine, thank you for the 5. If Destiny ever goes on trial, how long will it take for him to accidentally refer to the jury as chat? I give him less than an hour, honestly. I feel like that's a mistake even I would make, right? There's no way I wouldn't accidentally refer to the jury as chat. Okay, let me move this back to normal here. All right, we got big cup. We got big cup action. Less than 5 minutes. I should do more collabs with a lawyer guy and or Papa G. I'm not a lawyer person, so it's not like, right, it's not like when Rakita would do collabs with Sean. We're not like both giant giga lawyer brains. I kicked Sean for the second time tonight. The first time was an accident. But I'm glad that it was a good time. I really, really want to watch this Kohberger stuff. Maybe we can watch other trial things later, but most pre-trial stuff I don't think I would take too much of an interest in, but considering how much I've been following Kohberger, I've been very interested in this. So if you hung around for some less exciting pre-trial stuff with me, thank you. I love this shit. I want to know what's going on with the Kohberger. What percentage is the cup at? I think the percentage is dead, and Binary Mind went to bed, so we can't do anything with that. Do I have moderators here right now? If I have mods, I can bring up the GamerSup stuff. If I don't have mods, it'll have to really wait until tomorrow. No mods, never lucky. Because the GamerSups people did end up, because they gave me the extension, they did end up giving me the gifting page, but I don't know how to make the gifting merch page work well, because you guys will need to communicate with each other. So I'm thinking maybe make a Discord channel for that, because anyone who receives a gift, right, they still have to pay for shipping. So that might preclude some people if they're just oh, well, I could afford the merch but not the shipping with it, so if they got the merch as a gift, then they can afford the shipping. Some people might not be able to afford that at all, right? So I think if anybody was interested, and I know there were some people who were interested in doing gifts for other chatters, which you guys are fucking amazing, honestly. So GamerSups has made that back end thing for us to use, but I think the easiest way to go about doing that would probably be making a Discord channel so that people who want gifted merch and people who are willing to gift merch can collaborate and figure out how to get it done. Because there's also a way for and again, I've never looked at this gifting page before. This is completely new for GamerSups as well. So there could be some bugs, but to my understanding, there's ways to buy something that just kind of sits in the ether, and then anyone can go to the gifting page and claim that ethereal gift. And then there's also ways to be oh, I would like to give my gift specifically to Desert Ghost _117. So apparently you could put that person's Twitch or whatever name in there somehow, and it would specifically be only them that can claim that gift. And then apparently there's time limits on things, and maybe that's just for the ethereal gifts. I don't know. Which is why I wanted to be on stream when explaining this, because it's there's a lot of I don't know what the fuck is going on. Metal Murderer, thank you for the 10, my guy. We know you're not Rakita. Your VTuber doesn't have a 9-year-old child that tests positive for nose candy. It'd be nice if I had the first part of that, but not the second part. since the court stuff stopped, you suddenly have no more headache. Weird. Yeah, you know, those lawyers, they cause headaches, man. They really get at you. Rex Tenors, thank you for the 33 cents. He just bought a cup. Cost you a bit, but it's worth it. Thank you, my guy. Thank you. We have about a week and a day left on my merch because they did give us an extension. So you can buy Kirsche merch. Use like code Kirsche for 10% off until April 18th. No longer ends on the 11th. You have until the 18th. I saw someone comment. I can't remember if it was on my Twitter or on a YouTube video, but someone was like, I asked my mom for payment to get a cup because I wouldn't get paid until after the 11th and it was for nothing. I could have just waited, but there was no guarantee I would have gotten an extension. So it's like, you know, it's your mom might know that you have embarrassing Foxwoman merch now, but that's okay. Your mom accepts you for who you are. You bought a cup and a mousepad thing with my code. You're glad to get the beautiful artwork. They, again, Gidraji and Nightfang both did a bang up fucking job. Super fucking happy with both of their work. Speedy Cake, thank you for the 10. We should sponsor a Foxu Cup sweepstakes or something. I mean, it's possible. We'll have to see. We'll have to see what people can and can't do. Because like I would feel bad if someone's like I would love to, you know, get gifted a cup or a mouse pad because I can't afford it, but then like someone gifts it to them and they find out, oh fuck, I'm stuck with like $50 worth of shipping. I also can't afford that, right? Like I don't know how that works. I've never seen this gifting thing in action. Asking mother implies an underage viewer. No. Doesn't imply an underage viewer. It just implies that like, oh, I'm not getting paid until after the 11th. Could I have like an advance and I'll pay you back when I get paid? I've done that with my dad before as well. I'm just like, hey dad, I can't afford thing. Can you shoot me the money and then I'll pay you back after? Munya. Arbuelo, thank you for the 10-month resub, my dude. Thank you. Marine's Blood, thank you for the 5. A 911 dispatcher hosted a podcast and did a breakdown of the call if you're interested. They gave some good insight on it and calls in general. I mean, maybe. It depends on how long that is, right? Because like I feel like I have a pretty decent idea of it, and like Sean and I discussed it several times as well. He's not a 911 dispatcher, but like I feel like we're both pretty intelligent people. Jimothy Stickle Pasty, thank you for the 199. It's scavenger hunt season. What did he mean by this? What did he mean by this? Chip ISO, thank you for the 25. You started wailing for someone else so they'd stay manly, no dresses. You got them doing Batsu shit to toughen them up. Thanks for the ideas with Queen Snake and Genki Genki. But if the audio got on stream from such sites, would they get... Yeah, don't play fucking pornography on stream. What are you, high? What the fuck? How is that even a question? Uxinite, thank you for the 10. Colorado's trying to pass a bill that would effectively portion parents to affirm their child's gender. The bill is trying to be pushed under the rug, and they brought the bill to the floor in the State House on a Sunday. It's really scummy. Look it up. Colorado, what the fuck are you doing? The fuck's happening in Colorado, man? What's going on there? Mikado, thank you for the 10-month tier 3 resub. Thank you. VOD watcher mostly. You do not like the outside world. Can I go back? No. I'll pay the ticket in with the placenta bread. That's not how that works. You cannot put Babby back in womb. According to averages, it'll take 397 years to go on attendees date as a tier 3. You bought the cup and desk mat from Kirsche and other stuff from another import, so you know you'll have to pay 109% tax on it. You're glowing, as we say here. I can't scroll because Stream Elements is a shitty website. And 2/3 of the price pre-tax you paid with shipping. Thanks, GamerSups. Congrats on the marriage with the niece. Yeah, she's my favorite inbred lesbian couple woman. Colorado's becoming more and more of a shithole. I'm noticing that all of these states that happen to have preemptively made weed legal also make really bad choices alongside of it. Why can't people just be normal? Jimothy Stickle Pasty, thank you for the 199. What did I mean by this? That's... Only you can know. I know. Emperor Creatine, thank you for the 5. If Destiny ever goes on trial, how long will it take for him to accidentally refer to the jury as chat? I remember reading that. Thank you. Thank you. Andrew Grant, thank you for the member. Thank you for the member. Three-legged table, thank you for the 5. Based suspenders enjoyer, great coverage, both of you. Thank you. It was a lot of fun. That was my first collab with Sean. Like he said, I contacted him like either end of 2022 or like beginning of 23, and I was like, hey, I'm not a lawyer, but I'm really interested in this trial. Oh, we should watch it together. And he's like, I feel bad because I know it's not going to happen for like years. But here we are. We finally made it. The final stretch, man. August is the trial. Video gamer, thank you for the 225. Buy Foxu Cups. Thanks for covering this insanity. I am enamored with this trial. It's like my own personal A&E show. High Anxiety Media, thank you for the 4-month resub. Thank you. Thank you for being awesome. You keep me entertained while in the hospital with your papa. Oh no. I hope either you or your papa, whichever one is the actual patient, get better soon, man. Hope you get better soon. I'm sorry to hear that you're having to deal with that. Book of Grudges, thank you for the 5. Why does Santa sound like he's about to burst into tears? I think the player might have fucked up at one point, and even though it told me it was on 1.3 times speed, it might not have been. I'm not sure, but it certainly was like, man, these people talk so slow. I was like, holy shit. Collab has been marinating for a good while. It has been marinating. Psycho, thank you for the 2. You're as tarded as my woman. Gonna game. I have the brain damage. Ducky, I hate Twitch TOS. Thank you for the gift sub to Ya Honor, I'm sorry. Thank you, Ducky. I also hate Twitch TOS. Cinder Sins, thank you for the 5 gift subs, my guy. Thank you. Stack of Parts, thank you for the 20. How many women on his legal team? He's dead. Yeah, the defense was not making me feel like they're gonna do that great of a job, but like, we'll see. Maybe this is part of the plan, right? They just act incompetent in the pre-trial to put the persecution, like, I don't know why I keep saying persecution instead of prosecution. They like put them off their guard. They're just like, oh, this is gonna be easy in the bag, these dumb shit women. And then they come out on the trial and like, surprise, we were acting retarded. I was only pretending. Flatfoot Red, thank you for the proom. Thank you for prooming. Abra fucking Cadabra, thank you for the 5. Just post a blurry picture of a taillight of a vehicle on Reddit, and they'll ID the vehicle in under 2 minutes. Yeah, that was what Sean said he didn't know when I was talking about the Karen Reed trial. So, like, one of the big things that Turtle Boy was talking about for the longest time was the fact that Karen Reed's vehicle didn't have any damage to the taillight, that the police were claiming had damage to it from backing into something. I can't remember what she had backed into, or like what they were claiming she had backed into, but the photos of the vehicle that the police had did not match the photos of her actual vehicle. And then there was also some like fucky-wucky shit when they brought it into the garage for impounding or something. Again, I haven't been like super keeping up with the Karen Reed stuff because there's a lot of it and my brain can only handle so much thick information at one time. But I'm sure I will want to go check in on Turtle Boy soon. I wanted to a couple of weeks ago, but like, this is something I've been grappling with. First there was the issue of like, I love tangenting, and I couldn't figure out how to like split my time well between just yapping and playing video games. But now I have so many tabs every day that I just never get to go through. So they keep bulging at the seams. There's so much I want to talk about and so little time. I'm like weeks behind in even like bridge coverage for shit as well. Fuck, man. And like I feel also like, since I'm the only one talking about bridge, I have an obligation to be the one putting out that information. Not that I don't like doing it. I enjoy doing it, but I hate feeling like I get behind and I'm not disseminating info fast enough, and then there's like so many other things to talk about, and if I do too much bridge stuff all at once, it's so much like corporate gobbledygook that all of us have our eyes glaze over. It's hard, man. It's hard to figure this shit out. Emperor Kriti, thank you for the 5. By the way, did I see how Trump has put in a 90-day pause on the tariffs except for China? Yes, we talked about it at the beginning of the collab as well, and maybe someone can make me feel better. I had initially planned on like buying stocks on Tuesday morning, but then I didn't wake up because like I tried doing it Monday night and I was like, oh, the stock market has a closing time. And so I was gonna do it Tuesday, but once I start stream, I'm not gonna buy stocks on stream. I don't know what the fuck I'm doing. And obviously I woke up too late today to do it as well. So like, I don't know if I missed the dip window and I'm just like fucked now and I have to like wait until there's another dip, or like, I don't know, man. I don't know, man. Revisit in 89 days. Definitely would not buy now. Yeah, I think I might have fucked myself, but it's like, it's not too big of a loss since I wasn't already in there. And again, I have no idea what I'm doing, so I was like, whatever, man. Please don't try buying individual stocks, especially starting out. Stick to ETFs. I don't know what that means. I wanted to, like, I don't know, try buying like Nvidia and Tesla, but Tesla's like fucking expensive, man. Tesla shares are fucking crazy. They'll panic in another week or two. Yeah, I guess I gotta wait for another panic dip. I guess I gotta wait for that if it's already fucking shot up. Fuck you, Red Square. We had a little one. Little baby Red Square. Bad Kitty on X would be a great collab. I don't know who that is. I don't know who that is. Mutual funds are good. I don't know what that is. Buy AMD. I don't know. Feared Goblin, thank you for the 19-month resub, my guy. Thank you. Thank you. It's Ev, thank you for the $4.99. Your Honor, I depicted my client as the Chad and the accuser as the Soy Jack. Clearly, I am in the right, Your Honor. That's true. You can't argue with that kind of defense. Do I have my funds approved in my brokerage account? I don't know what that means. I don't know what that... I mean, I put money dollars in the account and I got an email that said thumbs up, so I assume that's what that means. And gold silver mining stocks might be a good bet. I don't know what that means either. You don't know much, but there's some places like Stash that will let you buy % of stocks. Yeah, I have no idea what I'm doing, so like, you know. Disavowed Agent, thank you for the 5. Get Richard Gere to sing Razzle Dazzle and do a tap dance. Hell, it would be more streamlined than the ladies explaining. Man, when I woke up today, I hope nothing bad is happening to my insides again. Because you guys know that I had like several months where I just could not stop fucking vomiting. And like my one thing was I was like burping this like really disgusting flavor that like, I don't know how to explain it other than like it just tastes like my insides are rotting. Like it's bad and it doesn't reflect anything I've eaten. And today I haven't eaten. I've had coffee and I've had like 33 ounces of water. And because of the mold, I don't know, maybe rotten. No, they're not sulfur burps. They're not sulfur burps. They're not the egg flavor. They're like really, really, I almost gag and vomit because of like, it just tastes so bad and I don't know what it is. But, like, that went away. I've been basically, like, recovering for, you know, about a month and a half now. I haven't had that many issues. Like, my shoulder's been my biggest issue, but I'm on medication for that. And today I woke up really needing to pee. And, like, my bladder was so fucking full, it was, like, giving me abdominal cramps. So I, like, got out of bed. And maybe I got out of bed too fast. I don't know. But I, like, went to the bathroom. And I got, like, so... Like, my body felt limp and heavy at the same time. Sort of like when I start, like, fainting from anxiety. And so I was like, I need to figure out a way to get out of the bathroom into my bedroom as quickly as possible without exacerbating this fainting feeling. And I managed to do that. And, like, my cramps eventually went away. And I was, like, sipping water. But, like, now the weird flavored burp is back. And I'm like, oh, God, no. Oh, please, I cannot survive another several months of just constant vomiting. Please do not do this to me. I'm gonna stop eating worms and moles. I don't do that. Ask my doctor about a full metabolic panel blood test. I don't know what that means. I did get a pretty comprehensive blood test recently. Now you know how it is for a man who pees way too hard. Your brother has bad breath like that, and he has issues with his lower intestines. You wonder if I have issues. It's like, the entire time I was vomiting for months, I didn't have any abdominal pain, I didn't have any cramps, so like, I ruled out, obviously, things like ulcers and whatnot, because there was no pain. But like, now that like, the flavored burp thing is back, maybe it's because I didn't eat much yesterday, and I didn't eat anything today, except for coffee and water. Like, that could be it. I'm trying to think, like, yesterday I streamed, so I didn't eat anything, and then after stream, I ate, like... a chicken sandwich with 2 slices of bacon and a slice of cheese. So like maybe I just didn't eat enough yesterday and now my insides are like, the fuck you doing, you dumb bitch? Like, I don't know. Is it just like bad breath? No, it's not bad breath. It's literally only like the flavor of a burp. You get some funny bacteria that lives in your guts. I mean, maybe my body's like rejecting the pH water now. Cause like I had to start drinking pH water, whatever the fuck this shit's called. I can't remember what it's called. I had to start drinking this shit because when I was vomiting, I couldn't keep down regular water. Like, even eating absolutely nothing for like 2 days and only drinking water, I would throw up that water. Like, my body would just reject regular water. Yeah, alkaline water. Thank you, chat. So I had to start drinking alkaline water, and I've just been drinking alkaline water ever since then, because, like, don't fix what ain't broke, right? Don't drink the fluoride water. Marine's Blood, thank you for the 2. Podcasts about an hour in Discord if interested. Thank you, my guy. Thank you for the link, you. Scary how similar our meals were. You just didn't have bacon on your side. I love bacon, man. Bacon is the only part of a pig I eat. Bacon's delicious. Cold Acid, they give the 200 biddies. The idea of both democratic elections and jury trials is that the electorate/jury pool can perceive breakfast. Unfortunately, the system breaks down when they can't. Politicians and courts are both counting on the non-perceivers. So naturally, everything's all fucked up these days. No, I agree with you. I agree with you. And it's just like, I think that there are some people that have way too much faith in other human beings. Like, I still get stunned at the stupidity of some people, but like, it's you know, when you see enough shit, you start realizing just how dumb the majority of people are. You had to crush up ice cubes or face throwing up more. Dude, it was fucking rough. It was like from end of October until like late February, I was just fucked. I had like a week period where I was gone in January. I think it was like 5 days, like 4 or 5 days, where I didn't throw up at all. And I wasn't home, so that's why I was like, maybe it's a mold thing. I don't fucking know. I don't fucking know, man. I just hope I'm not getting sick again. I hope I'm not getting sick again, man. I cannot have that happen. That was such a rough few months. I still can't get over how useless my doctor was through all that. Same. I am like just flabbergasted, but thankfully we figured out the issues with new doctors. DRT is king, thank you for the 5. The numbers don't lie, and they spelled disaster for the prosecutor at sacrifice. I don't know what that means. Brave SJ, thank you for the 25. You're disappointed I didn't point out Fillion would have absolutely wanted her death to be made about race, with riots in the streets and lynch mobs hunting down ladders, caught wandering around at night. But that was a beautiful eulogy all the same. Look, man, I don't know how much I can go on one of my friends' streams as a guest, especially when she has like managers and behind the scenes people like, you know, ushering me onto the stage. I feel like I shouldn't just go out there and be like, Fillion is dead. We must start a race war against these ladders. Burn ladders on front lawns. Throw ladders off rooftops. Total ladder death. I feel like maybe that would have been a bit too much, you know? She might have enjoyed it, but unless I have expressed consent, I don't wanna be that weird person, you know? Sure, her managers would find that pretty funny. SGT D4C, thank you for the 5. Oh my fucking god, I could never be a judge. You'd be too blunt and tell the defense, I see what you're trying to do, but that's stupid. Let's move on to another argument. Yeah, I'm impressed at that judge's patience. Fillion would love that, you know? Elijah Snow, thank you for the 199. Kirsche, you're still on hot mic. No, I knew my mic was on when I came back from peeing. I knew it was on. I knew I didn't mute myself. Brave SJ, thank you for the 5. You spent years grinding experience on VTuber Discords to level up your autism. This guy thinks he can get away with murder at just level 1. Well, Sean said that autism levels work backwards. So, like, you start at, like, level 100 and you're basically like a drooling sock. And then you gotta work your way up to level 1 where you're high functioning. 6 million ladders manufactured in 6 years with 6 machines. I just don't buy it. Standalone Complex, thank you for the 2. Decorsha's online. Hail Foxwoman, thank you. Let's see here. Nurglings, thank you for the 24-month resub, my guy. Thank you. John Burt, thank you for the 5. Fox Lady's here. Day is now better. Work was terrible bad today. New employee. She's already a walking food service violation. I'm sorry to hear about that. I get really nervous whenever I order food from places because I'm just like, I don't know how actual safe food handling these people practice. Cole Grave, thank you for the 24-month resub. He didn't buckle his seatbelt. Therefore, he'd go on a stabbing frenzy. Makes sense. Apparently, it's only a matter of time until I fucking kill someone based on that logic. No. Jefferson C. Post, I missed your Supa when Sean was still here, I'm sorry. Sean knows about being a public defender and suddenly being highlighted in the media. Dipped his toes in, so to speak. Yeah, he was at a court case today, so I'm glad he got home in time, because he wasn't sure if he was going to be able to make it. And I was like, I don't know how long I'm going to be on Philly's stream, I don't know what the fuck's going on. Not an FBI, thank you for the 301. Did Kohberger get his burger taken? His burger without cheese? And that's why he murdered people. He was given the burger without cheese. Abacus Flinch, thank you for the 5. Is it possible a lawyer can represent a client so zealously they become the tism themselves? I hope not. Capathic, thank you for the 2. What does the fox say? He's fat, fat, fat! Mr. Kohberger's not fat. He's a twiggy man. No cheese, no life? Yeah. You gotta get your own cheese, though. Don't be like that woman who's like, I can't date a man who won't spend an extra $2 for a slice of cheese on his cheeseburger. Like, that's just silly. Who's fucking paying $2 for a slice of cheese? That's fucked up. If I have to pay, like, $1 or more for a slice of cheese on my food, I will order the food without cheese. And then when it gets to my house, I'll put a slice of cheese on it. You know? Kier, go to bed. You're not my real dad. You can't tell me what to do. DRT is king. Thank you for the 10. You take Svetlana from Lithuania. You haven't been convicted of murdering someone. You even have enough to use code Kirsche to get Kirsche cups from Gamer Subs. Thank you. Thank you. Yeah, I want to know how these fucking murderers are getting Svetlanas. That seems a little out of the ordinary. Blue Mew 22, thank you for the 5. Happy days, beloved Fox. Plushie escaped the tariff locks. I know not what this court case entails, but cast the spell to put red squares in jails. I love your spells. It mostly worked today, too, even though I took ages to read it. We only got a little bit of a red square at the end here. What the fuck, Lala, thank you for the 5. Can you ask Lawyer Klaus, how does one become a lawyer without having to go to an indoctrination camp? You've been good, Mr. Klaus. Please don't hurt me. I feel like that's the only way you can do that, but I mean, maybe next time he's on, I can remember this question existed. Just wants a green card without commitment. Morpheus, thank you for the 29-month resub, my guy. Deus Volt guy, thank you for the 6-month Mamba. As a Quebecer, you're only retarded enough to watch this stream. My favorite Quebecer, which is a sentence that has never been uttered in the history of man, is the Cooking with Hoarders guy. I fucking love Masaukis. I love that weird little freak, and I hope that he is no longer living in a hoarder rat nest. Garjan Alpha, thank you for the 9 months of Proom. Congrats on being born in a courthouse today. Please enjoy a placenta coffee, because that's all lawyers drink. Rumham 556, thank you for the 5. Drinking game. Finish your drink when the judge completes a sentence without an... I don't think that's possible. I don't think that's possible. Eye of Magnus, thank you for the 1,000 bitties. Sparky's Tech Corner, thank you for the 7-month member. I see a sandwich eater and a sandwich maker on stream. This should be a good one. Yeah, I had a real fucking good time. I feel like I learned a lot. I felt like my brain was adequate. I wasn't too much of a drooling Californian retard. Eye of Magnus, thank you for the 2-month resub. Thank you. Thank you. Notere, thank you for the 2 fucking years of resubs. Thank you, my guy. The Raging D-Head, thank you for the 5. Pot and Kettle Moment. Adam Schiff says he wants to investigate for insider trading due to the tariffs pause. I don't know about all that. Nolan O'Malley, thank you for the full fucking year of resubby-bubbies. Thank you. Satomi Logan, thank you for the 2. It's not the size that matters, it's how you use it. Were we size queening in the trial? I don't even remember. Was that the binders comment? They had some big fucking binders, man. Binders full of women. Burning Phoenix, thank you for the 5 months of Proom. Awkward stream to resub on, but hey, do what you gotta do. Like, why was it awkward? Kurgan, thank you for the 2. What up? Who dis? That was Sean. That was Sean of Potentially Criminal. He's potentially Sean. He is a lawyer that I wanted to do a collab with for the Kohberger trial for ages now, and it's finally happening. We're in the home fucking stretch, baby. We're in the pre-trial phase, and then the trial's actually happening in August, and if they delay it, I'm just gonna have to break him out of prison, allegedly. You know, like, I'm just gonna have no other option. Vansar, thank you for the 11 months of Proom. Thank you for Prooming. C. Thomas the Peasant, thank you for the 8-month resub. You are almost done cooking, true. Lysenic, thank you for the 20-month resub. Thank you. And I think that is everyone that Stream Elements wants to acknowledge exists. Anthony, thank you for the 10. In Foxu Court, Kirsche and Chat are guilty of being cute and wonderful. You are very cute and wonderful, Chat. Ooh, my throat kind of hurts today, man. I've been drinking a lot, but fuck. Three-legged Tabel, thank you for the 5. Based suspenders, I remember reading that, thank you again. Stream Elements is just hating me. Kevin Hale, thank you for the 20. You just picked up 2 cups and all the other merch. Payment processor for Quine Bobs wouldn't let you get the DLCs. The Supa is to make up for it. My Quine Bobs link doesn't work anymore. It should be dysfunctional everywhere. I don't think it's in my YouTube descriptions anymore. I think I took it out of my Twitch panels, but the time for the Quine Bobs link is over, unfortunately. It is over. I know that there is another Crime Boss patch coming out real soon. I don't remember exactly when. I was going to do a preview if I remembered when the patch dropped, but I don't, so I don't know if I have enough time to do a preview or if it drops on like the 11th or some shit. I don't fucking remember. I don't remember. I can't remember things, chat. Victorian Orphan, thank you for the 10. Are your humors balanced with your star sign? I don't know. I'm a crab. I'm a crab, also known as a Cancer. I don't know. Stephen Tanchi, thank you for the 2. You enjoyed the lurk today. Thank you. Thank you. Thank you. I'm glad you guys enjoyed. Phillian Fan, 1996, thank you for the 100 biddies. A Dupa, 123. Thank you for the 7-month resubby biddy. Thank you. Thank you. The Forbidden Gabagool, thank you for the 500 biddies. Wyoming recently repealed gun-free zones. Oh, fuck. Color me surprised. I want to see how that works if they have no more gun-free zones in Wyoming. That'll be interesting. Dan Zanagri, thank you for the 22-month tier 3 resub. Thank you for the Gato posting. Almost 2 fucking years, dude. Almost 2 fucking years, Daniel. Let me see. I like how when I type in Twitch in my bar, it literally automatically drops me in fucking the Crime Boss area. I'm the Quine Bobs, as it were. Homestead is online today. And who do we have here? I am going to go touch. Oh yeah, I still have to figure out. I think we're still waiting on Kiba to mention when she's free for Schedule 1, because I do want to play that. I want to play it, baby. No. Well, 7th place POV. Oh, he's on a 5-minute delay. God damn. No. Is Pippa still streaming? Maybe I can just raid into Pippa again. Maybe I do a Pippa raid. I don't know if she's still streaming. Making the drugs are so much fun in that game. I've heard that it really tickles the autism from the couple of people I know who have played it. From the couple of people I know. Wyoming has wind and sheeps. Wind and sheepsies. Let me go to YouTube Studio, please. She's still streaming? Oh, hell yeah. Hell yeah. Alright, don't fuck me up here, Chrome. Don't fuck me up, Chrome. Silent Tucker Carlson. Duplicate stream key. Wait, what do they mean by this? Wait, did my stream go down? Am I fucking high? Uh-oh. How do I go back to my studio? 2 Foxus, no. That's weird. I guess my YouTube studio is just kind of fucked for me then. I don't know. Live? Can I go here? Wait, this isn't the right thing. This isn't the right thing. What the fuck? What the fuck? Create. Go live. I hate YouTube. Why is YouTube like this? Okay. Alright, I figured it out. I made it over here. Alright, we're gonna redirect to the Benoit. I did not have relations with my sibling yet. I just don't believe her. She's trying to fuck the brother, man. Remember, don't bring up politics in the Peeba chat. Peeba is not a political streamer. Only talk about how much you want to cuddle your little sister. Give Peeba some nice love during her cannibal incest game. I gotta still reach out to Kerr before I'm drowning in stuff to do, chat. I will see you guys Friday. And on Friday, hopefully I'll have mods around and we can set up like the little gifting channel in Discord. We'll figure it out together. We're beta testing, chat. Thank you for hanging out with me at a weird hour, extra long today, some fucking lawfare stuff. I'm really excited about the Kohberger trial. Come on this courtroom journey with me. Have a great rest of your night. Bye bye. Bye bye.